With my lords, kindly may I make a request pertaining to the regular bench, my lords, in view of extreme urgency. This is matter pertaining to recruitment of 1,500 posts of JTOs. Supreme Court has given a direction that 400 candidates who are appointed and working from 2 years, they should not be removed while the matters are pending before this court. 33 matters are pending. Now, my lords, day before yesterday, for all the 23 trades, revised final lists are released. In this list, these 400 candidates are not mentioned. To consider the interim order for Monday, it may kindly be taken.
Monday or Tuesday. Note Monday ಹಾಕಬಹುದಲ್ಲ? Wednesday. ಹಾಕಬಹುದು.
Much obliged.
Okay. ನಾರಾಯಣ ಸ್ವಾಮಿ. ಇದ ಬೆಂಚ್ ಮುಂದೆ. ಯಾವುದು?
Tank matters. Tank. Further reading on the first. 25% back, 50% back is so I am agreed to forgo 25%. Then thereafter matter was heard and so further giving it data.
All right. Notice post ಮಾಡಿ ಯಾವಾಗ ಒಂದು ದಿವಸ ನಾವು ಯಾವಾಗ ಕೂರ್ತೀವಿ ಅವಾಗ. Yes, sir.
Hearing for applicant in application number 237 of 2023.
Yes.
Lord, my grievance was, my lord, that the scheme was not implemented. Whatever undertaking which was given before the court.
Who are you?
Lord,
Who are you?
I argued, my lord.
No. Who is your client?
My lord, they are employees.
Employees.
Employees of respondent number.
As on which date?
As on the date of winding up.
As on the date of winding
up. Lord, kindly take notes.
ಅವ್ರದ್ದು
Company application number 237 of 2023. Lord, to put it this way, my lord.
Yes.
There are two groups of employees who are representing before this honorable court. One employees union, my lord, which has filed the OSCA. My lord, their grievance is different, and my lord, the retrenchment and all other allegations is between them and the respondent. So far as the another batch of employees, who are the employees on rolls as on the date of winding up itself.
Yeah.
My lord, their interest. Now, kindly take, my lord, Annexure C, page 82. The company was wound up, against which, my lord,
Of your petition application.
my lord, yes, please, my lord.
Page
82.
Sabad Saib order.
Please, my lord. In this case, can you take, my lord, company application number 732, page number 85 ಅಲ್ಲಿ.
Correct.
Various other employees also, ಇದು 85 ಒಳಗೆ ಒಂದು 19 employees ಇದ್ದಾರೆ.
ಇದರಲ್ಲಿ ಯಾರು ನಿಮ್ ಕ್ಲೈಂಟ್?
11 ಮತ್ತೆ 13.
11 and 13. Okay. Lakshmi Narayana and Srinivas Reddy.
Please, my lord. Company was wound up. Challenging that, my lord, an appeal was preferred before this honorable court. Annexure D, page 103.
and 13.
ಅಲ್ಲೂ 11 and 13, page 109 ಒಳಗಿದ್ದಾರೆ.
11 and 13. Anand Mohan.
Anand Mohan and P. Srinivas Reddy
ಶ್ರೀನಿವಾಸ್ ರೆಡ್ಡಿ. ಇನ್ನೊಬ್ರು ಯಾರೋ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರಲ್ಲ, ಒಬ್ಬ ಎಂಪ್ಲಾಯಿ, ಏನ್ ಹೆಸರು ಅವ್ರದ್ದು? You, Vasu.
And he is also, my lord,
He's number
There are three
one,
applicants.
number one.
He is number one.
he is number one.
Rajanna.
Okay.
And Rangappana, Raja.
You asked us to see which page?
My lord, page 109. Antandre, after considering our argument, winding up order was passed. Challenging that, my lord, an appeal was preferred.
Correct.
Saying that our contention was not heard, employees' contention was not heard ಅಂತ ತಿಳ್ಕೊಂಡಂತ. So that appeal, my lord, even in the appeal, my lord, page number 109, same T. Anand Mohan and
Serial number?
109. It is annexure D, page 103. It starts at 103, 109. Say
11 and
13.
13 only.
13, and my lord, applicant in another application, my lord, is at serial number 18. 18, Rajanna, he is applicant in.
You appear for. All right. Yes.
My lord, after considering our contention, page number 101.
It was recalled and
It was recalled. Further, my lord, once again, winding up order was passed, and at that point of time, the propounded a scheme. After that, my lord, I have no grievance regarding the scheme propounded or anything. My lord, after the scheme is propounded, my lord, at that point of time, around 43 acres of land was there with the company. My lord, everyone filed objections saying that it is not for, it was for real estate business, and it is, there is no iota of their genuineness in reviving the company. For that, all the objections which is filed by official liquidator and regional director of the ROC,
yes.
Compliance affidavit is filed by the propounder. On affidavit, stating before this honorable court, stating that he has all intentions to revive the company, and he is not going to do the real estate business. It is after that, my lord, this taking that into consideration,
Where is real estate?
that real estate business.
First, what is meant by real estate business? Suppose if I own property,
Please, my lord.
I sell them. Does it become real estate business? What is meant by the idea of real estate business? The buying, one sporadic, two sporadic instances. One swallow makes not the summer, said
Understood.
Shakespeare. So there are judgments under the Moneylenders Act holding one sporadic incident of lending would not amount to business at all. Where is the real estate business
My
here?
lord, real estate business in this sense.
Which ground you have taken up? Which is the ground you have taken up in your application?
In my application,
Which that ground is now, you are arguing.
my lord, in the application, I have stated that the order is passed in the year 2015, and
Asking you. Real estate business ಅವರು ಮಾಡಿದ್ದಾರೆ ಅನ್ನುವಂಥ contention ಎಲ್ಲಿ ತಗೊಂಡು?
ಅಲ್ಲ, they are trying
ಎಲ್ಲಿ
to sell.
elaborate ಆಗಿದೆ?
As on the date when I had filed this application, they had not sold the property. There was a registered agreement.
Now
to
we
sell.
will assume that they have sold the
They
property.
have sold the.
Where is the real estate business?
My lord, it is not the real estate business per se. What I mean to say, my lord, it is not that what they are going to do business. My lord, once the winding up order is passed, this honorable court becomes, my lord, custodial agent of all the properties of the company.
Correct.
Now, my lord, it is like the property of company that is in the custody of this honorable court. It is giving to someone in trust, saying that he is going to do for public betterment, or that he is going to revive this company. Now, it is that exercise, the entire exercise of filing this compromise petition, and that
No, now
being
you give
considered.
up contention of real estate business.
ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಬಿಸ್ನೆಸ್ ಅಂತಂದ್ರೆ ಮಾರಿದ್ದಾರೆ ಅಂತ.
ಮಾರಿದ್ದಾರೆ ಅಂದಾಕ್ಷಣ ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಬಿಸಿನೆಸ್ ಆಗತ್ತೆ ಅಂತ ಒಂದ್ ರೂಲಿಂಗ್ ತೋರಿಸಿ ನೋಡೋಣ.
No, my lord.
How to see, these are words, real estate business is a juridical concept. It is not just a combination of two words or coming from some dictionary. Is it not? Lot of like Subrato, Subrato, Sahara, Subrato, Armugam. These cases have decided what is meant by real estate business. Therefore, it is not, it has now from ordinary English law of realty, it has come to a particular meaning is attached because of so many things happening in the life of people. Is it not?
Please, my lord.
Where is that real estate business? If they sell that property, does it become real estate business?
My lord,
Does not.
if I may be permitted, as on that day, nan one day nan the statement. My lord, there was 44 acres land belonging to company at that point of time. There were around 20 to 24,000 shareholders. There were debenture holders and everyone who was there. Now, had that the winding up order, my lord, is passed in the year 2010, and they soon after that they filed this application. The exercise of getting the sale deed executed by KADB or anything did not arise for consideration before this honorable court at that point of time, because soon thereafter they filed the application seeking for revival of the company. Now, at that point of time, when the application is filed, the scheme propounded, there are certain things which was propounded in the scheme, because only then, my lord, this honorable court, because this honorable court is the custodian of that property.
You said about 3 times now that one. This
Alla.
is 4th time.
ನಾನು ಯಾಕೆ
It's a
ಹೇಳ್ತೀನಿ ಅಂತಂದ್ರೆ, ಆ
custodial
scheme-
legis. Property is custodial legis is admitted.
ಆಯ್ತು.
Go to the next point.
ಇದಾದ್ಮೇಲೆ ನಾವು kindly take the scheme for a moment. The scheme which is propounded by
Page number?
page number annexure E1 page 130, ಆ ಸ್ಕೀಮಿನ ಪೋರ್ಷನ್ ಸ್ಟಾರ್ಟ್ ಆಗೋದು 139. ಪೇಜ್ ನಂಬರ್ 137 ಒಳಗೆ ಏನೇನ್ ಇದಾರೆ ಅಂತ 136 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗತ್ತೆ.
136. ಅದ್ರಲ್ಲಿ ಬಹಳ ರಿಲೆವೆಂಟ್ 139,
139.
para 2.
137 ಒಳಗೆ
ಹಾ.
kindly take who are the secured creditors, who are the unsecured creditors,
Correct.
debenture holders,
ಹಾ.
share capital,
ಹಾ.
shares holding structure.
ಹಾ.
Total 1,81 lakh shares are held. It was a listed company before that, earlier.
ಹಾ.
So around 22,000 shareholders were there.
ಹಾ.
Now, my lord, scheme is proposed. In this scheme, it is a promise by the propounder that secured creditor as per what yes he is going to pay 139 ಒಳಗೆ, debenture holders face value 100 rupees each ಕೊಡುತ್ತೀನಿ ಅಂತ ಹೇಳ್ಕೊಂಡು ಅಂತ.
Correct.
Government of Karnataka 50 lakh he will give.
ಹಾ.
Employees serial number 8 as per OTS ಅಂತ ಹೇಳ್ತಾರೆ. Finally, serial number 2.
ಹಾ.
The propounder undertake to settle all the dues of the employees of the company as per one-time settlement. The company shall also offer employment opportunity to its employees upon commencing the commercial production after the revival of the company.
Correct.
ಇದೊಂದು ಹೇಳ್ತಾರೆ. Next, kindly take, my lord, with
ಹಿಂಗಂದ್ರೆ
respect,
what is meant by this clause?
this
Explain this.
clause with respect to commercial production. If his
What are the
application,
building blocks of this clause?
building blocks for this clause, my lord, in their application,
He should settle dues of employees of the company as per the one-time settlement. ಇದು ಒಂದು ಭಾಗ.
ಒಂದು
ಅದಾಗಿದೆಯಾ?
ಆಗಿಲ್ಲ,
ಅದು ಆಗಿಲ್ಲ.
ಅದು ಆಗಿಲ್ಲ,
Where have you
ಅದು
stated?
ಆಗಿಲ್ಲ ಅಂತಲ್ಲ. No, I have, ಇದು ಯಾವುದು ಆಗ್ಲಿಲ್ಲ. ಮೇಲ್ಗಡೆಯಿಂದ ಇದ್ದಿದ್ದು ಇಡೀ ಸ್ಕೀಮ್ ಒಳಗೆ,
ಅದು ಬಿಡಿ, ಅವ್ರು ನಿಮ್ಗೆ ಸಂಬಂಧ ಪಡ್ಲಿದ್ದು. ಕ್ರೆಡಿಟರ್ಸ್, ಸೆಕ್ರೆಟರಿ, ನೀವು how you are concerned with.
my lord,
Please talk about your cake.
my
In bakery, so many items are available. Don't worry about that. What is the cake earmarked for you? You can have grievance against that. You are not holding brief for the debenture holders, shareholders, investors, etc. You are holding brief for the employees. We can understand.
my lord,
Where is that?
the difference between the appeal filed and the application filed under 392, the difference is this. I might be a person who simply brings to this honorable court, court's notice, what has happened. Ultimately, my lord, what has happened in this case is, he has promised, I will pay everyone all along, kindly give this property.
Whether anybody is complaining that they have not been paid?
No, my lord, it is not about who has complained it. Our application, my lord, if there even balance sheet of the year 2022, if it is seen, they say, they don't say anything about payment to any other persons. Still now the due is there. But so far as the
How do you
property is
assume that?
concerned,
Persons, if anybody comes forward saying, ಹಿಂಗೆಲ್ಲ ಅಂಡರ್ಟೇಕಿಂಗ್ ತಗೊಂಡು ₹1 ತಗೊಂಡು ಕೊಡದಂಗೆ ಪ್ರಾಪರ್ಟಿ ಮಾರ್ಕೊಂಡ ನೀವು ಅನ್ಕೊಂಡು ಯಾರಾದ್ರೂ ಇದಾರ ಕೋರ್ಟ್ ಮುಂದೆ ನಿಮ್ದು ಹೇಳಿ. We understand the scope may be wider, but what is your locus? Your locus is
my locus is for commercial production, that is employment. But the application what I had filed, so far as the another application is, my lord, seeking for the implementation of the scheme. I had filed an application to restart the factory unit which they had undertaken before this honorable court.
Yes.
And that was done by way of this scheme. This scheme was propounded. Serial number 2, the propounder undertake to settle all the dues of the employees of the company as per one-time settlement. The company shall also offer employment opportunity to its employees upon commencing the commercial production after the revival of the company. Serial number 9.
Serial number?
ಅದು ಅಂತಂದ್ರೆ ನಾನು ಶೇರ್ ಹೋಲ್ಡರ್ಸಿಗೆ ₹1 ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳ್ಕೊಂಡು ಅಂತ. It comes to 1.81 crore rupees. ಅದು
No, we are asking you now. Again, how you are concerned with that? Are you assured?
I am not. Lord, it is at the time of filing this application, I did not bring to this honorable court's notice because I was concerned.
What are the grounds you have taken up in your
I was
application?
concerned with my application.
See,
It is
show your grounds. What are the grounds?
grounds ತರ ಆಗ್ತಿಲ್ಲ, but para number 26, para 24, my lord.
Para 24.
The applicant submits the propounder after taking over the respondent company has not made any efforts to revive the company. When the applicants approached the officers of the respondent company, they were told that KDB has not executed registered sale, and if the same is done, then the respondent will restart the factory and take the applicants and other unemployment with continuity of service for retirement benefits.
Where have they said this? When the applicants approached the officers of the respondent company, which applicant approached? When?
Ibru, nan.
When they approached? And where is the evidentiary material for?
Evidentiary material, my lord, it is oral. Nan document hakilla.
Do you have documents now?
No, my lord.
Sure. No document.
No document. No document.
ಇವ್ರು ಹೋದ್ರು ಅಲ್ಲೇ ಕೇರ್ ಮಾರ್ಕೆಟಿಗೆ ಹೋಗು ಅಲ್ಲೇ ತಗೊಂಡು ತಗೊಂಡು ಬರುವಾಗ ಅಲ್ಲಿ ಕಂಪನಿ ಆಫೀಸಿಗೆ ಹೋದ್ರು ಅವ್ರ ಎಂಪ್ಲಾಯೀಸ್ ಮಾಡಿದ್ರು ಅಂತ ಹೇಳ್ದಂಗೆ some watching little evidentiary material.
True, my lord. It is not that this is my
ಈ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲ ಹಾಕ್ಲಿಕ್ಕೆ ಬರ್ತದೆ ಅವ್ರಿಗೆ, ಇದಾಗ್ತದೆ. ಒಂದು ರೈಟಿಂಗ್ ನಲ್ಲಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟು ಲೆಟರ್ ಕೊಟ್ಟು, ನೋಡಪ್ಪ ನಮ್ಗೆ ಹಿಂಗೆ ಹೇಳಿದ್ರಿ, ನೀವು ಕೊಟ್ಟಿಲ್ಲ, ಆ ಪ್ರಕಾರ ನೀವು ನಡ್ಕೋಬೇಕು, ಇಲ್ಲಪ್ಪ ನಾವು ಕೋರ್ಟಿಗೆ ಹೋಗಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತೇವಿ. ಎಲ್ಲಿದೆ?
Every time, my lord, when they were approached, sale did execute agilla ಅಂತ ಹೇಳಿ, this is my pleading.
Which officer, which company official said, who is he? In one judgment it is said, officials of the company, sweepers also will include officials of the company in one judgment. Very old judgment under 1913 Companies Act, it mostly an older judgment. Which official? When? Where? What was the interaction? It is not that for the first time you are coming here. Throughout you have been in the court.
Illa, andre,
Okay.
ನಾನು first
You were parties.
no, after that, my lord, I was not party to anything.
How many times you should be party? In how many cases your names, serial number 11, serial number 1, serial number 11, 12, serial number 13. Figure in how many pages?
When-
Judgments.
When the winding up was happening, 2 times, my lord, when
No,
we
you
approached-
went only after all this. Therefore, it is not that court is something very, it is not Aladdin's mention. It is an institution with which you were fairly associated with,
please, my lord,
being a party. Yes, then.
please, my lord.
Hmm.
I filed this, he filed this scheme. this honorable court allowed the application. That was by majority, my lord. It was passed. In meeting. Kindly take, my lord. Thereafter, I have showed your lordships annexure J-172. Those are the objections of official liquidator. Then after scheme is approved by the majority, my lord, it is not that imperative for the honorable court to accept that scheme. It will call for objections from various persons only if it is in the interest of everyone. That
Kindly come to 136 of your paper book.
please, my lord.
Read para 16.
The
Yes.
scheme will also have social objective in as much as if the scheme is approved, the company stands revived, employment opportunity can be provided.
Can be provided. Employment opportunity, the state exchequer will stand official in terms employment. When you are reading, at least Justice Chipal Krishna of this court said, when you are reading the proposed scheme, every paragraph of the scheme should be read with rest of the paragraphs. You can't read them in isolation. They are not standalone provisions. Hold
Please, my lord, this is something like a preamble to everything. What happened in the company and then total explain madro.
Yeah.
Ultimately, scheme what they are going to propose and then they mentioned it 139, page 139.
Correct.
After the scheme,
para 2 you have read.
please,
Yes.
please.
Next.
Page 172. I have already brought to the notice of this honorable court. That is the reply by the official liquidator.
Yes.
Because
What?
everyone, 172.
172.
My lord, 179, the official liquid 172 is the principles ultimately he pointed out.
That JSK Rai Chaudhary case.
Please, my lord. JSK Rai, please, my lord. JSK Rai Chaudhary case.
Yes.
H, my lord, resumption of business of the companies, I must tell you.
Correct.
Fine, my lord, these are all the principles which are there. The observations, my lord, is at serial number 18, para number 18. That the official liquidator further submitted scrutinized on the above basis of the above mentioned principle. Few glaring discrepancies are noticed. Early 180, page number 180.
180?
180, ಕೆಳಗಡೆ
180.
serial number 18.
That the official code further submits that scrutinization on the basis of above mentioned principles. Few
ಅದರೊಳಗೆ
glaring discrepancies
please,
are noticed.
181.
Details are showing. So
181.
Ah.
That the applicant claims that he is in the similar business of the company in liquidation, that the applicant may be pleased to direct to provide the name of such companies along with the constitution of the board. See, the applicant claims to pursue the main objects of the company. However, the applicant does not contain the details of the project, the fund requirement, the way and means of financing the project, etc. Otherwise, serial number 19. Next para.
19.
That the
That the
official
official
further
liquidator
objects
further-
that the company in liquidation is in a strategic place,
Yes.
applicant also admits, and is having more than 42 acres of land. The market value of the same is certainly not less than 50 to 60 crores at that point of time,
Yes.
when the affidavit is filed.
Yes.
And further, my lord, 183, page 183, my lord,
83.
same.
24.
24. The official record further submission perusal of the aforementioned statement elucidates the applicant is pending investing approximately an amount not exceeding 16 crores for settling the dues of workers not quantified, assumed to 2.36 crores. The market value of the land and the building of the company in
Value
liquidation
50 to 60 crores ಅಂತ ಹೇಳಿದ್ರು.
is to 60 crores.
Ah.
ಇದಿಷ್ಟು ಇದೆ under these circumstances ಕೆಳಗಡೆ.
File affidavit.
Applicant to be directed to file an affidavit that land will be used for setting up factory and industry and not for any other commercial exploitation.
Yes.
Applicant to show his bona fide be directed to deposit this honorable required sum, file the quarterly returns
Ah.
before this honorable court ಅಂತ.
ಇದ್ರ ಮೇಲೆ ಏನಾಯ್ತು?
He
It
filed
was
a
on
reply.
21/5/2014.
He filed a reply.
Ah.
The propounder filed a reply before this honorable court,
Ah.
page 186.
186 189
188 ಒಳಗೆ
188 ನಲ್ಲಿ. Last time because you read 189,
Please,
para 6.
para 6, my lord.
Huh.
With respect to what I mean to say, my lord, I have read the serial number, page number, that is 1819, my lord. With respect to the observation made in paragraph 18 and 19,
Yeah.
counter affidavit ಒಳಗೆ file ಮಾಡೋತ್ತಿಗೆ 188 ಅಲ್ಲಿ para number 5 ಕೆಳಗಡೆ.
Correct. Pendants.
It is submitted
above
that
the
during the
commencement in favor of petition and thereafter upon since the initial scheme prepared by the petitioner in failed, petitioner filed company application seeking and company upon consideration of company.
ಅದಕ್ಕೆ 189 ಅದೇ para 6.
Para 6.
19 is with respect to 50 to 60 crores valuation of the property and also regarding
Denied.
the restarting. It is submitted that petitioner with intent to reviving the above scheme has put in great efforts for settle the dues of creditors. The petitioner who is into similar business intends to revive the company in order to expand its manufacturing capacity.
Correct.
The
Is not
petitioner is
the
not
next
in-
sentence.
the
Petitioner is not into real estate business. Yes.
No, real estate business, it is not that, my lord, he is going to subdivide the plots and he is going to sell. Everyone meant that, look, 50 to 60 crore rupees worth property is there. Someone is coming before this honorable court and saying that, please give me that property, I'm going to utilize it for the benefit of the company. Now, when everyone believes, at that point of time, when objection is filed, he has no intention. He files an affidavit before this honorable court. I have all intention to revive, I'm into similar business. My lord, similar means there is something which is there. I'm into similar business, I want to revive and manufacturing activity, to expand its manufacturing activity. The word specifically used is to expand its manufacturing activity.
Yes.
The petitioner, it is submitted petitioner prays for that the revival may be permitted under the supervision of this honorable court, whereby petitioner would periodically furnish the details regarding the revival of the company for the kind perusal of this honorable court. He
Ah.
files another undertaking also
Ah.
before this honorable court.
Affidavit. One 193.5 ಬನ್ನಿ.
Please, my lord. Revival of the company in liquidation may be for running the business of the company for which it was incorporated, not for doing real estate business. Since the scheme is for revival of the company and earlier employees of the company may be reinstated in the company. And this is the affidavit filed by the regional director. He also filed an objection. That is the observation before this honorable court.
Yes.
With respect to this also, my lord, at serial number 7 also.
Correct. 194.
Using the land only for revival of the company, not for doing any real estate business. Real estate business, everyone meant that don't say, you are not to make money out of.
Everyone says something, but we
ಅಂದ್ರೆ-
have to understand. We court of
Understand.
law. Legal language ಮಾತ್ರ ಅರ್ಥ ಆಗ್ತದೆ ನಮಗೆ.
My lord, for this also he filed an objection, annexure M, page 195. Andre affidavit, counter affidavit or reply affidavit. In this reply affidavit, kindly take, my lord, para number 5, my lord. ಅಲ್ಲಿ first ಗೆ the petitioner.
ಮಿಡಲ್ ಓದಿದ್ರಿ ಲಾಸ್ಟ್ ಟೈಮ್.
Middle ಓದಿದ್ದೆ.
ಹಾ.
The observation for which he writes this reply ಅಂತ ಹೇಳೋದಕ್ಕಾಗಿ. The petitioner submits that so far as the government set out in paragraph 3(5), that the revival of the company in liquidation may be for running the business of the company for which it was not for doing any real estate business. Since the scheme is for revival of the company ಅಂತ ಹೇಳಿ ಅದನ್ನೇ ಸೇಮ್ ಅದೇ ಕಾಂಟೆಕ್ಸ್ಟ್ ಅಲ್ಲಿ ಇಟ್ಕೊಂಡು ಅದಕ್ಕೆ ರಿಪ್ಲೈ. It is submitted that petitioner with intent to reviving the above scheme has put in great effort. The petitioner is also in similar, same, whatever he had replied earlier,
Yes,
intends to revive the company in order to expand its manufacturing capacity.
correct. You had also read the last
Last
four,
line.
four lines in
Please,
para
my
6
lord.
last.
Ready and willing to abide by any such conditions which is there.
ಹೊಸ argument ಏನಿದೆ?
Hasa,
Because we have already made
No,
notes in our papers.
Hasa argument,
Ah.
my, the main argument was, after this, kindly take, my lord, order that is passed. Otherwise, I have read it, my lord, page
That also 206 ಓದಿದ್ರಿ?
210
206 also you had read. We have mentioned your name. We have made notes beside.
and 209, my lord. Very important is 209. Para number 5, most important, my lord. It is not that observation or anything which was not argued. They filed, it is like an observation which is filed before this honorable court. He files a reply affidavit saying complied. Whatever observation you have made, I am complying with that. The registrar of companies has filed a petition on behalf of regional director with
Yes, I do
certain
not.
observation. The petitioner has filed his reply complying with the
Objections that
objections
were
that
raised.
were raised. No further objections are filed.
Right.
When I am saying that you have to revive the company, and he files an affidavit saying that I am going to revive the company, no objections are filed because he is complying to my that is the regional director's observation. With this, my lord,
Where he has said, I will revive the company. He said, I intend to revive the company. Everywhere the word intent is used. Everywhere. Everywhere. Nowhere unconditional this. Because
With
reviving
intent-
a company is, it's not just keeping the ship afloat by the tactics of the pilot. Reviving a company will have a host of factors. He said, we intend to revive the company. That is 7 times it is said in the pleadings. We have just noted that. ಎಲ್ಲೂ unconditional on sentence ಓದಿ ನೋಡೋಣ. We
unconditional,
are going to revive the company.
because company is not given to him. It is only when this honorable court passes an order, what is there in its custody, it is going to give it to him.
ಅಲ್ಲೂ ಸಹಿತ ನೀವು ನೋಡಪ್ಪ, you have not given an unconditional undertaking. You only say intent. We do not know what all intent you will have. Many intents will go. Just they are generated in the mind and just they grow and then wither away. That court should have asked you. Where you should have said, Swami, intent to revive has a wide import or meaning illa. We will revive an undertaking. ತಗೊಳ್ಳಿ ಅವರಿಂದ ತಗೊಂಡು ಮಾಡಿ ಅನ್ಕೊಂಡು ನೀವು ಪಾರ್ಟೀಸ್ ಎಲ್ಲ ಇದ್ರು.
No, we were not parties. We were not parties to this. No meeting was called for the employees because the scheme of the act does not permit, my lord, so far as.
Your application was not favored. The
Early.
application, the labor, the concerned authority did not favor the
Adu-
application where the employees wanted to enter the fray. Last time, about 6 months ago, you had read that sentence, I remember.
Nanalla, it is not me, my lord. That is.
No, employees is ಎಲ್ಲರದು.
ಅಲ್ಲಿ ಎಲ್ಲರದು ಅಲ್ಲ.
Because he said, you said, you brought to our notice 2 paragraphs.
Yes.
I distinctly remember, we remember that you said they were not part of the negotiation process at all.
That's correct. No, in fact, the first order of winding up was set aside at the behest of an employees union, where His Lordship Justice Gopal Gowda remanded the matter and directed the company just to once again examine the issue. Then, my lords, His Lordship Justice Bopanna notes that having heard learned counsel of rival parties, learned counsel representing the employees union and the staff members had an opportunity to put forward their contentions. They have not put forward any scheme. So, my lords, how many times can you go on giving opportunities?
Which page it is?
Page 156.
It is not there in this, my lord.
157, my lords.
It is not there in my application. That order copy is not
Sorry,
there.
OSA 8 of 16. my lords.
ಇನ್ನೊಂದರಲ್ಲಿ.
In
ಇನ್ನೊಂದರಲ್ಲಿ.
Page number?
page 156, 157 in
156.
OSA 8 of 16.
All right. Noted.
Only distinction I want to make, my lord, that is correct. I couldn't revive the company. I couldn't put forth any scheme before this honorable court. That does not absolve from a propounder giving all kinds of assurance before this honorable court and taking away the company's property, selling it off without even observing any of the conditions which was there, which assurance he had given before this honorable court. It is my only, and the another argument, my lord, what I am making now, it is because last date of hearing, my lord, senior counsel argued, so far as when it came to this commercial production aspect, only with respect to that issue, he said that with respect to scheme, all other points, that is a scheme is complied, only that is not complied. That was the submission which was made. Even, my lord, my instructions are that so far as that is also concerned, my lord, except for the secured creditors through whom they had taken under the assignment deed, neither the shareholders are paid, nor the debenture holders are paid, nor any other, either government of Karnataka 50 lakh rupees is there, even that is not paid. Now, my lord, whether
ಅವ್ರು
they
ಕಂಪ್ಲೇಂಟ್
ಅಲ್ಲ,
ಮಾಡಿ
ಅವ್ರು ಕಂಪ್ಲೈಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳೋದಕ್ಕೆ one thing is there, my lord. The company has one registered address from earlier. Registered address is not changed. That registered, no one, there is no person, that the company is not in existence in that registered address. The another office building which was there earlier, that is at this premises, where factory premises there, that is demolished. All the machineries have been sold off, I am told, my lord, for around 8 crore rupees.
ದೇ ಡೋಂಟ್ ಹ್ಯಾವ್ ಆಫೀಸ್ ಎಟ್ ಆಲ್ ನೌ.
They don't have office at all.
Where did your clients meet the officials of the
It is propounders.
where did they meet them?
That I have to seek instruction.
Say, you
They don't have office. They don't have office as prescribed here.
where have you stated that?
No, my lord, I have not stated that. ಅಲ್ಲ,
ಔಟ್ಸೈಡ್ ದಿ ಪ್ಲೀಡಿಂಗ್ಸ್
ನಾ-
ಆರ್ಗ್ಯೂ
ನಾನ್
ಮಾಡಿದ್ರೆ
outside the pleading ಅಂತ ಹೇಳಿದ್ರೆ
ದಿವಸ ಇಷ್ಟು ಕೇಸ್ ಡಿಸೈಡ್ ಮಾಡ್ತೀವಿ.
No, my lord.
ಇಷ್ಟು ಜನ ಲಾಯರ್ಸ್ ಹೆಂಗ್ ನೆನ್ಪಿಟ್ಕೊಳ್ಳೋದು ಹೆಂಗ್?
ನಾನು
ನಿಮ್ಗೆ
ಇದು
ಎಲ್ಲ
argument
ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಒಂದು ಬೇಕು. Kindly come to your page 13 para 24. Read it. ನಾವೆಲ್ಲ ಮರ್ತು ಬಿಡ್ತೇವೆ ಅಂತ ಇಟ್ಕೋಬೇಡಿ, ಎಲ್ಲದನ್ನೂ ನೆನ್ಪಿಡ್ತೇವೆ ಅಂತ ಇಟ್ಕೋಬೇಡಿ. ಬೈ ಅಂಡ್ ಲಾರ್ಜ್ ನಾವು ವಿ ರಿಮೆಂಬರ್.
ನಾನು ಈ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಿದ್ದು ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ I was only concerned
come
with
to
respect
page
to my production. My
Kindly
lord,
come to your
the
case
applicant submits that propounder after taking over the respondent company has not made any efforts to revive the company. When the applicants approach the officers of the respondent company,
approached the officers of the respondent company. Where did you approach them? Where have you taken up the contention? Company's office, registered office is non-existent.
ಅದನ್ನ
Then where did you meet
ಅದ್
them?
ಯಾಕೆ I am only concerned, my lord, when I had filed this application seeking for restarting of the industry and I being taking as an employee in the company. It is only during the course of the argument when the learned senior counsel said that except for that, all other things are complied. When we
Let
inquired
us see
regarding that,
what he will say.
please, my
All
lord.
right. Any other point?
No, my lord, with respect to
Are you happy that all your points are heard by us?
Please.
Ah,
ಆ ಸ್ಕೀಮ್ ಒಳಗೆ ಯಾವ್ದನ್ನು ಕಂಪ್ಲೈ ಮಾಡ್ಲಿಲ್ಲ ಅನ್ನೋದು.
ಯಾವ್ದನ್ನು ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ. ಅವ್ರು ಯಾರ್ಯಾರಿಗೆ ಶೇರ್ ಹೋಲ್ಡರ್ಸ್ ಏನ್ ಕೊಡ್ಬೇಕು, ಗೌರ್ಮೆಂಟ್
ಕೊಡ್ಲಿಲ್ಲ.
ಕೊಡ್ಬೇಕು,
That is also with them.
ಕೊಡ್ಬೇಕು, ಅವ್ರು ಕೊಡ್ಬೇಕು ಅನ್ನೋದು ನಿಮ್ ಉದ್ದೇಶ.
ಅವರಿಗೂ ಕೊಡ್ಲಿಲ್ಲ.
ಅವ್ರಿಗೂ
neither-
ಕೊಟ್ಟಿಲ್ಲ, ಅವ್ರೆಲ್ಲರೂ ಹೆಪಿ ಇದಾರೆ.
ಅಲ್ಲ.
ಅವ್ರು ಹೆಪಿ ಇರಬಾರ್ದು. ನಾನು ಬಂದಿನಿ ಇಲ್ಲಿಗೆ ಅಂತ
No effort is made to pay to them also.
Ah.
Or there is
ನಿಮ್ದು ಕೇಸ್ ಹೇಳ್ರಿ.
ಅಲ್ಲಿ ನಂದು
ಕಾಂಕ್ರೀಟ್
ನಂದು
ಕೇಸ್ ಏನಪ್ಪ?
revival
ಕೊಟ್ರಾಯ್ತು.
ಆಯ್ತು. ಅವ್ರೇನ
Other than the fact that what your lordships already pointed out, that he can't be holding a brief for them.
ಇಲ್ಲ, ನಾವು
No, my-
ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಷ್ಟೇ ಇದು. You have to answer.
Yes, my
What
lord.
was the object of reviving the company?
My lords, to ensure that the company is kept afloat. Initially, there was an order to wind up, and as I was submitting on the last date, my lords, when I'm not able to pay my debts, the learned company judge found that there was no question of reviving the company, therefore directed winding up. Then when a scheme was put forward, of course, in the meantime, there was one remand. Finally, when a scheme was put forward, my lords, the debenture holders, shareholders, creditors, secured creditors and unsecured, all sat. There was a meeting of minds and the scheme was approved by them.
Did you pay the money? to
Yes,
all
but
of them?
no, there are significant amounts owed to banks. My lords, I asked myself, would the banks keep quiet for 8-9 years?
No,
if I
we
don't pay
will
them?
not,
ಇಲ್ಲ, I'm on
you need
instruction.
not ask that question.
Yes.
We are asking that question.
Yes, my lords.
ಅವ್ರು ಯಾಕೆ ಸುಮ್ ಕುತ್ಕೋತಾರೆ ಗೊತ್ತಾಗಲ್ಲ. ಯಾರ್ಯಾರು ಏನೇನೋ ಸುಮ್ ಕುತ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ. ಆಯ್ತಾ? We are asking you. ಇವ್ರು
Other than
ಯಾರ್ಯಾರಿಗೆ
that-
ಏನೇನ್ ಕೊಡೋದಿತ್ತು?
Correct. No,
They would not have done this, that so much if is
ifs and
very-
buts better. I will, my lords, we'll
There
place
is
it
one
on record.
famous, there is one famous poem by Rudyard Kipling
If.
on if ಅಂತನ ಅದ್ರ ಹೆಸರು. It's a very cruel
Beautiful,
word ಅಂತ ಹೇಳ್ತಾರೆ.
beautiful.
Rudyard Kipling, which he wrote when he was in Bangalore.
Bangalore. no, I
He
didn't
was
know
in
that. I didn't
Bangalore.
know.
Yes, if you can Google out.
Yes.
And that poem impressed Palkiwala so much. Very often, every birthday, he used to recite that poem. In fact, I think that is there even in courtroom genius refer ಮಾಡ್ದಂಗೆ ಇದೆ ಅದು.
Had a very deep meaning, that poem has.
Very deep
In fact,
meaning.
the,
of that.
I don't know whether your lordship.
Count
your lordship
all,
does
but
not count
none
this-
too much.
Yes.
Count all in your life, whatever you do. While doing that, count all, but none too much.
In fact, your lordships may not, would
Therefore,
not
you
come on
should
this.
not, you should count all judges, but not too much.
Not too much.
It applies to you people also. Anyway,
That's all.
well, you file an affidavit or the memo, at least memo signed by your
We
person,
will do that.
saying
we will
that
do that.
we have
We
made
will
all
do
these.
that along with our written submission, addressing all the.
Where have you,
aspects.
you
No,
want to
no,
state?
along with our this thing, we'll file it. We'll ensure that is.
ನಿಮ್ದು written submissions ಎಲ್ಲ ಆಯ್ತು. ಹಾ. All right.
Hmm.
All right. Your party wants to say anything? Mr. Vasu. You want to say anything? Do you adopt these arguments or you have any special arguments than this?
They have not completed anything with the terms of the.
ಅದು ಅದ್ರಾಗೆ ಬಂತಲ್ಲ.
They made everything evidence. Whatever they submitted, everything is false.
They have not, everything is false. Got it? Good. All right.
Well, could we place it on record by Monday or latest Tuesday, Manoj? We'll hand it over to the court officer.
ನಮ್ಗೆ ಯಾಕಂದ್ರೆ ಈ ರಜದಲ್ಲಿ ಮತ್ತೆ ಬೇರೆ ಕೆಲ್ಸ ಇಲ್ಲ.
No, no, correct.
ಸ್ವಲ್ಪ ಬರೆಯೋ ಕೆಲಸ
No,
ಮಾಡ್ಬೇಕು.
definitely, latest by Monday, Manoj. Monday will.
ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಹಾಕ್ತೀರಾ?
Please, only thing, my lord,
Copy ಕೊಡ್ತೀವಿ.
copy, give copy. I had,
Action ಮಾಡ್ಕೊಳ್ಳಿ.
I had kept
Action
it ready.
ಹ್ಮ್.
In their
ಇನ್ನೂ ಒಂದ್ ಸ್ಟೆಪ್ ಫಾರ್ವರ್ಡ್ ಮಾಡು.
financial statement, ಅವ್ರು ಹಾಕಿದ್ರೊಳಗೆ ಇನ್ನು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅವರೇ, they are saying that in memo there.
ನಾವ್ ಹೇಳ್ತೀವಿ ಅವರು ಇದೆಲ್ಲ ಈಗ
I think he wants an opportunity to rebut that also.
No, my lord, I don't want to rebut anything. Let it be on
ನಿಮ್-
affidavit.
ನಿಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಮಾಡ್ಕೊಂಡ್ ಕೊಡಿ. ಮತ್ ಬಿಫೋರ್ ದಟ್ ನೀವೇ ಕುತ್ಕೊಂಡು ಏನೇನು ಆಗಿದೆ ಅಂತ ತಿಳ್ಕೊಂಡು ನೀವೇ ಬರ್ದ್ ಕೊಟ್ರೆ ಆಗ್ತದೆ ಅಂತ. ಮತ್ತೆ ಅಲ್ಲಿ ಏನೋ ಒಂದು ಚಿಕ್ಕದ ಏನಾದ್ರು ಮತ್ತು ಯು ಸೇಡ್ ಅದರ್ ಡೇ
Yes, yes, of course.
Ah,
We'll hand it
ಅದನ್ನ
over.
we are
No,
reminding
that
you.
we're definitely keeping in.
All they are out of employment
Certain,
now.
certain.
ಹೌದಾ? You said that we will consider whether some piece can be bought ಅನ್ಕೊಂಡು ಆ ರೀತಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದೀರಾ ಒಂದ್ ದಿವಸ.
That is still, we're not resiling from that. Manoj.
Ah.
We're certainly not resiling from that.
ಅದೇ
I remember some slips were handed over so that your lordship
That's
saw
all, that's
on both sides whether there was any possibility of the twain meeting, but.
ಅದಕ್ಕೇನು ನಿಮ್ಮ ಅದ್ರ ಮೇಲೆ ಅದ್ರ ಆ ಸ್ಟ್ಯಾಂಡ್ ಮೇಲೆ ಏನಿದೆ?
No, no, but at the same.
ಅವರೆಲ್ಲ ಎಂಪ್ಲಾಯೀಸ್.
No, no.
ಹೌದಾ? Come now you have sold that property.
No, along with
After
that.
after that property was, the conveyance was executed by KDB pursuant to
Yes, correct.
judgment of one of us. Now you got the property and you have sold it also.
So other industrial concerns, Manoj, and in fact, we'll place it on that also on record, but the instruction I'm submitting that the KIADB will not permit me to use it for me or anybody else for other than industrial purposes. These employees we will ensure that
ಎಷ್ಟು ಜನ ಎಂಪ್ಲಾಯೀಸ್ ಲಿಸ್ಟ್ ಏನೋ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್?
correct, Manoj,
ಎಲ್ಲಿದೆ ಲಿಸ್ಟ್?
that was a.
ನೀವು ತುಂಬಾ ದಿವಸ ಮಾಡಿದ್ರೆ ನಾವೆಲ್ಲ ಮರ್ತು
That's
ಬಿಡ್ತೀವಿ.
true, that's true.
ಅದು
The problem is the
justice
intervening
ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ.
vacation and the.
ಅಲ್ರಿ ಆ ಲಿಸ್ಟ್ ನಲ್ಲಿ ಏನೋ ಒಂದ್ಗೊಬ್ಬ ನೀವು 51 ಜನ ಏನೋ ಇದಾರೆ ಅಂತ ಹೇಳ್ದಂಗಿತ್ತು. ಏನ್ರಿ ನೀವೇನೋ ಹೇಳಿದ್ರಿ ಲಾಸ್ಟ್ ಟೈಮ್? ಆ ಡೇಟಿಗೆ ಯಾವ ಡೇಟಿಗೆ? ನಿಮ್ದಲ್ಲಿ ಎಷ್ಟು ಜನ ಇದಾರೆ ಅಂತ ಹೇಳಿದ್ರಿ?
Also, again, because of efflux of time, I'm.
ಅದೇನ್
First, can I-
ಬರೀತೀರಿ ಈಗ ನಮ್ಮಷ್ಟು ಕೇಸಂಕು ಇರಲ್ಲ ನಿಮ್ಗೆ. How you can
Impossible.
forget? ಹಾ.
No, not all of us are gifted with your lordship's memory also.
ಇಲ್ಲ ನಾವು ನೋಡಿರ್ತೇವಲ್ಲ ಅದಕ್ಕೆ.
And 114 employees, 114.
114. ಮತ್ತೆ ಅವ್ರಿಗೇನು ಏನು ಅದು ಚೀಟಿ ಏನೋ ಬರ್ಕೊಟ್ಟಿದ್ರು ಲಾಸ್ಟ್ ಟೈಮ್.
No, we'll put that also in our memo, whatever our submission in that regard is.
ಅಲ್ಲಿ ಒಂದು ಚಿಕ್ಕ ನಾವು ಅದನ್ನ ಚೀಟಿ ಮರ್ತೀವಿ ನಾವು ಅಮೌಂಟ್ ಇದ್ದಿದ್ದು ಒಂದ್ಸರಿ ಇನ್ನೊಂದ್ಸರಿ
ಇಲ್ಲ, ಮತ್ತೆ
ನಮ್ಗೆ
clients ಗೆ ಕೇಳ್ಬೇಕಾಗತ್ತೆ. ಇವ್ರು ಸಮೇತ, I don't want to put him on the spot. ಅದ clients ಗೆ ಹೇಳಿ.
ಮತ್ತೆ ಹಿಂಗೆ ಹಾಕೋತ್ ಹೋಗ್ತದೆ. ಮತ್ತೆ ಜೋಶಿ ಸಾಹೇಬರು ಧಾರವಾಡಕ್ಕೆ
ಇಲ್ಲ,
ಹೋಗ್ತಾರೆ.
ಇಲ್ಲ.
ಅದು ಮುಗಿಸೋದೇ ಅವಾಗ ನಾವು ಕೇಸ್
No, but we'll in that memo, we will put it forward. Or all should have it in maybe half an hour.
ಜಸ್ಟ್ ಹಂಗೆ ಬಂತು. ಲಾಸ್ಟ್ ಟೈಮ್ ಚೀಟಿಯಲ್ಲಿ ಇತ್ತಲ್ಲ. I remember the quote, but I want to have it from your tongue, just.
In this call. Well, could your lordship pass it over, then we will get back. Today itself.
Heard and heard. Yes, reserved.
We'll come back.
ಕೊಡಿ ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಇಷ್ಟು ಹಾಕೊಂಡು ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಟ್ಯೂಸ್ಡೇ ಹಾಕ್ತೀರಾ? ಎನಿವೆ ಈ ಟ್ಯೂಸ್ಡೇ ಥರ್ಸ್ಡೇ ತನಕ ನಾವೇನು ಆರ್ಡರ್ ಬರೆಯಲ್ಲ, ಬಟ್ ಜಸ್ಟ್ ಫ್ರೇಮ್ ಸ್ಟಾರ್ಟ್ ಆಗ್ತದೆ. ಇನ್ ದ ಮೀನ್ ವೈಲ್ಸ್ ಕೊಡಿ ಹೀಗೆ ಅಂತ.
Is that rent, my lord? ಅವ್ರು ಕೊಟ್ರ?
I appear for the official liquidator.
Petition. Brother Will Gold. ಸಮಿತ್, ಈಗ ರಿಸಲ್ಟ್ ಅಂದ್ರೆ ಯಾವ್ದ್ರ ಮೇಲೆ ಜಡ್ಜ್ಮೆಂಟ್ ಬರಿಬೇಕು ನಾವು? ಆ ಕಂಪನಿ ಪಿಟಿಷನ್ ಹಾಗೆ ಉಳಿಯುತ್ತಾನು?
Certain applications that were filed in the, but OSA is what the appeal is against his lordship's judgment.
Order made in company petition.
In the company petition, against that, wherein the learned company judge ordered that the company be revived. It is against that the employees are in appeal. So it have to be passed in the OSA itself. And there were some applications that were filed by some of the employees who were not part. So for example, Mr. Rakesh Bhatt's clients, they had filed his application. Then,
but our independent application maintain ಆಗ್ತದೆ. ಅದೊಂದು ಸೆಕ್ಷನ್ ತೋರಿಸಿದ್ರಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್.
yes, ma'am.
391. ಹೌದು.
In the OSA itself.
ಶ್ರೀಶೈಲ್
is for the OSA.
Appear for the order.
ಎಸ್
Serial
Yes.
number 2.
ಸಬ್ಮಿಟ್.
Please.
ಸೀರಿಯಲ್ ನಂಬರ್ 2 ದಲ್ಲಿ
Oh, sorry.
is another.
Sorry.
Yes. ಹೋಲ್ಡರ್ ಕೇಸ್ ನಲ್ಲಿ ಇರಬೇಕು.
Yes.
ನಮ್ಗೇನಾರ ಡಿಫಿಕಲ್ಟಿ ಆಯ್ತು ಅಂದ್ರೆ ಮತ್ತೆ ನಾವು ಪೋಸ್ಟ್ ಮಾಡಲ್ಲ, ನಿಮ್ಮೆಲ್ಲರಿಗೂ ಫೋನ್ ಮಾಡಿ ಅಲ್ಲಿ ಚೇಂಬರಿಗೆ ಕರ್ಸ್ಕೊಂಡು ಕ್ಲಾರಿಫೈ
Our duty to assist.
ಇಫ್
Our duty, we are always.
ಓಕೆ.
ಕೊಡ್ರಿ ಅದನ್ನ. ಕೋರ್ಟ್ ಕೊಡೋದು ಎಲ್ಲಿದೆ?
ನಿನ್ನೆ 31 lakhs ಅಂದ್ರೆ 10 lakhs ಕೊಡ್ಬೇಕಾಗಿತ್ತು ಪರ್ ಮಂತ್. 3 ತಿಂಗಳು ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ. ನಾನು ನಿನ್ನೆ ಹೇಳಿದೆ ನಾನು ಬರೋದಿಲ್ಲ ಇನ್ನು ಅಂತ ಹೇಳಿದೆ. ಕೊಟ್ಟಿದ್ದಾರೆ. ಎವ್ರಿ ಮಂತ್ we will ensure that the 90 rupees was what was agreed.
ಬಟ್ ದೇ ಅಸರ್ಟೆಡ್ ದಟ್ ಇಟ್ ಇಸ್ ಆಲ್ರೆಡಿ ಪೇಡ್ ಅಂತ ಅಸರ್ಟ್ ಮಾಡಿದ್ರು. ಅದಕ್ಕೆ ಏನಾರ ಆಗ್ಬೇಕಲ್ಲ?
ಅದಕ್ಕೆ Lord, what is no. I don't want to say
There is one
anything.
section
I don't want to say anything, my lord.
in transfer of property act there is one section.
ಅಲ್ಲ ಅದೇ ನಾನು ಹೇಳೋದಿಲ್ಲ ನಾನು.
ಆಮೇಲೆ ನಿಮ್ ಫಾದರ್ ನನ್ನ ಗುರುಗಳು ಬಿಪಿ ಹೊಂಡರ್ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದೆ ಕೇಸ್ ಇದೆ. ಹೌದು ಮಿಸ್ಟರ್.
ಅಲ್ಲ ನಾನು ಅದೆಲ್ಲ ಹೇಳಿದ್ದು. ನಾನು ಏನು ಹೇಳೋದಿಲ್ಲ ಅಂದ್ರೆ ಇದ್ರ ಬಗ್ಗೆ ತಾವೀಗ ಹೇಳೋದ್ರಲ್ಲ ಅದ್ರ ಬಗ್ಗೆ ನಾನು ಹೇಳೋದಿಲ್ಲ. ವಾಟ್ ಎವರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಸೇಸ್, my lord, I will accept it.
Yes, Mr. Nalgan.
Please, my lord. ನೆನ್ನೆ 31 lakhs ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ನಿನ್ನೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು ಸ್ವಾಮಿ.
ಇಲ್ಲಿ ನಾವು ಹೇಳಿದ ಮೇಲೆ
ಹೇಳಿದ್ಮೇಲೆ. It's a very
3 ತಿಂಗಳದ್ದು ಆಗ್ತದಾ?
ಸ್ವಾಮಿ.
3 months ಏನೋ ಆಗ್ಬೇಕಲ್ಲ?
3 months.
dispute
90 rupees, my lord, is what was agreed before the mediator. That was, my lord, what was placed before the learned company judge, because that was sent for the mediation. 90 rupees ಪ್ರಕಾರ 10 lakhs every month. ಅದು 31 lakhs ಕೊಟ್ಟಿದ್ದೀವಿ ನಾವು.
31 lakhs ಕೊಟ್ಟಿದ್ದಾರೆ.
And my lord, we'll have to, I have told them, if you don't pay every month, ನಾನು ಬರೋದಿಲ್ಲ ಅಂತಾನೆ ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀನಿ.
ನೀವು ಬರಲ್ಲ, ಮತ್ತೆ ನಿಮ್ಗೆ ಏನು ರಿಲೀಫ್ ಸಿಗಲ್ಲ ಈ ಕೋರ್ಟ್ ನಲ್ಲಿ ಅಂತ ಹೇಳ್ತೀರಿ.
ಹೌದು, ಅದನ್ನು ಹೇಳಿದ್ದೀನಿ.
ಇನ್ನೊಂದು 5 ಲಕ್ಷ ರೂಪಾಯಿ ಕಂಪನಿ ಕೊಡ್ಲಿಕ್ಕೆ ಹೇಳಿ.
ಆಗ್ಬೋದು.
Another 5 lakhs by way of cost and penalty, let them pay. Senior advocate Mr. Holla in all fairness submits that he has advised his client to be punctual in making the payment and that the deficit has been made good yesterday. First off, we partly appreciate this. First off, for the remaining part of unappreciation, we direct the appellant company,
ಹೌದು ಸ್ವಾಮಿ.
appellant company to pay to, another sum of rupees 5 lakh by way of cost, but if not penalty, first, we also warn the company that the conduct would be one of the factors in deciding this matter. First up, the payment now directed has to be made within 2 days. Okay. Next.
May I make one request, Swami?
Ah,
The appeal is on very short, limited points,
no,
Swami.
ಇವತ್ತಾಗಲ್ಲ 31J ದಿಂದ advocates have come.
Any
appointment.
date, if I may
ನಿಮ್ಮಲ್ಲಿ
request,
ಏನಾಗ್ತದೆ, for companies do not die because of Solomon and Solomon, but people die.
I appreciate.
People age and they die. ಅದು ಹಿಂಗಿದೆ. ನಿಮ್ಮಲ್ಲಿ ಏಜಿಂಗ್ ಇಲ್ಲ. ನೀವೆಲ್ಲ
ಇವತ್ತು
ಚಿರಂಜೀವಿಗಳು, ಕಂಪನಿಗಳೆಲ್ಲ ಚಿರಂಜೀವಿಗಳು. All legal persons are ಚಿರಂಜೀವಿ. They do not die.
ವೈಂಡಿಂಗ್ ಅಪ್ ಆಗುವಾಗ ಅದು ಸತ್ಯ ಹೋಗುತ್ತೆ. Then ಅದು ಸೋಲು ಇರೋದಿಲ್ಲ, ಯಾಕಂದ್ರೆ ಕಂಪನಿ ನೇಮ ಕಿತ್ತಾಕ್ಬಿಡ್ತಾರೆ.
Yes.
That interim order has to be extended. Now in the
Interim order to continue, subject to making the additional payment. First off, this additional payment shall not be accounted to the amount payable on regular basis. Okay.
My lord, if convenient, a date may be fixed.
Bharat.
Grateful.
Three. Correct. Charity. Please, ಅವ್ರು ಬರೋವರೆಗೆ ನೀವು ಹೇಳಿ. ಗವರ್ಮೆಂಟ್
ಅವ್ರದ್ದಾಗಿದೆ.
ಅವ್ರದ್ದಾಗಿದೆ, ನಿಮ್ದು ಹೇಳಿ.
State government is concerned, my lordship, whatever arguments advanced by the BDAs, my lordship, covered my statement of objection.
What do you say about the chief minister's order?
That is based on their recommendation, my lordship, CM is.
So you accepted recommendation of the BDA.
Please,
Then only the honorable chief minister had put subscribed his signature to this document.
subsequently based on subsequent.
ಏನಂತ recommend ಮಾಡಿದ್ರು ಅವರು? What was the recommendation of the BDA?
This is, my lordship, kindly along with memo.
So you stand by the order of the government.
Yes,
You stand by the order of the government.
please.
ಒಂದ್ಸರಿ ಈ ಕಡೆಗೆ ಇದ್ರಲ್ಲಿ ಬರ್ರಿ, ಇದ್ರಲ್ಲಿ ಕಾಣ್ರಿ, so that your statement we seen by.
Please, my lord.
ನಾಳೆ ಮತ್ತೆ ನಾವು ಹೇಳಲ್ಲ, ಹಿಂಗೆಲ್ಲ ಹೇಳ್ಬೋದು. We
Yes, my lord.
specifically asked
Yeah.
AGA, Shri so and so, as to what would be the stand of the government, in the sense that government still adheres to the note sheet containing the signature of additional chief secretary
Yes.
and the honorable chief minister. First off, he answers that government would stand by its,
Under the instruction of RPCL.
he submits that government would stand by the said note sheet, and that he is making this submission on the instruction of whom?
The RPCL, my lordship.
ಯಾರು ಹೇಳಿ, ಹೆಸರು ಹೇಳಿ, ಅವ್ರಿಗೆ ಹೇಳ್ಕೊಂಡು ಹೇಳ್ತೇನೆ ನಾನು. ನೀವು ಹಂಗೆ ಹೇಳಿ ಗೊತ್ತಾಗಲ್ಲ, ಬರೀಬೇಕಲ್ಲ.
SO, my lordship, Divakar SO.
ದಿವಾಕರ್
officer,
SO.
please.
ಯಾರು SO ಅಂದ್ರೆ ಏನು?
Section,
ಸೆಕ್ಷನ್ ಆಫೀಸರ್.
please.
As
He's in.
ಎಲ್ಲಾರು ಏನಾದ್ರು ಅಫಿಡೇವಿಟ್ ಸಿಗ್ನೇಚರ್ ಎಲ್ಲಾರು ಮಾಡಿದಾರ ಪ್ರೀಡಿಂಗ್ಸ್?
ಇಲ್ಲ, ಅವ್ರದ್ದು ಅದಿಲ್ಲ.
ಮತ್ತೆ ಯಾರು
Under secretary
ಗೊತ್ತಾಗತ್ತೆ?
ಅಂಡರ್ ಸೆಕ್ರೆಟರಿ ಮಾಡಿದ್ದಾರೆ.
ಅಂಡರ್ ಸೆಕ್ರೆಟರಿ.
ಪ್ಲೀಸ್. Under secretary.
ವಾಟ್ ಈಸ್ ಹೀಸ್ ರೋಲ್ ಬೇಕು ಅವನಿಗೆ? ಅಂಡರ್ಟೇಕಿಂಗ್ ನಾಳೆ ಮತ್ತೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ SO ಪವರ್ ಇಲ್ಲ, ತಪ್ಪು ಹೇಳಿ ಮತ್ತೆ ಅದು ರಿಕಾಲ್ ಮಾಡಿ.
Statement of objection in para 10, my lordship, please see.
First, on the instructions, first of the concerned jurisdictional officials. Okay. He also presses into service the stand of the government in para 10 of the SO, please, 10 of the SO, saying that this para 10 is structured consistent with the note sheet. Correcta? ನೀವು ಮಾತಾಡಿ ರೆಕಾರ್ಡ್ ಆಗ್ಬೇಕಿಲ್ಲ.
Please, my lord.
ಹಾ
Kindly, that last portion of the para 10, my lord, see,
ಓದಿ.
it was also observed that the state government has not issued any notification under section 48(1) of the land acquisition Act,
First.
deleting the land in acquisition proceedings. That is the,
But delete ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ ನಿಜ.
yes, my lord.
He also reads out the last 3 lines of this paragraph to the effect that government has not issued any order under section 48 of erstwhile LA Act 1894 denotifying the land from acquisition. First up, when we again asked the stand of the government, comma, he says that it is reflected in the note sheet itself. Okay.
Other thing is, my
Palla
lordship,
wanted
adopt
to-
the, my lordship, argument advanced by the BDA.
Subject to what next paragraph? Subject to what has been stated above, comma. Learned EGA adopts the submission of learned senior panel counsel appearing for the BDA. Okay. ಯಾವುದೋ ಒಂದು ಸೆಟ್ ಅಸೈಡ್ ಆಗಿದೆ ಅನ್ಕೊಂಡು ಹೇಳಿದ್ರಿ ನೀವು. You said yesterday, you said you were instructing counsel,
Yes.
said the endorsement is set aside.
My lord, can I persuade your lordships?
But
Just come to ಇವರದ್ದು ಶಾಂತನಗೌಡರು.
But
ಅದರಲ್ಲಿ ಪ್ಲೀಸ್ ಕಮ್ ಟು ಪೇಜ್ 45, my lord. ಈ ತರದ್ದು ಮಾಡಿಬಿಟ್ಟು ಕೊಡ್ಬೇಡಿ, ಅಲ್ಲೇ ಚುಚ್ಚಿಸ್ಬಿಟ್ಟು ಮಾಡಿಬಿಡಿ. ಜಡ್ಜಿರು ಕೊಡ್ಬೇಕಾದ್ರೆ ಸ್ಟಿಚ್
ಅದು
ಮಾಡಿ.
ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ನಿನ್ನೆ ಹೇಳಿದ್ರಲ್ಲ, ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅವ್ರದ್ದು ಅಂತ.
ಹೌದು.
ಅದು ಡೇಟ್ ಏನು?
15/6/2006.
15/6/2006.
Yes.
Just to freshen our
Please,
memory.
page 30,
Page,
page 38 of my memo,
your memo.
please. Oh. 31/1/2025.
ತಿರಸ್ಕರಿಸುತ್ತದೆಂದು ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ.
I may, lordship may permit me to read that.
Ah.
Why is, because this was a representation filed by the Tata Housing
Correct.
Limited.
Correct.
Lordship may kindly see the first paragraph onwards, this may of ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಅಪೀಲ್ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕ 25/1/2005 ನೀಡಿರುವ ಆದೇಶದನ್ವಯ 800 ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಜಮೀನನ್ನು ಭೂಸ್ವಾಧೀನದಿಂದ ಕೈಬಿಡಲು ಕೋರಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಲು ನಿರ್ದೇಶನ ನೀಡಿದ್ದು, ತಾವು ದಿನಾಂಕ 28/12/2015 ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿಯಲ್ಲಿ 5ರಲ್ಲಿ ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿಯಲ್ಲಿ ದಿನಾಂಕ 31/12/2005 ಅರ್ಜಿ ಸಲ್ಲಿಸುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತೀರಿ. ಆದರೆ ಸದರಿ ಅರ್ಜಿ ದಿನಾಂಕದೊಳಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿಲ್ಲ. ತಡವಾಗಿ ಅಂದರೆ ದಿನಾಂಕ 8/5/2006 ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತೀರಿ. ಮುಂದುವರೆದು ಸದರಿ ಜಮೀನಿನ ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಿದ್ದು, ಜಮೀನು ಖಾಲಿ ಇದ್ದು ಅಕ್ಕಪಕ್ಕದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಜಮೀನುಗಳು ಅರ್ಕಾವತಿ ಬಡಾವಣೆಗೆ ಭೂಸ್ವಾಧೀನಕ್ಕೆ ಒಳಪಟ್ಟಿರುತ್ತದೆ ಮತ್ತು ಜಮೀನು ಬಡಾವಣೆ ನಿರ್ಮಿಸಲು ಯೋಗ್ಯ ಹಾಗೂ ಅತ್ಯವಶ್ಯಕವಾಗಿರುತ್ತದೆ. ಈ ಎಲ್ಲ ಮೇಲ ಕಾರಣಗಳಿಂದ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದನ್ವಯ 800 ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ 26 ಎಕರೆ 12 ಗುಂಟೆ ಜಮೀನನ್ನು ಭೂಸ್ವಾಧೀನದಿಂದ ಕೈ ಬಿಡಲು ತಾವು ಕೋರಿ ತಾವು ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿಯ ಎಲ್ಲಾ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಸದರಿ ಜಮೀನು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ನೀಡಿರುವ ಯಾವುದೇ ಮಾರ್ಗಸೂಚಿಗಳಲ್ಲಿ ಅಡಿಯಲ್ಲಿ ಬರುವುದಿಲ್ಲವಾಗಿರುವ ಕಾರಣ ಹಾಗೂ ಸದರಿ ಜಮೀನು ಪ್ರಾಧಿಕಾರದ ಅರ್ಕಾವತಿ ಬಡಾವಣೆ ರಚನೆಗೆ ಅತ್ಯವಶ್ಯಕವಾಗಿ ಬೇಕಾಗಿರುವ ಕಾರಣ ದಿನಾಂಕ 31/5/2006 ನಡೆದ ಪ್ರಾಧಿಕಾರದ ಸಭೆಯಲ್ಲಿ ವಿವರವಾಗಿ
Because it did not comply with any of the parameters.
Entire contention of Tatas was rejected by this endorsement.
As a consequence, they consented to
For-
acquisition, therefore acquisition would stand intact is your stand.
Yes. And
Yes.
that finding and that order of the.
They have
division
attained
bench
finality.
Attained final.
There being no challenge to this. Okay.
Lord, please come to my lord, the compilation of judgment that we had given to your lordships. First I put it. Compilation, judgment, pseudo affidavit. Yes. Please come to page 45. ಎಲ್ಲ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ಸ್ ಅನ್ನು ವಾಚ್ ಮಾಡ್ಬಿಟ್ಟು ರೀಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ ಹೇಳು.
Page number, sir?
Page 45. Please come to my lord, the division bench order is referred to in my lord in the middle of paragraph 2. Then ultimately my lord, para 4. ಅದಕ್ಕಿಂತ 2 ಲೈನ್ ಮುಂಚೆ all endorsements are liable to be quashed. The 4, land acquisition officer, the Bangalore Development Authority shall hold a spot inspection after notice the petitioners thereafter proceed in accordance with law. Petitioners as well as the Bangalore Development Authority are directed to maintain status quo with regard to the properties in question during the consideration. No fresh construction shall be made by the petitioner in the meanwhile, etc., etc. Ultimately, my lord, please look at this, my lord. This endorsement, so-called endorsement, is of 2006. Supreme Court order, my lord, is 2010, and I'll point out everything. It is, my lord, in the middle, my lord, what they did, I'll point out. Now, my lord, the first contention that they have raised is, sorry.
Endorsement dated then 16/6/2005. Question. Sixteen six 2005.
5 is an endorsement at page 47, if your lordship would see. What was set aside, and this was not by Tata.
My lord, my learned friend will please be seated. Let me do what I want. Every time, my lord, he argues. My lord, this is what I find with the greatest respect. When, my lord, they argue, if I, my lord, even open my mouth, they'll say, you can't do it, I'm on my legs. When I argue, they want to, my lord, interrupt every now and then. Not fair.
Nim page heading.
My lord, my submission to your lordship says, the order passed by the Supreme Court, my lord, is in the year 2010. Matter was seized off by the Supreme Court. Please look at it. How could they have, my lord, given an endorsement in 2006? This is one aspect. Second, ultimately, my lord, in the light of this order that was passed by this honorable court, everything was, my lord, reconsidered, my lord, by the authorities. And, my lord, they said, all the neighboring lands, my lord, have been deleted from acquisition. Please come to, my lord, the order passed by the land acquisition officer. There, no? Annexure E, my lord, of the writ petition.
ಅಲ್ಲ ಒಂದೇ ನಿಮಿಷ ನೀವು ಪೇಜ್ 45 ಓದ್ತಾ ಇದ್ರಿ ಹೊಳ್ರೆ.
Yes,
45 is 23/8/2006. This is subsequent to endorsement. Subsequent to endorsement.
ಹೌದು.
Date ಹೇಳಿ ಅಷ್ಟೇ.
ಇದು in this, sorry.
ನಾವು ಸಿಂಪಲ್ ನಾವು ಕೇಳ್ತಾ ಇದ್ದೇವೆ ಹೇಳಿ. Is it after the judgment or before the judgment? ನಿಮ್ಮ endorsement.
After the judgment of the division bench, before the judgment of the Honorable Supreme Court.
ಅದಲ್ಲ ಕೇಳ್ತಾ ಇರೋದು ಇದಕ್ಕಿಂತ ಮುಂಚೆ ನಾನು.
Page 45 ಓದ್ತಾ ಇದ್ರಾ?
Page 45 of the memo, Lord. Lordship Justice.
Page 45 ಅವ್ರದ್ದು citation.
Lordship Justice.
List of authorities ನಲ್ಲಿ.
Justice Shantanu.
ಶಾಂತಗೌಡ ಸಾಹೇಬ್ರದ್ದು
Please.
ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಚಾಲೆಂಜ್ ಆಗಿದ್ದು 16/6/2005. ಬನ್ನಿ ಪೇಜ್ 46 ಗೆ.
46.
ಅಲ್ಲಿ ಹೆಬ್ಬೆಂಡಂ ನೋಡಿ.
ಇದು, sorry to say, if I am permitted, this is not a petition by Tata Housing.
Just asking. We are just asking. This is not by
This is not by Tata Housing. Tata Housing neither challenge this endorsement nor the petitioners challenge this endorsement is my respectful submission.
All right, that you have said.
Yes,
ಶ್ರೀಮತಿ ಪುಷ್ಪಾವತಮ್ಮ.
ಇಲ್ಲ, ಅವ್ರ ಸಂಬಂಧನೇ ಇಲ್ಲ ಈ ಲ್ಯಾಂಡ್ಗೆ.
ಈ ಲ್ಯಾಂಡ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ನಲ್ಲಿ ಈ ಲ್ಯಾಂಡ್ ಇತ್ತ?
ಈ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಈ ಡಿಸಿಷನ್ ಅಲ್ಲಿ ಈ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ 15/6/2006 ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಇಸ್ ನಾಟ್ ಅ ಪಾರ್ಟ್ ಆಫ್ ದಿಸ್ ರಿಟ್ ಪಿಟಿಷನ್.
ಒಂದು ಪ್ರಶ್ನೆ ಕೇಳ್ತಾ
ಹೌದು
ಇದ್ದೀನಿ. 16/6/2005 ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ನಲ್ಲಿ
ಇಲ್ಲ.
ಪಿಟಿಷನ್ ಲ್ಯಾಂಡ್ ಇತ್ತ?
ಇಲ್ಲ.
ಇಲ್ಲ. ನಿಮ್ಮಲ್ಲಿ ಏನಾರ ಕಾಪಿ ಇದೆಯಾ?
ಇದನ್ನ
ಬಟ್ ಅವರೆಲ್ಲ ಸಿಮಿಲರ್ಲಿ ಸರ್ಕಮ್ಸ್ಟಾನ್ಸ್
ಹೌದು.
ಇವರು
ಇರ್-
ಮತ್ತು ಪಿಟಿಷನರ್ಸ್
ಹೌದು.
ಅವಾಗನೇ ಈ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಇನ್ನೊಂದ್ಸರಿ ಫ್ರೆಶ್ ಆಗಿ ನೀವು ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕು ಅನ್ಕೊಂಡು.
ಹೌದು ಅಲ್ಲಿ ಸಾರಿ
ಸಾರಿ
ಇಲ್ಲ.
ಅಂತ ತಪ್ಪಲಜಿಟಿಕ್ ಇರೋ ಅಗತ್ಯಿಲ್ಲ. ನಿಮ್ ಸ್ಟ್ಯಾಂಡ್ ಅನ್ನು ನೀವು ಹೇಳಿ.
Yes.
ನಾವು ಕೇಳ್ತಾ ಇದ್ದೇವೆ, ಹೇಳಿ.
Here they cannot equate their case with any other
We
land.
are asking you.
Yes.
Not equating.
Similar.
We are asking you.
Similar
ಅವ್ರು ಸಿಮಿಲರ್ಲಿ ಸರ್ಕಮ್ಸ್ಟಾನ್ಸ್ಡ್ ಇದ್ರ?
similarly circumstance in certain points, but insofar as Tata Housing is concerned, there was an additional circumstance which the BDO was supposed to look into. That was a separate endorsement. Yes.
ಬಟ್ ಇವರು ಮತ್ತು ಅನೇಕ ಆಸ್ಪೆಕ್ಟ್ಸ್ ನಲ್ಲಿ ಈ ಲ್ಯಾಂಡ್ ಓನರು ಮತ್ತು ಪಿಟಿಷನರ್ಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಪಾಯಿಂಟ್ they work together.
Our aim contention before Lordship Justice Shantan Gaudru was that you have unilaterally taken a decision to not to delete without even giving us a chance of participating in the inspection. So your unilateral decision of rejecting it is bad in law of the contention. That was upheld.
Understood.
Yes.
Kindly be seated.
Thank you. Please.
Yes, sir.
Then, my lord, the first of the submission, my lord, that my learned friend made was, BDA has not passed any resolution for deleting the lands in question.
Correct.
Please look at, my lord, the order at Annexure E, page 64, first other writ petition.
ನಿಮ್ಮ 16139
Out Swami.
Annexure E page.
My lord, page 72. This is, my lord, there was a re-examination, my lord, of all the lands pursuant to the orders of His Lordship Justice Shantan Gowda. Please come to page 77, final report.
As per
Last
the order.
paragraph. As per the final decree, lands in survey number so and so, so and so, so and so, so and so, that's all our lands, are to be released from government ownership based on the sixth schedule of the division bench decision. Accordingly, the lands of survey number so and so, so and so do not fall within any schedule of the division bench and thus can be retained under the government ownership. Necessary steps. Idu translation no. ಸರಿ ಇಲ್ಲ. Please come to my lord, running page 70. ಅದು ಕನ್ನಡದಲ್ಲಿ ತೋರಿಸ್ತೀವಿ. ಇದು
ಅದು ಆರ್ಡರ್
ಎಲ್ಲ ಮರ್ಡರ್ ಮಾಡ್ತಾರೆ ಇವರು. ಕ್ಷಮಿಸಬೇಕು.
ಇಲ್ಲ.
Please come to page 70. ಅದರಲ್ಲಿ 1, 2, 3, 4, 5, 6, 7, 8, 9 lines from the bottom, my lord. ಮೇಲ್ಕಂಡ, my lords, sorry, 70ನೇ ಪೇಜು.
70.
Yes, ma'am. ಅಂತಿಮ ವರದಿ ಇದು.
Correct.
ಮೇಲ್ಕಂಡ
Final report.
ಅದರಲ್ಲಿ, my lord, please come to, my lord, from the bottom 10 lines. ಮೇಲ್ಕಂಡ ಸರ್ವೆ ನಂಬರ್ 17/1, 18, 19, 20, 26 ಜಮೀನುಗಳು ಮೇಲೆ ವಿವರಿಸಿದ ಚಕ್ಬಂದಿಗೆ ಒಳಪಟ್ಟಿದ್ದು, ಒಂದಕ್ಕೊಂದು ಲಗತ್ತಾಗಿ ಒಂದೇ ತಾಕಿನಲ್ಲಿದ್ದು, ಸದರಿ ಜಮೀನುಗಳ ಅಕ್ಕಪಕ್ಕದ ಜಮೀನುಗಳು ಈಗಾಗಲೇ ಭೂಸ್ವಾಧೀನದಿಂದ ಕೈಬಿಟ್ಟಿರುವುದರಿಂದ ಈ ಜಮೀನುಗಳು ವಿಭಾಗೀಯ ಪೀಠದ 6 ಮಾರ್ಗಸೂಚಿಗಳ ಪೈಕಿ 6ನೇ ಮಾರ್ಗಸೂಚಿಗೆ ಒಳಪಟ್ಟಿರುವುದಾಗಿ ಅಭಿಪ್ರಾಯಪಟ್ಟಿರುತ್ತೇನೆ. ಆದ್ರೆ ಮಲೋಡ್ 39 ಗುಂಟಾಸ್ ಮಾತ್ರ ಸೇರೋದಿಲ್ಲ ಅಂತಾರೆ. ಇಲ್ಲಿ ಕೆಳಗಡೆ ಇದ್ರಲ್ಲಿ ಹೇಳ್ತಾರೆ
ಉಳಿದಂತದ್ದು.
ಉಳಿದ 39 ಗುಂಟ
1 ಎಕರೆ ಸೇರಲ್ಲ
ಅಷ್ಟೇ, ಬಾಕಿದೆಲ್ಲ ಸೇರುತ್ತೆ ಅಂತ ಹೇಳಿ.
ಇದನ್ನ
ಅಂತಿಮ ವರದಿ ಪ್ಲಾಟ್ ಪೇಜ್ 71.
ಕರೆಕ್ಟ್. ಯಾರು ಇಶ್ಯೂ ಮಾಡಿದ್ದು?
Milord, this is that pursuant to the orders of this honorable court, division bench and justice. Yes, my lord. He, my lord, inspects in the presence of everybody and my lord gives this report.
This is a long after the endorsement.
Yes, my lord. 2012. ತಾವು ಡೇಟ್ ಬರುತ್ತೆ ನೋಡಿ.
8 February 2012.
Correct. And my lord, BDA passes a resolution. My lord, please come to my lord page 131. ಇದೇ compilation 131 ಗೆ ಬನ್ನಿ ಸ್ವಾಮಿ. ನಲ್ಲಿ my lord, ವಿಷಯ ವಿಷಯ ಸಂಖ್ಯೆ 79/13. My lord, this is the board, my lord, the board of BDM, my lord, takes a decision.
12/2/2013.
13, my lord.
Subject, the agenda number 79/13.
13. ಚರ್ಚೆಯ ನಂತರ, my lord, please come to my lord number 2. ಅಲ್ಲಿ ಚರ್ಚೆಯ ನಂತರ ಅಂತ my lord second
ಅರ್ಕಾವತಿ ಬಡಾವಣೆ ಯೋಜನೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ
ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಹಾಗೂ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ಅನುಸಾರ ಮತ್ತು ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆಯ ಅನುಸಾರ ರಿಟ್ ಅರ್ಜಿ ಮತ್ತು ರಿಟ್ ಅಪೀಲ್ ಹಾಗೂ ಸಿವಿಲ್ ಅಪೀಲ್ಗಳಲ್ಲಿನ ಎಲ್ಲಾ ಭೂಮಾಲೀಕರು ತಕರಾರು ಅರ್ಜಿಗಳ ಮರು ವಿಚಾರಣೆ ನಡೆಸಿ ಈ ಪ್ರಕರಣಗಳಲ್ಲಿ ವಿಶೇಷ ಭೂ ಸ್ವಾಧೀನಾಧಿಕಾರಿಗಳು ಹೊರಡಿಸಿರುವ ಆದೇಶಗಳನ್ನು ಗ್ರಾಮವಾರು ಕ್ರೋಢೀಕರಿಸಿ ಸದರಿ ಆದೇಶಗಳ ಹಾಗೂ ಅದರೊಂದಿಗೆ
ಎಲ್ಲಾ ಭೂಮಾಲೀಕರ ತಕರಾರು ಅರ್ಜಿಗಳ ಮರುಪರಿಶೀಲನೆ ನಡೆಸಿ ವಿಚಾರಣೆ ನಡೆಸಿ.
ಕರೆಕ್ಟ್.
ಎಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಮವರು ಬಂದು
Yes, and it doesn't end there. Please come to my lord paragraph 4. ಸದರಿ ಪಟ್ಟಿಗಳನ್ನು ಆಯುಕ್ತರು ಬೆಂಗಳೂರು ಅಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ಅವರು ಮರುಪರಿಶೀಲಿಸಿ ಪ್ರತ್ಯೇಕವಾಗಿ ಗ್ರಾಮವಾರು ಪೂರ್ಣ ಮಾಹಿತಿಗೊಳಗೊಂಡ ಪರಿಷ್ಕೃತ ಯೋಜನೆಯನ್ನು ತಯಾರಿಸಿ ಸರ್ಕಾರಕ್ಕೆ ಕಳಿಸಲು. My lord, the BDM, my lord, board authorized, my lord, the commissioner to do this. Today, my lord, their stand is completely different. I'll point out. This was, my lord, not even brought to your lordship's notice. Then 5. ಪರಿಷ್ಕೃತ ಯೋಜನೆಯನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಕಳಿಸಿದ ನಂತರ ಭೂ ಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆಯಿಂದ ಹೊರತುಪಡಿಸಿರುವ ಜಮೀನುಗಳ ಬಗ್ಗೆ ಅಗತ್ಯ ಕ್ರಮವನ್ನು ತೆಗೆದುಕೊಳ್ಳುವ ಅಧಿಕಾರವನ್ನು ಪ್ರಾಧಿಕಾರ ಆಯುಕ್ತರಿಗೆ ಪ್ರತ್ಯೋಜಿಸಲು
ಡೆಲಿಗೇಷನ್.
Yes, my lord. And in furtherance of this, sorry, page 141, Bani Swami, 141, they issue me an endorsement saying that this land of yours has been deleted from acquisition. 141. This is, my lord, in respect of 17/1, bottom last but one line al baratte.
By the commissioner.
By the commissioner. Then please come to page 143. 18. 143 ali last but one line. In fact, they take the opinion of the Advocate General also, as your lordship sees, my lord. Adralle baratte nodi. Page 143. It is in respect of 18. Survey number 18. Adrallu hage. After, my lord, examining the whole report, taking, my lord, opinion of the Advocate General, my lord, they pass this. And based on, my lord, that endorsement, I mean, the resolution of the BDA.
They have taken the opinion of Advocate General.
Yes, my lord. ಎಲ್ಲದರೊಳಗುನು. Then, my lord, 145. ಎಲ್ಲ ಸೇಮ್. ಎಲ್ಲದರೊಳಗೂ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಒಪಿನಿಯನ್ ತಗೊಂಡು ಮಾಡಿದ್ದಾರೆ. $145 is, my lord, in respect survey number 19.
ನಿಮ್ಮ ಲ್ಯಾಂಡ್ ಗೆ ಸಂಬಂಧಪಡೋದು.
ಹೌದು, ಎಲ್ಲ ಇದು.
ಇವಷ್ಟು ಎಲ್ಲದು.
ಹೌದು.
28/10/2020.
Separate ಆಗಿ, my lord, even in respect of each survey number they have issued. 145, then 147 in respect of survey number 20. $147 is survey number 20. 149 is in respect of survey number 26. Pages, my lord, 141, 143, 145, 147 and 149.
ಅದು ನಡುವೆ ಇಂಗ್ಲಿಷ್ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಇದು.
ಟ್ರಾನ್ಸ್ಲೇಷನ್ ನಡುವೆಯಲ್ಲಿ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಸ್ವಾಮಿ. ಅದು ನಾನು ಹೇಳಿದ್ನಲ್ಲ, ಇದೀಗ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಕನ್ನಡ ಇಂಗ್ಲಿಷ್ ಇರೋದು ಎಲ್ಲ, my lord, in the entire, my lord, Bangalore, there are 2 translators. ಅವರು ಕನ್ನಡವನ್ನು ಇಂಗ್ಲಿಷನ್ನು ಎರಡನ್ನು ಮರ್ಡರ್ ಮಾಡಿಬಿಟ್ಟಿರ್ತಾರೆ ಅಂತ ಹೇಳ್ತೀನಿ, ಅದಕ್ಕಿಂತ ಹೆಚ್ಚು ಹೇಳೋದು.
ಅಂದ್ರೆ ಈ ಎವ್ರಿ ಸರ್ವೆ ನಂಬರ್ಗೆ ಒಂದು ಸಪರೇಟ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್
ಕೊಟ್ಟಿದ್ದಾರೆ. And my lord, it doesn't end there. Look at their note sheet, my lord. Please come to the note sheet, which, my lord, my lord, we have filed, my lord, the entire note sheet of the BDA itself, along with our memo.
Memo
22/11/2024 ಅಲ್ಲಿ the entire note sheet of BDA, my lord, we have placed before your lordships after taking it under the RTI Act.
ಯಾವುದು ರಿಲೆವೆಂಟ್?
My lord, please come to, my lord, page 1. Page 1. After the tabular column, my lord, my lords get that, my lord, ಪ್ರಾಧಿಕಾರ ಅರ್ಕಾವತಿ ಬಡಾವಣೆ ಪರಿಷ್ಕೃತ ಯೋಜನೆಯಲ್ಲಿ ಮಾನ್ಯ ಉಚ್ಚ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯಗಳ ಆದೇಶಗಳ ಅನ್ವಯ ಮಾರ್ಗಸೂಚಿಯಲ್ಲಿ ಬರುವ ಜಮೀನುಗಳ ಬಗ್ಗೆ ಹೊರಡಿಸಿರುವ ಮರು ವಿಚಾರಣಾ ಆದೇಶಗಳು ಪ್ರಾಧಿಕಾರದ ಸಭೆಯ ನಡವಳಿ ಹಾಗೂ ಸರ್ಕಾರದ ವತಿಯಿಂದ ಭೂಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆಯಿಂದ ಕೈಬಿಟ್ಟು ಹೊರಡಿಸಿರುವ ಅಧಿಸೂಚನೆಗಳನ್ನು ಒಳಗೊಂಡಿದ್ದು ಆ ವಿವರಗಳು
ಈ
ಕೆಳಗಿನಂತೆ ಇದೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 3 is ಪ್ರಾಧಿಕಾರದ ಸಂಖ್ಯೆ ನಂಬರ್ 79. Please turn the page over. Para 12, serial number 12 ಬನ್ನಿ. Sorry. Serial number 12, writ appeal ಸಂಖ್ಯೆ 2757, serial number 12, page 2 ನಲ್ಲಿ. Sorry. ಎರಡನೇ ಪೇಜ್ ನೋಡಿ. ಅಲ್ಲಲ್ಲ. page 2, my lord.
Page 2,
my lord, sorry. ಅದರಲ್ಲಿ serial number 12
number
57 is our writ petition.
2005.
Correct. 26 acres 31 ಗುಂಟಾಸು ಭೂಸ್ವಾಧೀನದ ಹೊರತುಪಡಿಸಲಾದ ಜಮೀನುಗಳು. Then 75-76 ಬನ್ನಿ. Sorry.
75-76.
This is, my lord, 2 ಅಲ್ಲಿ serial number 12. ತಾವು ನೆಕ್ಸ್ಟ್ ಪೇಜಿಗೆ ಬನ್ನಿ ಸ್ವಾಮಿ. 3 page 3ಗೆ
ಕ್ರಮ ಸಂಖ್ಯೆ
ಕ್ರಮ ಸಂಖ್ಯೆ 6, 7, 8, 9, 12 is, my lord, ours as your lordship saw. ಪ್ರಕರಣಗಳ ಪ್ರಾಧಿಕಾರದ ಸಭೆಯ ವಿಷಯ ಸಂಖ್ಯೆ 57/11 ದಿನಾಂಕ 15/2/2011 ಒಳಪಡುತ್ತದೆ. ಸದರಿ ನಿರ್ಣಯದ ಆಯ್ದ ಭಾಗವನ್ನು ಪುನರುಚ್ಚರಿಸಲಾಗಿದೆ. ಅರ್ಕಾವತಿ ಬಡಾವಣೆಯ ಉಳಿದ ವಿಷಯಗಳ ಬಗ್ಗೆ ವಿಶೇಷ ಸಭೆ ತೀರ್ಮಾನ ತೆಗೆದುಕೊಳ್ಳುವಂತೆ ನಿರ್ಣಯಿಸಲಾಯಿತು ಹಾಗೂ ಹೀಗೆ ನಿರ್ಧರಿಸಿರುವ ಸಂದರ್ಭದಲ್ಲಿ
ನೀಡಿರುವ ನಿರ್ದೇಶನಗಳನ್ನು
ಸರ್ಕಾರಕ್ಕೆ ಶಿಫಾರಸು ಮಾಡಿ ಆದೇಶ ಪಡೆದ ನಂತರ ಜಾರಿಗೊಳಿಸಲು ಸಹ ನಿರ್ಣಯಿಸಲಾಯಿತು. Then, my lord, please come to page 41. ಇದರಲ್ಲೇನೆ all the note sheets, my lord, we have placed before your lordships. Page 41, 41. ಎರಡನೇ ಅನ್ನಂಬರ್ಡ್ ಪಾರ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಖಂಡಿಕೆ 20-24 ಪಟ್ಟಿಯಲ್ಲಿ ತಿಳಿಸಿರುವ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯಗಳ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯಗಳ ಆದೇಶಗಳನ್ವಯ ಭೂಸ್ವಾಧೀನಾಧಿಕಾರಿಗಳು ನೀಡಿರುವ ವರದಿ ಆದೇಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಪ್ರಾಧಿಕಾರದ ನಿರ್ಣಯಗಳನ್ವಯ ಅನುಮೋದಿತ ಯೋಜನೆ ವಿಸ್ತೀರ್ಣದಿಂದ ಕಡಿಮೆ ಮಾಡಿರುವ ಪ್ರದೇಶಗಳ ವಿವರಗಳು ಎಂಬ ಶೀರ್ಷಿಕೆಯಡಿಯಲ್ಲಿ ಪ್ರಾಧಿಕಾರದ ವಿಷಯ ಸಂಖ್ಯೆ 57/11 dated 15/2/2011 ಮತ್ತು ವಿಷಯ ಸಂಖ್ಯೆ 79/13 dated 12/2/2013 ನಿರ್ಣಯದನ್ವಯ ಪರಿಷ್ಕೃತ ಯೋಜನೆಯಲ್ಲಿ ಹೊರತುಪಡಿಸಿರುವ ವಿಸ್ತೀರ್ಣ ವಿವರಗಳು ಈ ಕೆಳಗಿನಂತೆ ಇರುತ್ತದೆ. ಪ್ಲೀಸ್ ಕಮ್ ಟು ದ
15, 16, 17.
Then, my lord, turn the page over. 18, 19. ಅದು 17/1, my lord, second column is the survey numbers. 17/1, 18, 19, 20, 26. Then, my lord, please come to page 60. ಇದು ಸರ್ಕಾರದ ನೋಟ್ ಶೀಟ್. ಅರ್ಕಾವತಿ 60ನೇ ಪೇಜ್
page
60. ಎಲ್ಲ ಹೇಳ್ತೀನಿ. ಅರ್ಕಾವತಿ ಬಡಾವಣೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪರಿಷ್ಕೃತ ಯೋಜನೆಯ ಬಗ್ಗೆ ನಾವು ಇಫ್ your lordships come to, my lord, the bottom
12.
ಅದು ಅಲ್ಲಿದೆ. ಇದು ಸರ್ಕಾರಕ್ಕೆ, my lord, ಅವ್ರು ಕಳಿಸಿರೋದನ್ನೆಲ್ಲ ಹೇಳಿಬಿಟ್ಟು ಪ್ಲೀಸ್ ಕಮ್ ಟು, my lord, ರನ್ನಿಂಗ್ ಪೇಜ್ 75. 75 ನೋಟ್ ನಂಬರ್ 366 ಬರುತ್ತೆ 75ರಲ್ಲಿ ನೋಟ್ ನಂಬರ್ 366 ದಿನಾಂಕ 27/3/2014 ಆಯುಕ್ತರು ಬಿಡಿಎ ಇವರು ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಿದ ಅರ್ಕಾವತಿ ಬಡಾವಣೆ ಪರಿಷ್ಕೃತ ಯೋಜನೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಕಡತಲ್ಲಿಸಲಾಗಿದ್ದು ಸ್ವಯಂ ವೇದ್ಯವಾಗಿರುತ್ತದೆ. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಸೂಚಿಸುವ ಎಲ್ಲ ಅಂಶಗಳು, ನ್ಯಾಯಾಲಯದ ಆದೇಶಗಳು, ಪ್ರಾಧಿಕಾರದ ಠರಾವುಗಳು ಹಾಗೂ ಈಗಾಗಲೇ ಸರ್ಕಾರ ಕೈಗೊಂಡಿರುವ ಕ್ರಮಗಳು ಈ ಎಲ್ಲವೂ ಸದರಿ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಒಳಗೊಂಡಿದ್ದು ಪ್ರಾಧಿಕಾರದ ಪರಿಷ್ಕೃತ ಯೋಜನೆಯ ಸರ್ಕಾರದ ಅನುಮೋದನೆಯನ್ನು ಕೋರಿರುತ್ತದೆ. ಅದರಂತೆ ಖಂಡಿಕೆ 361 ಪ್ರಸ್ತಾಪಿಸಿರುವಂತೆ ಪರಿಷ್ಕೃತ ಯೋಜನೆಯನ್ನು ಅನುಷ್ಠಾನಗೊಳಿಸಲು ಅನುಮೋದಿಸಬಹುದಾಗಿದೆ.
This is additional chief
ದಯಪೂರಿತವಾದ
secretary.
then my lord next page.
This is by additional chief secretary.
Yes. Then my lord just Sri Chief Minister puts his seal, signature. He approves it. 350ರಿಂದ 366 ಟಿಪ್ಪಣಿಗಳನ್ನು ಗಮನದಲ್ಲಿಟ್ಟುಕೊಂಡು ಖಂಡಿಕೆ 361ರ ಪ್ರಸ್ತಾವನೆಯಂತೆ ಪರಿಷ್ಕೃತ ಯೋಜನೆಯನ್ನು ಅನುಮೋದಿಸಿದೆ. ಅಧಿಸೂಚನೆ ಹೊರಡಿಸುವ ಮೊದಲು ಚುನಾವಣಾ ಆಯೋಗದ
ಅವಾಗಿನ ಎಲೆಕ್ಷನ್ ಪ್ರೊಸೆಸ್
ಆಗಿತ್ತು. Even otherwise, my lords may recollect. Court's order is automatically, there's no need for 48.
Because this is in furtherance of orders of the court.
Correct. Then, my lord.
ಯಾವ ವಿಲೇಜ್ ಇದು?
ಹೆನ್ನೂರು, my lord.
ಹೆನ್ನೂರು, ಚಳ್ಳಕೆರೆ, ಗೆದ್ದಲಹಳ್ಳಿ, ರಾಚನಹಳ್ಳಿ, ತಣಿಸಂದ್ರ, ಅಮೃತಹಳ್ಳಿ, ದಾಸರಹಳ್ಳಿ.
Page 41 ಅಲ್ಲಿ ಬಂತು ನೋಡಿ.
ಕರೆಕ್ಟ್.
Then, my lord. One to 51, my lord, is BDA note sheet.
Remaining is government
Note sheet, my lord, which they have, my lord, based on the BDA, my lord, letters, note sheet.
This you have produced only to dispel the doubt that
Correct.
whether that resolution was passed or not.
Correct. That's all, my lord. Ultimately, my lord, we will have to satisfy our lordship's conscience because the committee, my lord, did not go into all this. Committee, my lord, I'll point out. That's, my lord, that is why
Well, he admitted that committee did not address
Go
that
into all
particular point, but it referred to the judgment of Justice, Honorable Justice, ಎರಡು judgment ಅನ್ನು refer ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋದು ಅವ್ರ contention.
Then the next.
ಒಂದೇ ನಿಮಿಷ. I'll come to you. Yes.
Then, my lord, the next submission that was made, should I continue? 12 ಗಂಟೆ ಆಯ್ತಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ಕೇಳಿದ್ದು.
ಒಂದು 2 ನಿಮಿಷ.
ಯಾಕೆಂದ್ರೆ ನಿಮ್ಮ ಜಮೇದಾರರಲ್ಲಿ ಬಂದರು, ಹಾಗಾಗಿ ನಾನು ಕೇಳಿದ್ದು. No, I understand.
Small medicines
What happens is, we will be, my lord, ಇಲ್ಲಿ ಮುಗಿಸ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಹೋಗಿ ಕಾಫಿ ಕುಟ್ಕೊಂಡು ಆಮೇಲೆ ಬೇರೆ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ತೇವೆ. ನಿಮಗೆ ಅದು ಇಲ್ಲ. Luxury is not there for your lordships. Please.
ನೋಟ್ ಶೀಟ್ ಓದಿದ್ರಲ್ಲ, ಯಾವ ಪೇಜ್? ಸೀನಿಯರ್ ಓದಿದ್ ನೋಟ್ ಶೀಟ್ ಯಾವ ಪೇಜ್? ನಮ್ಮ ಬಿಡಿಯದ್ದು ಅದಲ್ಲ, ಅಲ್ಲ ಯುಡಿದಲ್ಲ, ಅದಕ್ಕೆ ಮುಂಚೆ ನಮ್ಮ ಬಿಡಿಯದ್ದು ರೆಸಲ್ಯೂಷನ್ ಓದೋದು.
ಸ್ಟಾರ್ಟಿಂಗ್
Page 3.
Page 1, page 2 ಇದೆ written bill
ಅದಾಯ್ತು.
page 3.
ಹಾ, page 3. ಆಮೇಲೆ ಇನ್ನೊಂದು ಯಾವ್ದು ರೆಸಲ್ಯೂಷನ್ ನೋಟ್ ಶೀಟ್ ಅಂತ ಓದಿ.
ನೋಟ್ ಶೀಟ್ ಅಲ್ಲೇ page 40, 41,
41 ಸರ್.
40 and 41.
Yes, sir.
Please. Then, my lord, they have also tried to make it appear as if they have made form the layout. Please come to my lord. Page 53 of the memo filed by the BDA. They have also filed, my lord, some documents.
Memo filed by BDA,
Yes, my lord.
dated
My lord, it is dated. They have not given me the date. One big compilation. my lord.
31 January 25, no?
2024 ಅಂತ ಕೊಟ್ರು ಅದ್ರಲ್ಲಿ ಡೇಟ್ ಗೇಟ್ ನಮಗೆ ಹಾಕಿಲ್ಲ ಹಿಂಗೆ ಕೊಟ್ಬಿಟ್ರು 31 January ಅಂತ ಆಯ್ತು
31 January.
ಪೇಜ್ 53 ಸರ್ ಅನೌಪಚಾರಿಕ ಟಿಪ್ಪಣಿ ಅಂತ ಬರುತ್ತೆ ಸಾರಿ 53ನೇ ಪೇಜ್ ಲುಕ್ ಎಟ್ ದ ಡೇಟ್ my lord 15/12/2012 Please turn the page over, my lord. Ten ಅಂತ ಬರುತ್ತೆ ಸೆಕೆಂಡ್ my lord ಕಾಲಮ್ 10 ಜಮೀನಲ್ಲಿ
ನಿವೇಶನ ರಚಿಸಲಾಗಿದೆಯೇ?
17, 18, 17 / 18, 20, 26, 94ಗಳಲ್ಲಿ ನಿವೇಶನಗಳು ರಚಿಸಲಾಗಿದ್ದು ಎಲ್ಲಾ ನಿವೇಶನಗಳನ್ನು ರೈತರಿಗೆ ಸಾರ್ವಜನಿಕ ಈಗಾಗಲೇ ಹಂಚಿಕೆ ಮಾಡಲಾಗಿರುತ್ತದೆ. ಮತ್ತೆ my lord
ರಚಿಸಿದ್ದೇವೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಹೌದು. Why, my lord, I am pointing this out is there is an embargo on your my lord passed by your lordship's court that till my lord entire thing is over, my lord, you will not do anything. How could they have, my lord, done this at all? And my lord, if your lordship recollects, their other endorsement says it's all Kali. Even now, my lord, they are saying that they have already formed layout.
Where was the embargo?
My lord, the order passed by this honorable court, my lord, division bench,
Saying that
specifically says, my lord, you will not do anything till, my lord, the entire process is over. And
ಅದ್ಯಾವುದು ತೋರಿಸಿ.
please come to, my lord, the division bench order. Judgment ಅಲ್ಲಿ
ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಂತ
ಅಲ್ಲ ಅವರೇ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ
ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅವ್ರು ಕೊಟ್ಟು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಡಿವಿಷನ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್.
ಡಿವಿಷನ್ ಬೆಂಚ್
ಬಂಡು ರಾಮಸ್ವಾಮಿ.
ಕರೆಕ್ಟ್.
ಬಡಿ ಅಲ್ಲೊಂದು ನೋಡೋಣ. ಬಂಡು ರಾಮಸ್ವಾಮಿ ಜಡ್ಜ್ಮೆಂಟ್ ಇಸ್ ಸಬ್ಜೆಕ್ಟ್. ಅದೇ ಇರ್ಬೋದು ಕೊಡಿ.
91
ಇದೇ ಜಡ್ಜ್ಮೆಂಟ್.
ಅದರಲ್ಲಿ ಪೇಜ್ 288 ಬನ್ನಿ ಸ್ವಾಮಿ. ಇದು ಇಟ್ ಸ್ಟಾರ್ಟ್ಸ್ ಅಟ್ 178, 178 ಶುರುವಾಗುತ್ತೆ, 288 ಬನ್ನಿ ಸ್ವಾಮಿ. No, where do you get that? Till it is done, you will not do anything. Not that one. 95 ಬನ್ನಿ ಸ್ವಾಮಿ. 292 ಬನ್ನಿ. However, in WP number so that's our petition. Material and record is not sufficient to grant relief sought for. Firstly, petitioners are only agreement holder, though there is an award in their favor. Same is challenge so and so. Next page ಬನ್ನಿ ಸ್ವಾಮಿ. ಅಲ್ಲ ಇದರಲ್ಲೇ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಬನ್ನಿ. Under these circumstances, proper course would be to direct the petitioners to approve the BDA with an application setting out their claim. BDA shall decide the claim. Last 4 lines, my lord, 6 lines.
After these circumstances.
Correct. Under these circumstances, the proper course would be to direct the petitioners to approve BDA with an application setting out their claim, and the BDA shall decide that claim on its merits. In the light of what we have said, if the BDA were to uphold the claim of the petitioner, then the lands covered in this writ petition would stand excluded from acquisition. If the claim is negatived, as the landowners have no objection for acquisition of land stands affirmed, BDA would be at liberty to form the layout. Till such adjudication, BDA shall stay its hands. Then Justice Mohan Shantan Gowda's order also, my lord, says you will not do anything. Sorry. Justice Mohan Shantan Gowda's order, my lord, which I read in the morning, ಅದರಲ್ಲೂ ಹೇಳ್ತಾರೆ.
2006 order.
Correct. In the compilation, my lord, our compilation, that small one we had given to your lordships, page 45 ಅಲ್ಲಿ. That short compilation, my lord, I'm sorry.
No,
We
no
have to
problem.
give, I think,
No
you know,
problem.
we'll have to give you some written submissions ಕೊಡಬೇಕಾಗುತ್ತೆ. ಎಲ್ಲಾ ಕಡೆ ನಿಮ್ಮಲ್ಲಿ ಅಲ್ಲಿಂದ ಇಲ್ಲಿಂದ ಎಲ್ಲ
ಇಲ್ಲ ಒಂದು ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಕೊಡ್ಬೇಕಾಗ್ತದೆ.
ಮಾಡ್ಕೊಡ್ತೀವಿ. ಪೇಜ್ ನಂಬರ್ ಯಾವ ಇದರಲ್ಲಿ ಎಲ್ಲಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. ಇದರಲ್ಲಿ ಪೇಜ್ 49 ಬನ್ನಿ ಸ್ವಾಮಿ. 45 ಅಲ್ಲಿ, as your lordship saw, my lord, it starts 49. Last ಅಲ್ಲಿ para 4. Sorry.
Para 4.
ಹೌದು, page 48, para 4. Concerned land acquisition officer, Bangalore Development Authority shall hold spot inspection after notice the petitioners thereafter proceed in accordance with law. Petitioners as well as the Bangalore Development Authority are directed to maintain status quo with regard to the properties in question during such consideration. No fresh construction shall be made, etc.
But ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಇಲ್ಲ ಇದು.
My lord, my lord, my submission to your lordship sees, ultimately, my lord, we were also, my lord, similar, and therefore, my lord, they conducted an inspection of our land also. And that is what, my lord, your lordship saw. Page 141 ಅಲ್ಲಿ, ನಮ್ಮ writ petition 141, if your lordship sees. ಬಂದೆ. Writ petition ಅಲ್ಲಿ ಅದೇ ಪ್ರತಿಯೊಂದಕ್ಕೊಂದು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ರಲ್ಲ ನಿಮ್ಮ ಕೈ, ಅದರಲ್ಲಿ ದೇ ರೆಫರ್ ಟು ದಟ್ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಆಫ್ ಜಸ್ಟಿಸ್ ಮೋಹನ್ ಶಾಂತನ್ ಗೌಡ 141 ಬನ್ನಿ ಸ್ವಾಮಿ.
ಅದನ್ನು ರೆಫರ್ ಮಾಡಿದಾರ?
ಹೌದು.
WP 9232 of 2006.
Correct. ಎಲ್ಲಾದ್ರೊಳಗೂ 141, 145, 147 ಎಲ್ಲಾದ್ರೊಳಗೂ ದೇ ರೆಫರ್ ಟು ದಟ್ ಆರ್ಡರ್.
ಇದು ಶಾಂತನಗೌಡ ಸಾಹೇಬ್ರದ್ದ?
ಎಸ್ ಮೇಡಮ್.
ಎಷ್ಟು ಒಳ್ಳೆ ಜಡ್ಜ್ ಪಾಪ, ಬೇಗನೆ ಮುಗಿದ.
ಅಬ್ಸಲ್ಯೂಟ್ಲಿ. ಅವರು ಮೇಲ್ ಕೂತಾಗ ಯಾರು ಬಂದ್ರು ಅಂಡ್ ಎನಿ ಸಬ್ಜೆಕ್ಟ್ he would not take it up. Nothing was
taxation
anathema to him.
And the royal personality in all his
very sad
speech, conduct, very royal. ಯಾವುದು ಕ್ಷುದ್ರತನೇ ಇರ್ತಿರ್ಲಿಲ್ಲ.
Then, my lord, the next submission that has been made by the council is division bench order only, my lord, entitles, my lord, the petitioner, Tata Housing, to, my lord, they are not concerned with the 6 parameters or barade illa ant heli. This is one new argument that has been canvassed. My submission to your lordship is, please look at the order. It says, my lord, all petitioners, my lord, all petitioners
includes your client also.
Absolutely. And that's why, my lord, all this, my lord, process was done, examined.
But ಆ petitions ನಲ್ಲಿ ನೀವು petitioners respondents ಅಲ್ಲಿ ಇರುವಂತ petition ದಲ್ಲಿ all petitioners
ಅಲ್ಲ, all petitioners ಅಲ್ಲಿ ನಾವು petitioners ಏನೆ, in the sense Tata is, my lord, our power of attorney holder. So virtually, my lord, they represent us. In fact, if your lordship, my lord, take that compilation, big compilation of judgment given by the BDA, please take that. I'll tell your lordship why. Adaralli, please come to, my lord, Justice Gopal Gowda judgment to page 39 ಅಲ್ಲಿ ಬರುತ್ತೆ ಸ್ವಾಮಿ. Page 39 ಅಲ್ಲಿ
Right.
ಪ್ಯಾರಾ 3 ಅಂತ ಬರುತ್ತೆ ನೋಡಿ, ಅದರೊಳಗೆ
WP 25807 of 2004.
ಕರೆಕ್ಟ್ ಅದರಲ್ಲಿ ನಾನು 5 ಲೈನ್ ಕೆಳಗಡೆ ಬನ್ನಿ.
Petitioner is Tata Development
Correct.
Corporation.
It is stated, 5 ಲೈನ್ ಕೆಳಗಡೆ,
It is
stated that the petitioner obtained power of attorney from the owners. They are our, my lord, they represent us. It's as if, my lord, we are there.
petitioners.
Correct. Then, please come to, my lord, the division bench order. They also refer to, my lord, the fact that there is a power of attorney given by us. 91 ಬನ್ನಿ ಸ್ವಾಮಿ, ಡಿವಿಷನ್ ಬೆಂಚ್ ಇದ್ದು ಪೇಜ್ 288 ಬನ್ನಿ ಸ್ವಾಮಿ.
Ah,
10 line from the top, my lord. The owners have executed a power of attorney in their favor. Same, my lord, that
owners have executed
power of attorney in their favor.
in
That is, my lord, the Tata Housing. So, and now come to, my lord, the order. All petitioners anta barutte. Please come to page 302.
302.
302. That is, my lord, paragraph 100 and, my lord, 5 D, 106 D1.
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 All
All
the
petitioners who are landowners,
landowners.
who are seeking dropping of acquisition proceedings insofar as their respective lands are concerned, F, their lands are similarly situated, which are adjoining their lands but not notified for acquisition at all, are permitted to make appropriate applications, so on and so forth. All petitioners would include, my lord, us also. In addition, my lord, paragraph 2 at page 304.
Writ appeal number is partly allowed. WPN filed by Tata
Correct.
Housing Company.
Because there was one observation, my lord, by the learned single judge. Therefore, my lord, this petition they had to file, my lord, to exclude that observation of the learned single judge. So, my lord, while allowing it, my lord, they said this also will be taken into account. My submission is all, my lord, petitioners are entitled, would include, my lord, us also. This is the submission. And then,
For the landowner.
correct. Not only that,
And Tata Housing was fighting the battle on your
my behalf.
because as a GPA holder.
Correct.
Notwithstanding, there is some dispute between you and Tata.
That's a different thing, my lord. But they have not come, my lord. They are not the owners. Ultimately, my lord.
You were the owner.
Yes.
Therefore, all the petitioners who are the landowners.
Owners are entitled to, my lord, this relief. Therefore, my lord, that is why, my lord, BDM, my lord, goes into it. The land acquisition officer, my lord, examines the whole thing, comes there, finds that, my lord, the neighboring properties are not acquired. Therefore, says this has to be excluded. My lord, accepted by the board of the BDA itself, accepted, my lord, by the government, accepted by the chief minister.
Yes. Yes, sir.
Then, my lord, the commissioners.
ಒಂದು ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಅಂತ ಹಾಕಿ.
ಮಾಡ್ತೀನಿ, ಖಂಡಿತ ಮೇಡಮ್. I must assist
ಸ್ವಲ್ಪ
because
very
ಇದು
complex ಆಗಿದೆ.
ನಾವು
ನೀವು ಒಂದು ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಹಾಕ್ಬೇಕು. ನೀವೇನಾದ್ರು ಹೇಳಿಕ್ಕೆ ಇದೆಯಾ ನಿಮ್ದೇನಾದ್ರು ಹೊಳ್ರೆ ಮುಗಿತಾ ಇದೆಯಾ ನಿಮ್ದು?
ಅಷ್ಟೇ ಅಲ್ಲ ಸ್ವಾಮಿ,
ಇಷ್ಟೇ.
ನಾವು ಹೇಳಿದ್ರೆ ಇನ್ನು ಮುಗಿಯೋದ ಕತೆ ನಾವು ಹೇಳ್ತಾನೆ ಇರ್ತೇವೆ. ಅದಕ್ಕೆ ನಾನು ತಮಗೊಂದ್ಸಲ ಹಿಂದೆ ಹೇಳಿದ್ದೆ ಅಂತ ಕಾಣುತ್ತೆ. ಜಸ್ಟಿಸ್ ಬಾಲಕೃಷ್ಣ ಅವರು ರಿಟೈರ್ ಆದ ಕೇಳಿದ್ರು, ಯಾಕೆ ಇಷ್ಟೆಲ್ಲ ಡಿಲೇಸ್ ಇನ್ ಕೋರ್ಟ್ ಅಂತ. ಬಿಕಾಸ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ವಿಲ್ ಕೀಪ್ ಆನ್ ಆರ್ಗ್ಯೂಯಿಂಗ್ ಟಿಲ್ ದ ಕೌಸ್ ಕಮ್ ಹೋಮ್ ಅಂತ ಹೇಳಿ. ಹಾಗೆ ನಾವು ನಮಗ್ ಬಿಟ್ರೆ ಏನು ಹೊಡಿತಾನೆ ಇರ್ತೀವಿ ನಾವು ಲೆಕ್ಚರ್.
I understand there's no reply to reply.
ಹಾ. if you want to say something, you file your, ನಿಮ್ದೊಂದು ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಹಾಕಿ
ಆಯ್ತು.
ಅವ್ರದ್ದು ಇಬ್ರು ಎಕ್ಸ್ಚೇಂಜ್ ಮಾಡಿ
ಆಗ್ಬೇಕು, ಖಂಡಿತ.
ಎಕ್ಸ್ಚೇಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಮಾಡ್ಕೊಂಡು ನಂತರ ನಿಮ್ಮ ವ್ಯೂಸ್ ಏನಾದ್ರು ಅಲ್ಲೇ ಮಾತ್ರ ಅಲ್ಟರ್ ಮಾಡ್ಕೊಳ್ಳಿಕ್ ಬಂದ್ರೆ ಅಲ್ಟರ್ ಮಾಡಿ ಆಮೇಲೆ ಇಬ್ರು ಕೊಟ್ರೆ
ಆಯ್ತು.
ದಟ್ ಬಿಕಮ್ಸ್ ಈಜಿ. 2 minutes.
2 to 3 minutes with regard to only a clarification, which
ಹೊಲ್ರಿಗೆ ಬೇರೆ ಕೋರ್ಟಿಗೆ ಬಿಡ್ತೀರಾ ಅವ್ರನ್ನ ಬಟ್ ಒನ್ ಥಿಂಗ್ ಇದೆ, ಅಲ್ಲಿ ಟಾಟಾಸ್ ಫಾಟ್ ದ ಲೀಗಲ್ ಬ್ಯಾಟಲ್ ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಓನರ್ಸ್ ಇದೆಲ್ಲ ಅಂತ ಹೇಳಿಕ್ಕಾಗಲ್ಲ, ಬಿಕಾಸ್ ದೇ ವರ್ ಓನ್ಲಿ GPA ಹೋಲ್ಡರ್ಸ್.
ಆಮೇಲೆ ಇನ್ನೊಂದಿದೆ ಸ್ವಾಮಿ, ನಾನೊಂದು ಹೇಳೋದು ಮರೆಸ್ಬಿಟ್ಟೆ. ಇವರು ಲ್ಯಾಂಡ್ ಓನರ್ಸ್ ನಮ್ಗೆ ಬೇಡ ಅಂತ ಹೇಳಿದಂತ, ಅದು ನಾವಲ್ಲ ಹೇಳಿದ್ದು. There was, my lord, a lady who, my lord, was claiming that she is the wife of, my lord, my husband. Matter was fought right up to the Supreme Court. It was found that she is not my lord, the wife of my husband. That lady had given one letter. So adannu hitkondu idu madidare. But at any rate, my lord, that has no relevance, because BDA itself, my lord, passed resolutions saying delete this land. Therefore, my lord, adu yakandre ivaru ondsala illa argument ಮಾಡುವಾಗ ಅವರು ಒಂದು ಒಪ್ಪಿದ್ದಾರೆ ಅಂತ ಒಂದು ಹೇಳಿದ್ರು. ಅದನ್ನ ನಾನು strictly, my lord, it has
ನಿಮ್ಮ ಒಪ್ಪಿಗೆ ಆಗಲ್ಲ,
ನಮ್ಮ ಒಪ್ಪಿಗೆ ಅಲ್ಲ.
contention.
That's
ಆ ಲೇಡಿ ಯಾರು?
ಅವರು, she is an interloper. She, my lord, claimed that she was the wife of my husband, second wife ಅಂತ ಹೇಳಿ. ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ತನಕ ಹೋಗಿ ಅವರು ವೈಫ್ ಅಲ್ಲ ಅಂತಾನೆ ಆಗಿದೆ. ಅದ್ ನಾನು ಇದೆಲ್ಲ ಹಾಕ್ಬೇಕು ಅಂದ್ರೆ ಹಾಕ್ತೀನಿ. ತಾವು ಹಾಕಿದ್ದೀರಾ?
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹಾಕಿದ್ರ?
what they call as an interloper. For her letter also,
I
felt both. Kindly refer to
What was her status? How she was concerned with this land?
we are not concerned with what he has said. What we are concerned only with what petitioners have said. Page 45 of my
Which yesterday you read,
memo.
day before yesterday.
45. These are the 3 petitioners. And 42 only what they claim, Geeta Sahadevji, whom they call as an interloper, but her letter also has place. I have said, and it is not that much.
No.
It is not that submission, that she participated in proceedings before the Honorable Division Bench. No, they'll have to accept the fact that they themselves participated before the Division Bench and said this, that we don't have an objection for that. But that is now, Lord, to come and say, I did not participate before the Honorable Division Bench, when they were specifically made as a party to the response.
ಅಲ್ಲ, ಎರಡು ಆಸ್ಪೆಕ್ಟ್ ಇದೆ.
Then, my lord, how did the division bench, my lord, say that, yes, consider their application and then do it? Please look at it. Therefore,
ಕಾಂಪ್ರಿಹೆನ್ಸಿವ್ ಆಗಿ ನೋಡುತ್ತೆ.
The case of Tata Housing was dealt on the issue of promissory estoppel.
No, Tata Housing was not the owner of the property at all.
That's why I produced those documents also to show that the Tata Housing, the transaction between the Tata Housing and the petitioner is nothing but a sale that has been accepted by them, not by
But
me.
a
I'm
sale-
not saying.
No, can there be sale without conveyance?
Lord may kindly see that. That is what are the findings of some of the court, the authorities and the court. Yes, Lord may kindly see this KT order. Karnataka Administrative
ಯಾವ್ದ್ರಿ
Tribunal's
ಅದು?
order is that. Lord may kindly refer to my
Administrative tribunals,
Appellate
Appellate tribunals.
tribunal.
ಯಾವ ಆರ್ಡರ್?
But,
ಅಲ್ಲ, how can there be, because Sanjeev Rao, just I was reading to give a lecture on that law relating to registration. I was referring to Mullah's Registration Act and Professor Sanjeev Rao's Registration Act. There are 2 sentences, one in one paragraph, and in other book there is another paragraph. They said, by consent, there cannot be conveyance. For conveyance, there has to be a written document, duly stamped and registered also. By just 2 persons coming to court and saying that he is the owner, I am the seller, he is the buyer, he has bought the property, I have sold the property, I have received the money, would not amount to conveyance. ಅಂತ 2 paragraph ನಲ್ಲಿದೆ. They have given ಒಂದು ಕರಾಚಿದು, ನಂತರ ಕೇರಳದ್ದು, ಇದ್ರದ್ದು ಒಂದು 2-3 ಜಡ್ಜ್ಮೆಂಟ್ ಸೈಟ್ ಮಾಡಿದ್ದಾರೆ.
It's not only an agreement to sell. It was not only a power of attorney. It was not only an affidavit. All these 3 coupled with a joint development agreement wherein the possession of the property was handed over with the permission to sell the so-called sites or the properties formed on it with the authority to sell them, was considered by the KD. They themselves go and say, this amounts to a sale of this property. That is why he invoked 79A and B. That is what I'm trying to-
Ultimately, what happened to 79AB?
Can you permit me to read?
Just answer that question. We have read every page. ಯಾಕಂದ್ರೆ ಎಷ್ಟು ಸರಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿರಿ ನೀವು.
ಇದನ್ನ ತೋರಿಸ್ತೀನಿ.
Just, ಹಾ.
ಇದನ್ನ ಅವರು ನಾನು
ಹೇಳಿ,
ತೋರಿಸ್ತೀನಿ.
ಹೇಳಿ.
ಅದ್ರಲ್ಲಿ ಏನಾಯ್ತು? What?
We are asking a question now.
Yes.
What happened to those forfeiture proceedings? 79AB at they then were. Though now it pales into insignificance because with retrospective effect ಅಂತ hold ಮಾಡಿದ್ವಿ. Now, how that is going to alter the position? If it is with retrospective effect, it will be answered that way here also. Because that is taken out from the statute book itself, from the first day of passing of the bill.
2000 till 2021, the order passed by the Karnataka Appellate Tribunal was in existence.
Correct.
But after that, this honorable court's order, but what it has said is, it has not said, but may permit me to read the order passed by this honorable court in the very same matter where they challenge the 79A and B. But what happened? During the pendency of the present writ petition, the state government has issued an ordinance so and so. However, in terms of the aforesaid ordinance.
That's abolishing those two
Yes.
sections, deleting those two sections.
Yes.
Then it became a statute, act also.
In view of the amendment or the order passed by the Assistant Commissioner and the Karnataka.
They go.
With status.
Correct.
Yes. But what fact is, they want to come and contend here that in 2003 and 4 and 2005, before the single judge and division bench, I was represented through my power of attorney holder, may not be correct.
But the court itself has said
No,
that.
the writ petition speaks about it. I produced a copy of the writ petition filed by Tata Housing.
We'll assume now.
Yes,
But court itself has said that.
yes,
The division bench has said that.
Yes.
Even then, we should discredit the division bench observation.
Where have they
disputed? Even though he is conceding for the.
Where have they disputed it,
petitioner
BD?
here, who was the respondent in the appeal as well as the petitioner, as well as in the petition. Even though he is conceding for the acquisition, I will not give credence to his submissions. I'll give credence to the promise made by the state government insofar as Tata Housing is concerned.
Correct.
Not the credence to their submission of acquiescing to acquisition.
No, brother.
They are on a loggerheads. One wanted property to be retained, who's his agent. Now the principal is coming, I will step into the shoes of an agent. No, not my respectful submission is, the agent steps into the shoes of the principal. But now here is, principal wants to step into the shoes of agent.
They never challenged, my lord, before the learned single judge division bench, they did not say that, they are not the power of attorney, they are the owners of the property.
Sorry, two
New.
more submissions with regard to those resolutions. My learned senior had read these portions of the note sheet.
Government's note sheet.
Yes, bro. Government note. These three resolutions senior has read, learned senior has. All the three resolutions I have produced. My learned senior has also read this 2014 resolution showing the serial number 12. Lordship may kindly refer to the very same resolution. Whether has it been given effect to? No. In the whether same resolution, the last fourth page, tadediyalagide. That is not
Sir,
concluded.
did you write to the government? One thing we wanted to ascertain.
Yes.
Did you write to the Honorable Chief Minister saying that,
No.
Honorable Chief Minister, you are misled? It is not like that. There is no such
But there
resolution.
is no such.
We have not, even if there is such one, there is one. This resolution will not include the land of the petitioners herein.
Now, Bharati.
Therefore, kindly reconsider your note sheet because you are head of the executive. So your signature will have lot of repercussions. Did you seek any clarification? Did you not to Chief Minister? You could have sent it to the secretary to the Chief Minister
No.
or department secretary saying, ನೀವೆಲ್ಲ ಹಿಂಗ್ ಮಾಡ್ಕೊಂಡ್ರಿ ಬಟ್ ಆ ರೀತಿ ಇಲ್ಲ ಅದು
Yes.
ಇದರಲ್ಲಿ ಹಿಂಗಾಗಿದೆ ಅದು ಅಂತ ಅನ್ಕೊಂಡು ನೀವು ಒಂದ್ ಮಾತು ತಿಳಿಸೋದು ಬೇಡವಾ ಅವರಿಗೆ? ಅದರ್ವೈಸ್ ಹೌ ಚೀಫ್ ಮಿನಿಸ್ಟರ್ 1000 ಕೆಲಸ ಇರ್ತದೆ.
Correct.
ಎಲ್ಲ ಓದ್ಕೊಂಡು ಮಾಡಕ್ಕೆ
ಇಲ್ಲ.
humanly impossible.
Chief
He
Minister,
has to depend upon his officer.
correct, please.
Correcta?
Chief Minister has not dealt into a particular file or a particular recommendation for deletion. ಇಲ್ಲ ಎಲ್ಲಾನು 983 ಒಂದೇ ಸಲ ಒಂದು ಇದನ್ನ ಮಾಡಿದ್ದನ್ನ Chief Minister has accepted, not a single, never, not even a single file was put. Yes. ನಾವು ಮಾಡಿ-
Assumption ಏನು?
It is looked into and taken a decision.
Because
We keep credence to his.
ಎಲ್ಲ ಚೀಫ್ ಮಿನಿಸ್ಟರ್ ಅಷ್ಟು ಓದ್ಕೊತ್ ಕುತ್ಕೊಳಂಗಿದ್ರೆ ಐದು ಕೆಲಸ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ.
But we give,
ಸಾವಿರ ಗಟ್ಟಲೆ ಕೆಲಸ ಇರ್ತದೆ ಅವರಿಗೆ.
we should give,
We understand that.
we should give.
So ಅದಕ್ಕೆ ನೀವು at least you should have said, we are putting this question, we'll treat that also is another thing.
Yes.
Saying that, can we assume Honorable Chief Minister has not seen the papers at all?
No,
He,
no,
somebody will
I cannot,
see, somebody will brief him. Sir, it is like this, sir. Everything, ಅಷ್ಟೆಲ್ಲ ಟೈಮ್ ಇರಲ್ಲ ಅವರಿಗೆ.
ಇಲ್ಲ ಅದನ್ನ ನಾವು
ಅಬ್ಸಲ್ಯೂಟ್ಲಿ ಟೈಮ್ ಇರಲ್ಲ ಅವರಿಗೆ. ನಮಗೆ ಸಾಧ್ಯ ಆಗ್ತದೆ. ಹಾ.
Not to inform him.
no, it was. No, it was not sent by the board.
There is a.
ಎನಿವೆ ನಿಮ್ಗೆ ಗೊತ್ತಾಯ್ತಾ?
ನಾವು ಅದನ್ನ ಏನು ಮಾಡಿಲ್ಲ ಅನ್ನೋದು. ಇಲ್ಲ ನಾವು 983 ಎಕರೆದನ್ನು we have accepted the deletion and a modified
1066 was arrived at.
1766 was,
Arrived at.
yes,
1766 was
arrived at.
arrived at.
Yes, ma'am. That is the modified scheme of Arkavati layout. That is in 2014 notified. That we have not disputed. But the learned single judge of this court finds specific fault with such things. That is why it was all sent to, and one more, learned senior read one portion of 79/2013 ಅದು ಒಂದು ಪ್ರತ್ಯಾಯೋಜಿಸಲು ನಿರ್ಧರಿಸಲಾಯಿತು ಅಂತ ತಾವು ಸೀನಿಯರ್
Commissioner-ನ.
ಕಮಿಷನರ್ಗೆ ಪವರ್ಸ್ ಕೊಟ್ರು. No, that is not a power which was given to the commissioner to delete the lands. No, Lord, may I read that sentence of it so that I can point out after deletion what is left out in 1766 ಅಲ್ಲಿ ನೀವೇನು
ಅದಕ್ಕೆ ಸಂಬಂಧಪಡುವ
ಅದಕ್ಕೆ
ನಿರ್ಣಯಗಳನ್ನು ತೆಗೆದುಕೊಳ್ಳಲಿಕ್ಕೆ
ಪರಿಷ್ಕೃತದಲ್ಲಿ ನೀವು ಹೆಂಗೆ ಕೆಲಸ ಮಾಡಬೇಕು, ಸೈಟ್ ಇಲ್ಲಿ ಮಾಡಬೇಕು, ಸಿವಿಕ್ ಕಮ್ಯುನಿಟಿ ಮಾಡಬೇಕು ಅನ್ನೋದನ್ನ ಡಿಸೈಡ್ ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ ಕಮಿಷನರಿಗೆ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟರು. ಮೈ ರೆಸ್ಪೆಕ್ಟ್ಫುಲ್ ಸಬ್ಮಿಷನ್. ಟೇಕಿಂಗ್ ಅನ್ ದಟ್ಸ್ ವೈ ದ ಲರ್ನೆಡ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಯೂಸ್ taking an advantage and umbrage under the order passed by the division bench of this honorable court. The honorable learned Justice Arvind Kumar has observed. That is why I read that on that day. Umbrage under the order passed by the honorable division bench and the Supreme Court of it.
at least ಆ single judge, learned single judge ಗೆ,
Please.
as honorable the judge then was.
Please.
Whether you notified to him, the honorable chief minister has seen all these things.
Yes, it is seen by the honored the learned single judge.
ಎಲ್ಲೂ chief minister ಅನ್ನೋ ಪದ
Chief
ಬಂದಿಲ್ಲ.
Minister, government ಅನ್ನೋ ಪದ.
Government ಅನ್ನೋ ಪದ ಬಂದಿದೆ.
Government ಅನ್ನೋ ಪದ.
But at least government ಅಂದ್ರೂ ಸಹಿತ correct. But when honorable chief minister takes a decision as head of the government, now we are all coordinate branches of the state.
Yes.
We have to respect we may agree, we are not super governments. Governmental process ನಲ್ಲಿ ಏನೇನಾಗ್ತದೆ, because Supreme Court said, honorable Supreme, the theory of separation of powers of Montesquieu, we have largely adopted that.
Yes.
And one of the, which Dicey says, referring to Montesquieu, one of the features of this is every branch of the government, now every branch of the state, because of Ram Javaya.
Yes.
Every branch of the state shall respect the decisions of the coordinate branches. The Thomas Cooley American Constitutional Law, Lala Nodi, especially page 179. Sorry, just note what he has said, Thomas Cooley. Court is not a super body. It does what is assigned to it. Very beautiful here. If people are unhappy with the decision of the government, it is not the business of the court to make them happy. Court should see whether the decision is in accordance with law or not.
Yes.
Court should not act that it is sitting in appeal over the governmental decisions.
Yes.
If people are unhappy, their remedy lies in appealing to the legislature through election process. Very beautifully he has quoted that.
Yes.
Thomas M. Cooley, one of the greatest experts. This was more than 100 years back. He wrote it on a constitutional American Constitution. Just you see that paragraph. We have quoted it in some judgments. I have quoted them. This- we may be unhappy with the decisions of the coordinate benches. The unhappiness is not a ground. A spouse may be, a person may be unhappy with his spouse, but that is no ground to deny spousal relationship that way. No, we are only discussing. We have not yet formed any opinion. But that's one of the best books one should read. Thomas M. Cooley, which Apex Court considered in case one on the, it is referred. Thomas Cooley is referred. George is referred. Just look it. Please. Great. Thank you.
My respectful submission to this is what has been done by the BDA, state government, and the other deletions, Lord, were not in consonance with the order passed by the Bandu
Court.
Ramaswamy case. That is why the learned single judge, Justice Arvind Kumar, refers entire thing to be done by the committee, including this 982 acres, which was deleted by virtue of the recommendations approved by the government, signed by the Honorable Chief Minister.
ಅದನ್ನ ಹೇಳಿಲ್ಲ ಅವ್ರು.
ಇಲ್ಲ.
Government ಅಂತ
Government
ಕೈ ಬಿಟ್ಬಿಟ್ರು.
980.
ಇದು ನಿಮ್ಮ ಹೊಡೆಸಿದ್ದು. ಹಿಂಗಂತ. But government means ಅದೇ same, because we held in Sudhindra Rao's case, we held that the government chief minister includes the government ಅಂತ hold ಮಾಡಿದ್ವಿ ನಾವು. Referring to one.
If the other side's argument of, since the BDA had passed this resolution, there was a report. And in view of that, the committee could not have taken this exercise of identifying whether I fall within the Bandu Ramaswamy's case or not is to be accepted. Then, Lord, there is entire 982 acres which has been referred by the learned single judge to the committee, which was also on the basis of some of the recommendations, orders, and the decisions of the board and the state deletion by the state government. Lord, would not survive for consideration. Then I'll
set aside ಮಾಡ್ಬೇಕು ಅಂತೀರಾ?
ಅಲ್ಲ ಈ ಆರ್ಡರ್ ಸೆಟ್ ಅಸೈಡ್ ಆಗ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ
ಆಯ್ತು ಅಂದ್ರೆ
ಈ ಆರ್ಡರ್
just we want to know the consequences.
982 acres would stand excluded. They deemed to be deleted.
If we say, suppose we're just exploring how to minimize the disastrous consequences.
Yes.
When citizen comes to court and says my right to property is violated in the light of all this, etc., then we have to consider, at the most we may confine it to the petitioners.
But in all the 900.
Unless you say, if you allow the petition, this appeal, the petition, then give relief to others who are not before the court ಅಂತ ನೀವು ಹೇಳಂಗಿದ್ರೆ ಅದನ್ನು ಸಹಿತ ನಾವು ಮಾಡ್ಲಿಕ್ಕಾಗ್ತದೆ. But as long as petitioners are here, others have not come.
No, I'm not saying that way. If their argument has to be accepted, that there are recommendations, there are some reference to in my note sheets. And under such circumstances, the order passed by the committee, finding that my land, deletion of my land was not in consonance with the Bandu Ramaswamy's case, has to be set aside only on that ground. If that has to be accepted, then there is, for 982 acres also, it is virtually goes out of consideration before the committee, is my respectful submission. Because everyone has such a recommendations. And now what they want to take an umbrage under the, order of the Justice Shantanu Gowda in the second time. But it will follow the same thing. 982 acres will go out of consideration. Then the entire exercise, what the learned single judge took to see whether these are all under the Bandu Ramaswamy's case, will have no consequence. Yes,
we unsettle that nim contention.
Yes.
That cannot be done.
that cannot.
My lord, my
They
reply.
may have a case of saying that I fall within the Bandu Ramaswamy's case. They must establish that I fall within Bandu Ramaswamy's case. Only then they have a relief. Unless until this order of the learned single judge, Justice Arvind Kumar's order is set aside by a.
That binds, because
Yes.
it's very based on norms.
Yes. And they say, they never go before the committee saying that I don't fall within the order passed by the Justice Arvind Kumar. No, they say my deletion is as per the Bandu Ramaswamy's case.
Justice Arvind Kumar also says, follow Bandu Ramaswamy only.
Yes, my lord. But what you have done is 982 is not virtually in consonance with Bandu Ramaswamy's case. That is why it says certification by the committee. All deletions are
ಒಂದು
subject to
ಶಾರ್ಟ್
certification.
ಒಂದು ಶಾರ್ಟ್ written submission.
My lord, by way of a reply, because ultimately, my lord, it's the petitioner who has to reply. Anyway, my lord, now we have reached the stage where, my lord, respondents, my lord, want to have the last say. Doesn't matter. Please look at it, my lord. My learned friend contention is KT, my lord, judgment, overrules, my lord, division bench judgment, Supreme Court judgment, single judge's judgment, everything. That, my lord, would be anathema to, my lord, rule of law. KT judgment cannot overrule, my lord, all these. One. Second, we always create, my lord, a ghost. Mother, when, my lord, the child doesn't, my lord, drink milk, she creates a ghost. So, my lord, this 959 bogey is created. Your lordships have, my lord, looked into, my lord, each document. Your lordships have looked into, my lord, each, my lord, note sheet of the BDA. BDA cannot, my lord, go back on its own note sheet. In the light of all this, my lord, question is whether, my lord, they fall within the parameters of Bandu Ramaswamy. Answer is yes. Therefore, to say, oh, if you allow this, all the 952 will go, my lord, is not so. Because we have, that's why, my lord, we place before your lords as a note sheet of the BDA itself. We have produced, my lord, the documents, my lord, which clearly indicate that we fall within the parameters of Bandu Ramaswamy and, my lord, Supreme Court judgment. Therefore, my lord, all this bogey, oh, within allow 952 hogutte. With the greatest respect, my lord, that's not so. That's all, my lord. Great.
Heard, result. ಟೈಮ್ ಕೊಡ್ಬೇಕು ಇದನ್ನೆಲ್ಲ ನಮ್ಗೆ ಬರೀಲಿಕ್ಕೆ.
Naturally, my lord.
ಇಲ್ಲ ಯಾಕಂದ್ರೆ ಬೇರೆ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಇದೆ.
ಅದು ಮಾತ್ರ ಅಲ್ಲ, ನಾವು ಇಲ್ಲೆಲ್ಲ ಮಾಡಿ ಅಲ್ಲಿ ಹೋಗಿ ನಾವು ಕಾಫಿ ಕುಡಿದು ಬರ್ತೀವಿ. ನಿಮ್ ತಲೆ ಮೇಲೆ ಹೇಗೆ ಮೇಲೆ ಬರ ಹಾಕ್ತೀವಿ.
Lakshmi, grant me time till Monday to file a.
ಒಂದು ವಾರದಲ್ಲಿ ಹಾಕಿ
Please.
ವಿದಿನ್ 1 week ಹಾಕಿ.
Please.
ನೋ ಪ್ರಾಬ್ಲಮ್.
Oblige.
ಇಬ್ರು ಶೇರ್ ಮಾಡ್ಕೊಂಡು ಹಾಕಿ.
ಆಯ್ತು.
ಆಮೇಲೆ ಶೇರ್ ಆದ್ಮೇಲೆ ಸ್ವಲ್ಪ ಏನಾರ ಮತ್ತೆ ಸ್ವಲ್ಪ ಏನೋ ಒಂದ್ ರೀತಿ ಕನ್ಸೆನ್ಸಸ್ ಕೆಲವೊಂದು ಪಾಯಿಂಟ್ ಮೇಲೆ ಟ್ವೀಕ್ ಮಾಡ್ಕೊಂಡಿದ್ರೆ ಮಾಡ್ಕೊಂಡು ಹಾಕಿ. ಥ್ಯಾಂಕ್ ಯು.
Oblige.
ರಿಸಲ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಎಷ್ಟಾದವು? ಇನ್ನೊಂದು ಪೆಂಡಿಂಗ್ ಇದೆ. ಓಕೆ, ಬನ್ನಿ ಚಂದ್ರಶೇಖರ್. ಎಸ್. Yes, sir.
I request your lordship kindly have a look at 371. My lords have seen it several times.
ನೋಡು, ಏನೇನೋ ಒಂದೊಂದ್ಸರಿ ಓದಿದಾಗ ಒಂದೊಂದು ಮೀನಿಂಗ್ ಬರ್ತೀರಿ. ಹಂಗಾಗಿ ಏನ್ there is no prestigiator for reading law. ಬಡಿ. J. ಬೇರೆ ಎಲ್ಲಾ ಪ್ರಾವಿಷನ್ ದಲ್ಲಿ ಇರುವಂತ ಮಿಸ್ಟರ್ ಚಂದ್ರಶೇಖರ್, ಈ ಬೇರೆ ಯಾವುದೇ ಪ್ರಾವಿಷನ್ಸ್ ನಲ್ಲಿ ಇರುವಂತ ನಾನ್ ಅಬ್ಸ್ಟಾಂಟೆ ಕ್ಲಾಸ್ ಇದರಲ್ಲಿ ಇಲ್ಲ. ಇದು ಒಂದು ಆಸ್ಪೆಕ್ಟ್ ನಾವು ಕಣ್ಣು
ಇಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ they say establishment of a separate development board. This is where I would like to bring to the notice of the court, my lord. A, establishment of a separate development board for Hyderabad, Karnataka region with the provisions that a report on the working of the board will be placed each year before the state legislative assembly. This becomes very crucial, my lord, to understand, my lord, the scheme of 371J. And your lordship will kindly see, my lord, clause B, subsection, my lord, sub-article 2B. ಒಂದು ಹೈದರಾಬಾದ್ ಕರ್ನಾಟಕ ಬೋರ್ಡ್ ಆಗ್ಬೇಕು, ಇನ್ನೊಂದು ಆರ್ಡರ್ ಸ್ಪೆಸಿಫೈ ಮಾಡಬೇಕು. ದಟ್ ಈಸ್ identification of the, kindly mark this, my lord, identification of the post or class of post under the state government in any body or organization under the control of the state in In the Hyderabad, kindly mark this, my lord. In the Hyderabad, Karnataka region, they do not speak of the vacancies, my lord, outside Hyderabad, Karnataka region. It is
correct.
confined only to Hyderabad,
Karnataka.
the vacancy that are available. You should identify the vacancies. In respect of those vacancies which have been identified in the Hyderabad, Karnataka region, amongst those vacancies, there has to be a reservation to the extent, my lord, it is stated further.
Posts,
Yes, post,
identification of posts.
Post.
Vacancy ಅಂತ ಹೇಳಿದ್ರೆ ಇದೇ word?
post,
Posts.
whatever the posts are there in Hyderabad, Karnataka region, that will have to be identified. How many assistant commissioners are there? How many tahsildars are there working within the territorial jurisdiction of Hyderabad, Karnataka region?
State and Article 12 entities.
Houdu. Thereafter, reservation of a portion of such posts. Your lordship may kindly mark that also.
Reservation
And reservation of a portion of such posts.
portional, proportion.
Proportion of posts.
Ah.
Proportion of posts. That is left to the discretion of the Lord Governor while preparing the order. For persons who belong to that division by birth or domicile, for the appointment thereto by direct recruitment or by promotion, or in any other manner as may be specified in order. It contemplates that, my lord, the governor will have to make an order, preparing a mechanism how a direct recruitment or a promotion in respect of those posts which are there in the Hyderabad, Karnataka region. Now, my lord, I will bring to the notice of this honorable court.
ಏನಿದ್ರ ಅರ್ಥ? Reservation of a proportion of such posts.
ಅಂದ್ರೆ ಎಲ್ಲ 100% ಬೇಡ. ಇಲ್ಲಿ 75% ತಾವು ನೋಡಿದ್ರಿ. 75% of group A, group B and 80% of group C and D. The entire 100% is not, my lord, earmarked for them.
ಆ ಅರ್ಥದಲ್ಲಿ.
Yes. Now, may I request your lordship kindly see, my lord. The board that has been now constituted, my lord, the 2013 order and the, my lord, the development of Hyderabad establishment of the board is done on the same day, my lord.
And the honorable governor, His Excellency, the governor has established the board.
ಹೌದು.
Page number
174, my lord. This is, this notification is, my lord, of the 6/11/2000.
You are right. Hyderabad, Karnataka Region Development Board Order
Yes.
2013.
Your lordship will kindly see page 12 also, my lord. Just to see the dates, my lord. It's on the same day, my lord, both the notification. Page 12,
Same day.
same day.
That order.
Yes,
Governor's
2013 order.
Yes.
Section, my lord, paragraph 3 deals with, my lord, constitution of the board.
As soon as maybe after the commencement of this order, the state government shall establish the
ಹೌದು,
board.
ಹೌದು.
Called Hyderabad so and so. It
Sec-
is established.
Paragraph 3 and subparagraph 3, my lord.
It is established not by, but under paragraph 3 of this order.
Under this order, the government, my lord, will constitute, my lord, the
The
board.
board. Functions of the board.
My lord, therefore, why I am saying, my lord, There is no question of delegation. He says you constitute like this. It is at the order of the governor.
Correct.
He is not delegating, my lord, his power. He says you do this. Now kindly see, my lord, who are the persons, my lord, in the board? The board shall consist of the following members. Page 175.
Correct.
It consists of in charge minister of the districts, eight members, my lord, of 8 MLAs, 2 members of legislative council, 1 member of the parliament representing part of the whole of Hyderabad. My lord, all elected representatives are there, my lord, in this board. And some bureaucrats are also there, my lord, which constitute the board.
Nominees,
Yaudu,
regional commissioners,
regional commissioner.
secretary to government,
Yes.
secretary to government,
Mayor. In addition to this board, my lord, there is one more council, my lord, advisory council, my lord, is also constituted, my lord, under paragraph 4.
There shall be
Advisory council.
consisting of the following, namely district in charge
Yes.
ministers, revenue, all members of the parliament representing all members of the. all-
Subclass 2 will be important. 4.2.
For two, the advisory council shall submit its annual draft development plan to the board well before so and so in respect of succeeding financial year.
This advisory council, my lord, will submit its report to the board. And the board will create, my lord, a roadmap for development of the area. The functions of advisory council is also specified, my lord.
Board of the functions,
ಅದು ಇದೆ. Paragraph 12.
from time to time.
Consider the recommendation of advisory council made in the annual draft development plan.
Yes. A certain relative levels of development in different sectors in relation to its region on the basis of appropriate indicators as in regard to the levels of development in the state as a whole.
Now, paragraph 25, my lord. ಬಹಳಷ್ಟಿದೆ. Only relevant, my lord, I am bringing to my lord's notice. Notwithstanding anything contained in the order or any other law for the time being in force, if in the opinion of the governor or on the advice of the council of minister, it's expedient in the public interest so to do, it may general or a special order issue such direction to the board as are necessary to carry out the purpose of the order. It shall be the duty of the board to comply with such direction.
ಯಾವ್ದು paragraph ನೀವು ಓದಿದ್ದು?
25, 26. At page 180. I'm sorry, 25 only.
Read it.
Notwithstanding anything contained in the order, order means 2013 order. or any other law for the time being in force. If the opinion of the governor or on the advice of the council of minister, it is expedient in public interest so to do, it may by general or
Who is
special
that? It may, it,
governor.
it,
ಹೌದು.
he may.
He may ಅನ್ಬೇಕಾಗಿತ್ತು, it may ಅಂತ ಹೇಳಿದೆ. It may by general or a special order issue such direction. My lord, it is speaking of only the governor. Such direction to the board as are necessary to do to carry out the purpose of the order. It shall be the duty of the board to comply with such direction. Yes.
Translation ಇದೆ.
Paragraph 28 may I kindly be.
ಅದು ಅವ್ರು ಹೇಳ್ದಂಗೆ ಸಿನ್ಸ್ ಇಟ್ ಅಡ್ರೆಸ್ ಗವರ್ನರ್.
Lord, in so many paragraphs, my lord,
ಬೇಕಾದಷ್ಟು.
one see, ಸಾಕಷ್ಟು ಹಂತವಿದೆ. Governor himself directing himself to do certain acts. ಅವಸರದಲ್ಲಿ ಮಾಡಿದ್ರೆ ಹಿಂಗೆ ಆಗುತ್ತೆ. ಹೌದು.
ಅವಸರ ಮತ್ತು ಅವಧಾನಹೀನತೆ, ಅಪ್ಲಿಕೇಶನ್ ಆಫ್ ಮೈಂಡ್ ಇಲ್ದಂಗಿರೋದು.
ಆಮೇಲೆ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ನೂ ಇಲ್ಲ.
ಯಾವೂ ಇಲ್ಲ.
My lord, it is by, it's an evolution, my lord, in the field of making reservation, my lord, in the state, regional wise. If you go by the, my lord, 371D, the experience the other state had, if at all I want to borrow their experience, my lord, it is totally different.
ಎರಡನ್ನೂ ಪಾರಿಮಟಿರಿಯಾಗಿ ನೋಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
ಬರದೇ ಇಲ್ಲ. ಇದು ಸ್ವಂತ ಬುದ್ಧಿಲಿಂದ ಎಷ್ಟು ಹೇಳ್ಬೇಕು ಅಷ್ಟು ಸದ್ಯಕ್ಕೆ ಹೇಳ್ಯಾರ. ಆಮೇಲಿಂದ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದ್ದಾವೆ. It's a process of evolution, my lord, in the matter of regional reservation.
A bit of experimentation also takes place.
Yes.
ಇದನ್ಯಾಕೆ ಓದ್ತಾ ಇದ್ದೀರಿ ನೀವೀಗ?
My lord, only to show, my lord, that governor himself is not doing alone. It is a coordinate effort by all persons concerned, my lord, in the region. They give advice to the governor. Everything is placed before the governor. Governor will have ultimate last say. And thereafter, my lord, it is not the governor's decision alone. It is again the state legislature, my lord, will take a final call on whatever the roadmap that is prepared. Kindly see, my lord, 28, paragraph 28.
Report, board shall before such a date in such format, such interest as may be prescribed, submit the prescribed report to the state legislature. Prepare every year government by order from time to such, including rules for the proper transaction. Not one of the things I will do.
Now kindly read along with, my lord, 371 subclause A, my lord.
29 to be read along with 371J A.
A. This is strictly in compliance with A. Establishment of a separate development board for Hyderabad, Karnataka region with the provisions that a report on the working of the board will be placed each year before the state legislative assembly. Governor ಒಬ್ಬರದೇ ಜವಾಬ್ದಾರಿ ಅಲ್ಲ.
ಅಲ್ಲ 29
ಹೌದು.
ಬೇರೆ 371A ಬೇರೆ 371(1)A ಬೇರೆ.
ಅಲ್ಲ ಅದರ ಅನುಗುಣ in pursuance of that, my lord, this my lord, the board is constituted prescribing the functions, advisory council.
371 J report to be laid before the legislature. It is a laying procedure which the administrative law authors like Wade, Jolovich, Jain and Jain, Sate, IP
Yeah,
Massey.
laying
What
and-
they say is
laying-
legislative control of administrative action. That's how it has been discussed.
ಲೇಯಿಂಗ್ ಅಂತಿಲ್ಲ ಇದರಲ್ಲಿ.
ಯಾವ್ದ್ರಲ್ಲಿ? ಅಲ್ಲಿದೆ 371 1A
ಹೌದು.
laying ಇದೆ.
Report-
Placed each year before the state
laying
legislative
ಇಲ್ಲ.
assembly
Lay-
is interpreted as a laying.
No, laying, my lord, the rules will prescribe. When a rules are made, it should be laid before the house, before it is given effect to. My lord, here, my lord, it is placing the report.
ಎರಡನ್ನು equate ಮಾಡಿದ್ದಾರೆ. There are
My lord,
judgments.
ultimately, my lord, what I am trying to say, my lord, is ultimately, my lord, the state legislature will also have a say, my lord, in the matter. It's not only the elected representative of Hyderabad, Karnataka area only matters.
Whole legislature will be looking.
Yes. They may modify.
29 ಏನ್ ಹೇಳ್ತದೆ? 29 is differently worded.
ಅದು budget.
Board has to place the rule. Not the chairman and the secretary might have to.
Twenty-nine relates to the budget of the board, my lord.
29 relates to budget of the,
Board.
no, 28.
28 report, the board shall before such date, in such form, or in such interval as may be prescribed, submit the prescribed report to the state legislature.
State legislature.
ಹೌದು.
This and this is replica of 371 1A.
Yeah. It is in compliance of 371A. My lord, these rules, my lord, this order is made.
Amplificatory rules
Yes.
are made.
Yes.
So, but
The
budget-
governor, my lord, governor has the assistance of the board. The governor has the assistance of advice that is given by the advisory council. And ultimately, a report is prepared with regard to the manner in which the board has to function, including, my lord, making an appointment also.
ಈಗ ಈ ಆರ್ಡರ್ಸ್ ಅನ್ನು ಇಶ್ಯೂ ಮಾಡುವಾಗ
ಹಾ.
ಬೋರ್ಡ್ ರೋಲ್ ಏನಿತ್ತು
ಅವಾಗ ಇದು ಬಂದೇ ಇರಲ್ಲ, ಹುಟ್ಟಿದ್ದೇ ಇದರಲ್ಲಿಂದಾನೆ.
ಈಗ
This is how, my lord, it is a
not this, the impugned orders.
ಅದ್ರಾಗ ಏನಿಲ್ಲ.
ಇದು
There is no way reference, my lord. My lord, those circulars are outside 371J and, my lord, without reference to, my lord, the board order.
What you want to tell us is,
Yes.
it is not that, there are 2-3 things which you want to undercurrents ಇದೆ ನಿಮ್ಮ submission ನಲ್ಲಿ. ಒಂದು, governor does not act on the aid and advice of the minister.
ಅವ್ರು ಹೇಳಿದ್ದಕ್ಕೆ ನಾನು ರಿಪ್ಲೈ.
ಗೊತ್ತಾಯ್ತು ನಂಗೆ. ಅಲ್ಲ, we want to understand
Yes,
what
yes.
you said ಅನ್ನೋದನ್ನ
Yes.
ಸೂತ್ರ ರೂಪದಲ್ಲಿ ತಿಳ್ಕೊಳ್ಳೋ ಪ್ರಯತ್ನ ನಮ್ಮದು
Yes.
ಅಷ್ಟೇ. ಒಂದು, the idea of aid and advice of the government of the day ಇದೆಲ್ಲ ಬರಲ್ಲ ಅಲ್ಲಿ. ಇದು ಸಪರೇಟ್ ಪ್ರಾವಿಷನ್, ಇಂಡಿಪೆಂಡೆಂಟ್ ಆಗಿ ಮಾಡಬೇಕು ಅನ್ನೋದು ಒಂದು.
Yes.
ಗವರ್ನರ್ ಅವ್ರ ಡಿಸಿಷನ್ ತಗೊಳ್ಳೋದಿದ್ರು ಸಹಿತ ಅವ್ರೊಬ್ಬರೇ ತಗೊಳ್ಳಲ್ಲ. ಅಲ್ಲೊಂದು ಇಂಟರ್ನಲ್ ಮೆಕ್ಯಾನಿಸಮ್ ಇದೆ.
ಹೌದು.
ಅಲ್ಲಿ ಇನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಡಿಸಿಷನ್ ಇದ್ದಂಗೆ ಇದೆ. ಆಲ್ದೋ ಹಿ ಮೇ ನಾಟ್ ಬಿ ಬೌಂಡ್ ಬೈ ಇಟ್.
Yes.
ಹಾಗಾಗಿ ಪಾರ್ಟಿಸಿಪೇಟರಿ ಡಿಸಿಷನ್ ಇದೆ ಇದರಲ್ಲಿ.
ಹೌದು. That is in compliance of 371J only.
ಆ ಸ್ಕೀಮ್ ಹಂಗಿದೆ.
It is not independently done by the governor. It is in compliance of 371J.
Not part 6
Yes.
at all.
Yes.
It is independent. ಇದರಲ್ಲೇ ಹಿಂಗಿದೆ,
ಹೌದು,
inbuilt
ಹೌದು,
ಇದೆ ಅಂತ.
ಹೌದು, ಹೌದು.
Understood.
Yes.
But you also admit board had no role to play in framing the orders that were put forth before the KAT.
ಹೌದು,
ಅಂತ ಅನ್ಕೊಂಡು.
ಹೌದು, ಹೌದು. Now, my another limb of argument, my lord, in this only. 371J will not deal with the post, my lord, outside the region, Karnataka, Hyderabad, Karnataka region. They have no business at all.
Because 2 says that.
ಹೌದು. Because it says, my lord, the post of the
Is
Hyderabad.
the reason.
Yes. Now, what we are now concerned is whether you can create an embargo upon the domicile or residents of Hyderabad, Karnataka from applying independently without reference to 371J and compete in the merit in respect of the posts which are available in
In
the
the reason.
residuary, that is called, my lord, residuary. This is reserved and this is residuary.
ಅಲ್ಲ ಪೋಸ್ಟ್ಸ್ ಆ ರೀಸನ್ದಲ್ಲೇ ಇರೋದೆ. Kindly come to 371J.
ಹೌದು
2B.
ಹೌದು
Identification of posts or classes of posts under the state government and in any body or organization under the control of the state government in the Hyderabad, Karnataka region.
ಅಲ್ಲಿಗೆ ಅಷ್ಟೇ. Now what is happening is, if you are making a choice, you are not allowed here. There is nothing like that, my lord, in 371J.
ಆ ಎಂಬಾರ್ಗೋ ಕ್ರಿಯೇಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
ಬರೋದೇ ಇಲ್ಲ.
That is
My
not within
existing, my existing rights cannot be dealt with, my lord, by the state. My right is there, my lord, for every post in the state. If I am eligible, if I am qualified,
I'm entitled.
I am entitled to apply. By virtue of those 6 and 15, my lord, 6 notification, I was prevented.
That anomaly is set right.
Yes.
ಹಾ ಊಟ ಮಾಡ್ಕೊಂಬರೋಣ.
ಆಯ್ತು.
ನೀವೇನೋದು ಆ ಎಂಬಾರ್ಗೋ ಡಸ್ ನಾಟ್ ಫಿಟ್ ಇನ್ ಟು 371J ಪ್ಯಾರಾಮೀಟರ್ಸ್ ಎಟ್ ಆಲ್
No.
ಅನ್ನೋದು ನಿಮ್ ಕಂಟೆನ್ಷನ್.
Nowhere, my lord. ಅವ್ರು ಹೇಳೋದೇನಂದ್ರೆ, ನಿಮ್ಗೊಂದು ಕೋಟ ಮಾಡ್ಬಿಟ್ಟದೆ, ನೀವು ಅಲ್ಲೇ ಹೋಗ್ರಿ, ಈ ಕಡೆ ಬರ್ಬೇಡ್ರಿ.
ಅದು ಕೋಟ ಆಗೋದೇ ಇಲ್ಲ ಅನ್ನೋದು
ಹಾ.
ರವೀಂದ್ರ ಭಟ್ ಜಜ್ಮೆಂಟ್ ಇಟ್ಟು.
ಹೌದು.
ಕೋಟನೇ ಆಗಲ್ಲ. ಕೋಟ ಇದಷ್ಟೇ ಆಗುತ್ತೆ. ಅದು ಜನರಲ್ ಮಾರ್ಕೆಟ್ ಆಗಿದೆ. ಅದು ಒಂದ್ಸರಿ ಜನರಲ್ ಇತ್ತು ಅಂತ. ಐ ಆಮ್ ಎಂಟೈಟಲ್ಡ್ ಟು ಅಪ್ಲೈ ಫಾರ್. ಇಟ್ ಈಸ್ ನಾಟ್ ನೆಸೆಸರಿಲಿ ರಿಲೇಟೇಬಲ್ ಟು ಇಂದ್ರ ಸಹಾನಿ ಅಂತಾನು ಹೇಳೋದು ಇವರು. Even independent Indra Sahani, this happens. Even independent of Indra Sahani, that happens ಅಂತ ನೀವು ಹೇಳೋದು. ಮಧ್ಯಾಹ್ನ ಒಂದು ಸ್ವಲ್ಪ ಲೇಟ್ ಆಗೋದು. ಇವ್ರದ್ದೊಂದು ಬೆಂಚ್ ಇದೆ.
Please.
ವೆರಿ ಮುಕ್ಕೊಂಡು ವಿಲ್ ಸೆಂಡ್ ವರ್ಡ್ಸ್.
My lords, that serial number 1, that's chit which we had just passed on to your lordships. May I just pass it on again, my lords?
ರೀಡ್ರಾಫ್ಟೆಡ್ ಮತ್ತೆ ಅದೇನೋ
ಇಲ್ಲ ಇಲ್ಲ ಅಷ್ಟೇ ಅಮೌಂಟ್.
ಬಿಡಿ.
ಎರಡು ಕಾಪಿ ಇದೆಯಾ ಸರ್? ಇದು ಸಬ್ಮಿಟ್ ಸರ್. 2 sets. Yes.
Otherwise they will have to share it.
There are 29 employees ಅಷ್ಟೇ.
ಅಲ್ಲ, ಇನ್ನೊಂದು 114 ಜನದ್ದು it is already part of the record, my lords. This also was submitted as part of the memo that we during our-
ನೀವು ಹೋಗ್ಲಿ. Need not wait, Mr. Rajgopal. Lakshmi Narayana, need not wait.
These are 29 employees, staff members, my lords, who were not a part of the employees union, like Mr. Rakesh Bhatt's clients. For instance, those are 29 in number, staff members, office staff ಇವರೆಲ್ಲ.
ಇದರಲ್ಲಿ ಯಾರ್ಯಾರು ಇನ್ಕ್ಲೂಡ್ ಆಗ್ತಾರೆ?
At least, I think all of them have already been, there's an overlap, which is why that offer which now is being made, is in addition to what that amount that OTS is already paid to them. OTS and.
ಅಲ್ಲ, ನಂಬರ್ ಆಫ್ ಎಂಪ್ಲಾಯೀಸ್ ಇದ್ರಲ್ಲಿ 29 enlist ಮಾಡಿರಿ ನೀವು.
114, my lords, as part of the statement of objections.
ಒಂದು at least ಒಂದು ಮೆಮೊ ಟೈಪ್ ಮಾಡಿ ಹಾಕಿ. ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ, ಮೆಮೊ ಮಾಡಿ ಹಾಕಿ.
ಇದೇ ಮೆಮೊನ ನಾವು
ನಾವೇ ಟ್ರೀಟ್ ಮಾಡ್ಕೋಬಹುದು ಅಂತ.
I will just I will just submit this memo to them.
114 plus 29.
114 plus 20.
114 plus 29.
114 plus 29. Employees union 114.
ಅವ್ರು ಹೇಳೋದು 150, 151, 152 ಹೇಳಿದ್ರು ಅವರು. ನೀವ್ ಹೇಳೋದು ಅದು 114 ಪ್ಲಸ್
Being staff.
ಒಂದು 10 ಜನ ಕಡಿಮೆ ಆಗ್ತಾರೆ ಅದರಲ್ಲಿ. ಅದು ಅಲ್ಲಿ ಅಮೌಂಟ್ ಎಷ್ಟು ಅದು?
ಇದ್ರಲ್ಲಿ ಬಂದಿರೋದು amount total is only for this.
ಅವ್ರನ್ನೂ ಸೇರ್ಕೊಂಡು
It includes 114 plus 29, because already we have paid them, my lords, in 94.
ಅಲ್ಲಿ ಕೈಯಿಂದ ಬರ್ದು ಕೊಡಿ, ಮತ್ತೆ ಕನ್ಫ್ಯೂಸನ್.
This is the total.
ಇದ್ರದ್ದು total.
We will just pass on, my lords.
ಮಾಡ್ಕೊಂಡು ಮಾಡಿ.
And we will serve it on them as the opposites. Because this was given only to my lords on the last occasion.
ಅದನ್ನ ನಮಗೆ ಕೊಡಿ ಸಾಕು.
Please,
ನೋಡೋಣ, ನಮ್ಗೆ ಅದು ಸೀಲ್ಡ್ ಕವರ್ನೇ ಕೊಡಿ.
seal cover, I will just.
114
ಪ್ಲಸ್ 29.
addition.
If possible, little improvement also is welcome. We do not know what we are going to say, but ನಮ್ಮ ಮೈಂಡ್ ಅನ್ನು ಇಂಪ್ರೆಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ನೀವೇನೆಲ್ಲ ಮಾಡ್ಬೇಕು ಅದನ್ನೆಲ್ಲ ನೀವೇ ಮಾಡ್ಕೋ, ನಿಮ್ಮ ವಿಜಡಮ್. ಹೌದು.
ಅಲ್ಲೇ ಫೈಲಿಂದ ಹಾಕಿಲ್ಲ, ಫೈಲ್ ಅಲ್ಲೇ ಇರುತ್ತಲ್ಲ. ಇದೆಯಾ ಆಮೇಲೆ ಊಟ ಮಾಡಿ ಹೋಗ್ತಾರೆ. ಅದಾದ್ಮೇಲೆ ಅಲ್ಲಿರುತ್ತಲ್ಲ ಇಲ್ವಂತ ಇರ್ಬೇಕು. ವಿಚಾರ ಮುಂದೆ ಇಟ್ಟು ನಿಮ್ಗೆ ಗಮನದಲ್ಲಿ ಎಲ್ಲ
Region.
Karnataka region. It's one small exception. May I request you to kindly see paragraph 30,
15.
page 17.
I think on that there is a judgment of brother Judge Devdas, which went to apex court also.
Division bench also confirmed. It is only the validity of this 13 was called in question. It has been upheld.
That's all. Nothing beyond that.
But I would be wrong if I have not stated, my lord.
No, no, you are still making submission, na? In the course of submission.
Outside the territorial jurisdiction, there are some posts identified in terms of rule 13, paragraph 30.
Page
17.
17.
This is contrary to your.
When I say, my lord, article 371, they ನೋಡಿದ್ರೆ
ಆ impression ಬರ್ತದೆ.
ಆ impression ಬರುತ್ತೆ. But there is
Some interpretation.
what should happen to an institution or a body which is central. Even there has to be some vacancy for
Those
HKE.
people.
They have given the office's name also, your lordship will kindly say secretariat.
Official designation ಎಲ್ಲ ತಗೊಂಡ್ಬಿಟ್ರೆ they will travel outside region only.
ಹೌದು. ಅದಕ್ಕೆ
But text ಅಲ್ಲಿ ನೋಡಿದ್ರೆ ಆ impression ಬರಲ್ಲ.
ಹೌದು ಬರಲ್ಲ.
Within the reason, in the reason ಅಂತ ಇದೆ.
ಹೌದು ಹೌದು. Because they are central institutions. Even there they have carved out some reservation for.
Outside also.
Yes.
Especially one glaring ಅಂತಂದ್ರೆ KPS.
ಹೌದು.
KPS doesn't have any of its offices in that region.
ಎಲ್ಲಾನು all these institutions malord ಅಷ್ಟು
All there outside only. 13 ನಲ್ಲಿ ಇರೋದು BDA, BBMP.
even high
All
court
outside.
high court also D.
High court also.
No, that's all my lord I would like to say my lord as far as classification of the post is concerned.
But ಆ text ನೋಡಿದ್ರೆ ಹಂಗ್ ಬರಲ್ಲ.
ಹಂಗ್ ಬರಲ್ಲ.
Text
ಅದಕ್ಕೆ ವ್ಯಾಲಿಡಿಟಿ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ.
ಮಾಡ್ತಾರೆ.
Then this court my lord upheld the validity of this paragraph 30.
ಆ judgment ಇದೆ.
ಇದೆ ಇದೆ. DB ಇದೆ.
Justice Devdas judgment.
ಎರಡು
member.
ಎಲ್ಲ
Then DB ಗೆ ಹೋಗಿ ನಂತರ then went to Supreme Court and Supreme Court not went to Supreme.
ನನಗೆ
Is it?
lord I am not able to lay my hand my lord on Supreme Court.
It was here only.
ಅದು ಒಂದೇ ಇದೆ ಇನ್ನೊಂದು.
Last sentence is not necessary because obviously you will be appearing. Either this way or that way. That's one. Otherwise it will be retrogressive ಆಗ್ತದೆ. ಆ ರೀತಿ textual, but what Chandrasekhar said, it appeared that way even to us after reading the text of that provision. Courts in the reason ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ ಹಂಗೆ ವರ್ಡ್ಸೇ ಹಂಗಿದೆ ಆಕ್ಚುಲಿ. ಹಂಗಾಗಿ ಅದು in the reason ಅಂತಂದ್ರೆ ಅದನ್ನ ಹೆಂಗೆ they traveled outside, we do not know.
No, they are all central institution my lord. You cannot expect the office my lord
To be there only.
to be there only.
That way. In other words, ports in the region need not be offices in the region.
Yes.
ಆ ರೀತಿ ಮಾಡ್ಕೋಬೇಕು. Which paragraph? Para 12, page 12. In respect of that reason only, which you said is put in block letters. Hmm. 13, 12, 13 ಎಲ್ಲ argument ಅದು. Per contra, Nitin Ramesh argued. 23, 24 heard, 25, import, promote inclusive growth with a view to reduce inter-district and inter-regional disparities in the state. Words in the Hyderabad, para 32. Page 27. Kindly read that. Copy. But all right, we'll see one copy. Just look
Yes.
into your. Copy.
Yes. The words in Hyderabad, Karnataka region as found in.
ನೀವು ಓದ್ತಾ ಇರೋದು ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್?
ದೇವದಾಸ್ ಸರ್ ಸಾಹೇಬ್ ಸರ್ ನಾನು ಕೊಟ್ಟಿರೋ ದೇವದಾಸ್ ಸಾಹೇಬ್
ಸಿಂಗಲ್ ಜಡ್ಜ್.
ಸಿಂಗಲ್ ಜಡ್ಜ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಎರಡು.
ಡಿವ್ ಬೆಂಚ್ all.
My lords may kindly note, my lord,
Yes.
the 2013 order, my lord, is not in question. And there is no question of going into the
All
validity
these
or.
things may not be, but just to ascertain the scope of that.
Yes.
So, so it can be.
It is only for a limited purpose to say that 371J is confined to that post in those reasons. The
And-
government cannot make any rules with regard to the person who is domicile or resident of Hyderabad, Karnataka in respect of the post outside the region. If any restriction is imposed,
At least
that will be violative of Article 14 and 16 of the Constitution.
If outside region posts are also within the sweep of 371J,
Yes.
then
Lord, that is only with regard to Lord, purposive interpretation of LIA. They have said because these posts also, my lord, are in central offices. Therefore, my lord, the governor thought it there must be representation of this region also into those central institutions. Lord, which has been now held to be.
those offices which have been enlisted under Rule 13
Yes.
are notional extension of Hyderabad, Karnataka territory.
Yes.
Even assuming that
To the extent of 8%.
8%.
Yes.
So, in respect of even assuming that, that restriction cannot count at the contention.
And this reservation of 75% and 80%, it's not entire post, my lord, are reserved for the locals. It's only to the extent of 75%, my lord. There is a restriction for the persons who are coming from residuary area, that is other than Hyderabad, Karnataka area. It is not complete ban on or complete restriction, my lord, on those posts. It is only to the extent of 75%. 25%, my lord, they are eligible, my lord. There is eligibility, my lord, for them to compete for 25% posts. It is not total restriction in so far as Hyderabad, Karnataka regions are concerned for others to compete against those posts. Even when it comes to, my lord, the post to be filled up there, even there, my lord, this 25% becomes unreserved.
So it will not be quota at all.
It will not be quota. Everybody can compete, even including, my lord, a person from outside the state also can compete. A person within the Hyderabad, Karnataka area also can compete.
Open market.
It's an open market. Within that 100%, 25% is unreserved. In fact, some of the candidates who are outside the state are also selected in the unreserved category.
If you say it is not a quota,
Yes,
25% is not a quota, let us say.
yes.
75%,
75% is a quota. Reserved quota meant for only locals.
See. Quota, this terminology is reading, telling us in the light of Justice Ravindra Bhatt judgment. Once you call it quota, these questions arise. Don't call it as quota at all. It's a general merit. ಅದ್ನವ್ರು ಕೋಟಾ ಅಂತ ಆ ಪ್ರಿಮೈಸ್ ಮೇಲೆ ಆಪರೇಟ್ ಮಾಡಿದ್ದಕ್ಕೆ ಇಷ್ಟೆಲ್ಲ ಸಮಸ್ಯೆ
ಹೌದು
ಆಗಿದೆ.
ಹೌದು.
okay, in 25%, if, let us say, there are 25 posts under the 25%.
Yes.
So 10% from the Hyderabad, Karnataka area, they compete in 25% and they come up.
10% ಅಂತ ಏನಿಲ್ಲ. There is no percentage fixed.
ಉಳಿದಿದ್ದು
10% percentage.
Well, if they are meritorious, they can come. Even for 25 also, my lord, they can come.
That means it is on par with the same analogy which has been formulated in respect of the quota under Article 14.
15 and 16.
So there is no difference on that.
Yes. Everybody can compete.
But how do you meet the argument of the other side that they are the two cadres?
Yes.
It says that there shall be two cadres.
Yes,
One delivery cadre and one parental cadre.
Yes.
So this cadre it makes.
I am grateful to your lordship, my lord, for that question. There is a protective umbrella for 75% for regional classification. That is, my lord, a regional reservation. There is a constitutional protection as far as the 75% of the post in the Hyderabad, Karnataka region. Even if there is a challenge to that quota, it will not stand because there is a constitutional protection. It can be said, my lord, protective reservation in so far as the 75% is concerned.
That accords with the policy of government president's order itself.
371J.
J itself.
Yes. And one of the other argument advanced, my lord, 50% cap as per the Indra Sahni's case. There cannot be reservation more than 50%. It has to be worked within 50%. My lord, that is not applicable to this case. 75% reservation will violate the 50% quota. Because it is a regional reservation is on the basis of regional. Here in that, in
vertical ಅಲ್ಲ, horizontal ಅಲ್ಲ ಅಂತ.
ಹೌದು. Even in this 75%, there are.
ಆ ಕಾನ್ಸೆಪ್ಟ್ alien ಇದೆ ಅಂತ ಇವರು ಹೇಳೋದು. That very idea is alien to the 371 jurisprudence.
As far as this 75% of the post, it's a reserved, my lord, for HKE. It is not just given, my lord, without looking into social reservation. Social reservation is taken care of within that 75%. The only difference is only locals will come.
That's all.
Yes. Social reservation is
Not excluded.
It is not, my lord, violated. On the other hand, my lord, it is being protected. Even there in that 75%, again, there is the same system is being followed.
Even the 100% reservation ಅನ್ನುವಂಥದ್ದು ಅಥವಾ it will not read beyond 50% ಅನ್ನೋದು ಅದು social reservation ಗೆ ಅಪ್ಲೈ ಆಗ್ತದೆ, ಈ regional reservation ಗೆ ಅಪ್ಲೈ ಆಗಲ್ಲ ಅಂತ ನಿಮ್ ಕಡೆ.
As far as social reservation is concerned, my lord, it has been adhered to when they fill up the 75% regional reservation.
In fact, ಇಂದ್ರ ಸಾಹನಿ, ಎಂ.ಆರ್. ಬಾಲಾಜಿ, ಅಲ್ಲಿ ಇದೆಲ್ಲ ಪ್ರಶ್ನೆ ಬರಲೇ ಇಲ್ಲ.
ಇಲ್ಲ, ಅದು ಪ್ಯೂರ್ಲಿ
ಸೋಷಿಯಲ್ ರಿಸರ್ವೇಶನ್ ಮೇಲೆ ಹೋಗ್ಬಿಡ್ತದೆ.
ಅದನ್ನು ಇದಕ್ಕೆ ತಗೊಂಡ್ಬಂದು ಹಚ್ಚಿದ್ರು. Petitioners are saying it amounts to 50% violation ಅಂತ. Some of the petitioners have also stated. A feeble attempt is made to say that it amounts to more than 50% violative of Indra Sahni's case. ಯಾವ ಲಿಸ್ಟ್ ಇದೆ? ಅಯ್ಯೋ, ನಾನು ಕೇಳಕ್ಕೆ ಹೈದರಾಬಾದ್ ರೆಸ್ಟ್ ಆಫ್ ಕರ್ನಾಟಕ ರೆಸಿಡ್ಯೂವಲ್ ಕೇಳ ಪ್ರಶ್ನೆ ಉತ್ತರ. ಇದು ಲಿಸ್ಟ್ ಏನದ? ಇವೆಲ್ಲ ಸೆಲೆಕ್ಟ್ ಆಗ ರೆಸಿಡ್ಯೂವಲ್ my lord, I am just for my lord, just to demonstrate, my lord, a candidate from Kerala, candidate from Tamil Nadu, candidate from Kerala, Maharashtra have been selected, my lord, in the residuary cadre.
ರಿಮೈನಿಂಗ್ ಇದರಲ್ಲಿ
ಈಗ ಅಲ್ಲಲ್ಲ, ಅದರ್ ದೆನ್ HK ಇದೇನ್ ಪೋಸ್ಟ್ ಇದಾವೆ,
ರೆಸಿಡ್ಯೂರಿ ಕೇಡರ್ ನಲ್ಲಿ
ರೆಸಿಡ್ಯೂರಿ ಕೇರ್ನಲ್ಲಿ ಇವರೆಲ್ಲನೂ ಬಂದಿದ್ದಾರೆ. ದೇ ಹ್ಯಾವ್ ಕಾಂಪಿಟೆಡ್, appeared for the my lord in the recruitment process and they have been selected.
In other words, anybody can be a candidate.
Yes. They only say ಹೈದರಾಬಾದ್ ಅವ್ರು ಬರಬಾರ್ದು, ಜಗತ್ತಿನವ್ರು ಯಾರಾದ್ರೂ ಬರ್ಲಿ, ಹೈದರಾಬಾದ್ ಅವ್ರು ಬರಬಾರ್ದು. ಹೈದರಾಬಾದ್ ಕರ್ನಾಟಕ should not come.
That will defeat the purpose of 371J ಅನ್ನೋದು ನಿಮ್ಗೆ
Yes.
message.
Kindly see, my lord, these are the candidates, my lord, who have been selected, my lord, who are not from the state of Karnataka.
Let alone ಹೈದರಾಬಾದ್ ಕರ್ನಾಟಕ.
ಹೌದು, ನಾವು ಬಂದ್ರೆ ಅಬ್ಜೆಕ್ಷನ್, ಅಲ್ಲಿನೂ ತಗೊಂತೀರಿ, ಇಲ್ಲಿನೂ ತಗೊಂತೀರಿ, 8% ತಗೊಂತೀರಿ, ನಿಮ್ಗೆ ಎಷ್ಟು ಬೇಕು ಅಂತ. ದಿಸ್ ಈಸ್ my lord, is the grievance that they have. Why 25?
Kerala, 320, Kerala.
Yeah, 320. Lord, we have given the index of in the first page. The serial numbers are written there. 320. First one is 325.
ಕೇರಳ, ತಮಿಳುನಾಡು, ಕೇರಳ, ಮಹಾರಾಷ್ಟ್ರ, ಕೇರಳ, ಮಹಾರಾಷ್ಟ್ರ.
This is the selection list, my lord. The grievance is, my lord, of the petitioner. They were once selected in the provisional select list. On account of those, my lord, 6-6 notification and 15-6 notification. Once they withdrew, they made a final selection. The persons whose names were found, my lord, in the provisional list were displaced because those were occupied by people of Hyderabad Karnataka region who are more meritorious than the person who was displaced. They are challenging as if a right has been conferred upon them. The removal of the name from the provisional select list on account of this 2023 notification, they call in question that because this Hyderabad Karnataka region candidates were also considered first in the open category cadre and they are selected. All these petitioners are displaced on account of the merit of the candidates in Hyderabad Karnataka region.
These anomalies are addressed by the impugned order.
How?
Therefore, it is sustainable
It is,
regardless of all.
it
these
is in
variables.
conformity with Article 14, 16 and 21. Because creating an embargo on the candidates of Hyderabad, Karnataka area was violative of 16, 14, 16 and 21 and 371J also. 371J did not put a restriction on seeking selection, my lord, outside the Hyderabad, Karnataka region.
In other words, such restriction is unauthorized,
Yes.
is one limb.
Yeah.
Even otherwise, assuming that it is authorized, it is discriminatory, therefore unsustainable.
Yes. The existing right of
Candidates cannot be killed.
Yes.
It is incompetent because it does not, is not authorized in the text of 371J or orders issued thereunder. And even otherwise, it is violative of these provisions.
Yes.
Okay.
My lord, page 130, my lord, in this book, my lord. Government publication. It starts from 125, my lord. This is a circular, it's
Circular.
styled as circular by the government. They justify, my lord, the state level reservation at 130, my lords. It starts, the subject starts at 130. And it also deal with the seniority, my lord, between the HKE and the state level also, my lord. If my lords were to kindly see, my lord, the rules framed at 177, my lords. Oh, I'm sorry, only 77. These are the rules, my lord, under 2013 order. It's called Hyderabad, Karnataka region, organization of local cadre, allotment, transfer of persons, rules 2013. My lords have, my lord, please.
Yes.
Yes.
These rules are promulgated by?
My lord, I think DPR, my lord.
Government.
Yes. It says, my lord, by the order in the name of the governor of Karnataka.
Every government order says.
My lords will get, my lord, at page 80, my lord.
This is, these rules are relatable to which provision?
Cadre
of the-
management, my lord. Cadre management, my lord, rule that, order 13, my lord. In the preamble only it says, my lord. First paragraph, my lord, in the page 77. It's only, my lord, I am bringing to the notice, my lord, only for a limited purpose. Seniority, my lord, roster point and the seniority has been maintained, my lord, between the residuary cadre and the local cadre. Paragraph 4, chapter 3 and chapter 5, my lord, the seniority at page 78 and 79. Now, may I request your lordship kindly put up, sir, application copy. But I have completed my submission, my lord, with regard to the power of the governor, regulating, my lord, this cadre, local cadre, management of this local cadre, and the seniority between, my lord, the local cadre and, my lord, the residuary cadre.
Yes.
And the question of reservation, my lord, as contended, my lord, by the petitioner, drawing the sustenance or, my lord, saying that placing reliance on Indrasani's case, first merit and thereafter reservation, they have drawn, it is not applicable, my lord. We are not on the question, my lord. The reservation, principles of reservation, my lord, flowing from Article 15 and 16. This is totally different. Therefore, placing reliance on those judgments, my lord, is of no assistance, my lord, to the petitioner, is my respectful submission.
Yes.
1900. Read petition copy. My lord, my next submission would be, my lord, the scope of the application, my lord, before the tribunal. Kindly see the prayer, my lord, at
ಅಲ್ಲ ಅದಕ್ಕಿಂತ ಇನ್ನೊಂದು ಪಾಯಿಂಟು ವೆನ್ ಗೇಮ್ ಈಸ್ ಹಾಫ್ ಎ ಥ್ರೂ
ಅದ್ ಬರ್ತೀನಿ.
ಇದಾದ್ಮೇಲೆ ಬರ್ತೀರಾ?
ಇದರಲ್ಲಿಂದನೇ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. Page 67, your lordship, index page 67 is the memorandum of application, my lord, before the tribunal.
Correct.
Kindly see, my lord, the grounds. Page 69, my lord. There are only two grounds, my lord.
Applicant is qualified for the assistant professor post. Who found a
Due to
PC
the
for
circular issued by the second respondent applicant, the names were not found in the final select list, which is violative of 14 and 16. They were displaced, as I submitted, my lord. They were displaced on account of consideration of the candidature of Hyderabad Karnataka region person on account of the notification dated 1/2/2023. And the next challenge is, my lord, the circular.
Yes.
Just above that, my lord, they have placed reliance, my lord, above grounds. Middle of the selection process is impermissible. Page 69, just above the grounds, relief. That the alteration or change of the game in the middle of the selection process is not permissible.
Yes.
My lord, apart from this, my lord, there were no other grounds, my lord, urged by the petitioner. One is the removal of their name from the provisional list, and this circular dated 1/2/2023 will result in change in the rules of the game once the process has commenced.
Yes.
Now, my lord, kindly see the writ petition now. The contention, my lord, of the applicants before the tribunal on these both the grounds, my lord, were not accepted. On the ground, my lord, Article 16 restriction, my lord, the notification dated 1/2/2023, my lord, is held to be valid.
Yes.
Now, kindly see, my lord, the entire scope of the writ petition has now enlarged. Page 21. These were the submissions, my lord, made by Mr. Vatsudan Naik. He appeared in this matter.
Yes. Just we got.
Yes. My lord, the scope of the claim has enlarged. My lord, I'm not saying they are not entitled to, my lord. Since my lords are considering, my lord, the larger question. Therefore, I reply to all this, my lord, contending that, my lord, the validity of 371J is not called in question.
No orders.
2013 order, my lord, is also not called in question.
Only circulars are put in charge.
Yes. Now kindly see the prayer, my lord, at page 70, my lord. They have not even challenged, my lord, the final selection list. Page 70, my lord. Index page 70. Set aside the circular published
By second
second respondent number so and so.
Same or arbitrary,
Yes.
illegal, etc. Whether the lists which you say that they are to have challenged, whether lists are prepared on the basis of these circulars? Yes.
1 to 23 only, my lord.
So if they go, everything ex nihilo nihil fit.
Yes. But the selection list, my lord, is not called in question, is only my subject. Nevertheless, my lord, one has to my lord, it may be a consequence of, my lord, the
the
notification
circular.
dated 1/2/2023.
Apex Court has employed the maximum ex nihilo nihil fit, at least in 1, 3, 4 judgments, as I remember. Out of nothing, nothing comes out.
I'm only
If this is
placing,
nothing.
Lord,
then what's that?
I'm only saying, my lord, there is some defect, my lord, in their approach. They should have, my lord, called in question the selection list also. Because there are so many persons, my lord, who will ultimately going to be affected, my lord, by, my lord, redoing the whole thing, my lord, in the event, my lord, they succeed in the matter. It is only for that limited purpose. Now, the question that remains, my lord, the validity of, to be answered by me, my lord, the validity of 1/2/2023 and
15/6/22.
yes. And my lord, the change in the rules of the game. My lord, the courts have held, my lord, consistently. There must be change in the qualification, eligibility. If there is a change in the qualification,
It violates.
eligibility, then it amounts to change in the rules of the game. Here, there is no change in the qualification. Merit list remains the same. What I have secured in the examination or, my lord, in the merit list, my lord, has not changed. What is changed is, my lord, the process of making a select list. That will not amount to change in the rules of the game. First, you prepare a select list of residuary cadre, and thereafter you make the selection of the reserved cadre. A person who is from Hyderabad, Karnataka area, if he is selected in the residuary cadre, because you have adopted a method in terms of 1/2/2023, the procedure is to fill up the residuary cadre first and thereafter the reserved category. There is no change in the qualification. There is no change in the eligibility. What has been done is the disqualification, that is preventing a person who is having a fundamental right to consider his merit. That embargo has been lifted and brought it in conformity with Article 16 and 14.
Not a change in.
It is not a change in the rules of the game. They want to take the advantage of a disability of a person. They were selected because they were less meritorious. The merited candidate was made to sit outside the purview of the selection. Now, by contending so, they want to say, select a person who is less meritorious, even though the persons who are now selected on merit, they should be removed from the select list. A person who is less meritorious must be selected.
Which judgment of the apex court
My lord, constitution judgment,
explains
my lord,
what is meant by changing the rules of game?
my lord,
We have proposition, we have understood.
my lord,
Rules of the game cannot be changed when the game is played halfway through.
yes,
That's understood.
yes.
Everybody understand. What is meant by that?
The first judgment, my lord, in my compilation, my lord, is Tej Prakash. It's a constitution bench judgment, my lord. During the pendency of this matter, my lord, the judgment has been rendered. Yes. Conclusion, my lord, my lords will get it at the judgment is pronounced, my lord, on 7th of November, 2024. My lords will get at page.
Yes. Where the concept is explained.
Yes. My lord, Manjushri case, your lordship will kindly see para 3 of the conclusion. They hold, my lord, Manjushri case lays down good law.
Page.
Paragraph 3, my lord, at page 43, my lord.
Yeah. Where is that idea?
Para 20, my lord. Para 20, my lord. At page 24.
Discernible ratio.
Yes. or the extract, my lord, we'll find at the previous page, my lord, the Manjushri. Manjushri is held to be a good law. And the tribunal, my lord, has taken into consideration, my lord, the Manjushri judgment. Para 12 in the analysis of the judgment, my lord. At page 15, my lords.
Kindly read para 20. Or above that one, extract para 33. 27, that para 20 you are coming to at
Yes.
page 24.
Yes.
That culled out paragraph 27 above at the top. Therefore, it begins like that. Page 24. Above paragraph 20.
1 minute, I'm sorry. The desirable ratio of K. Manjushe is that.
ಅದಕ್ಕಿಂತ ಅದು preluding ಇದೆಯಲ್ಲ.
Oh,
What preludes that paragraph?
yes,
There are two more paragraphs, 27, 33.
yes.
Para 20 above.
Therefore, the introduction of recruitment, minimum marks for the interview. After the entire selection process consisting of a written examination and the interview was completed, would amount to changing the rules of the game after the game was played, which is clearly impermissible. We may clarify that the perception of minimum marks for the interview.
Prescription of minimum
marks for any interview is not illegal. We have no doubt that the authority making the rules regulating the selection can prescribe by rules the minimum marks both for written examination and the interview, or prescribe a minimum marks for written examination but not for the interview, or may not prescribe any minimum marks for either written examination or interview. Where the rules do not prescribe any procedure, the selection committee may also prescribe the minimum marks as stated above. But if the selection committee wants to prescribe a minimum marks for the interview, it should do so before the commencement of the selection process. If the selection committee prescribes the minimum marks only for the written examination before the commencement of the selection process, it cannot be either during the selection process or after the selection process. Add an additional requirement that the candidate should secure the minimum marks in the interview. What we have found to be illegal is changing the criteria after completion of the selection process when the entire selection process on the basis that there will not be any minimum marks for the interview.
Then kindly come to page 20.
The desirable ratio in Manjushri is that the criteria for selection is not to be changed after the completion of the selection process. Though in the absence of the rules, to the contrary, the selection committee may fix minimum marks either for the written examination or for the interview for the purpose of selection. But if such minimum marks are fixed, it must be done before the commencement of the selection process. This view has been followed by other three judges bench of this court in Ramesh Kumar, so and so, wherein the law on the issue has been summarized thus. In case of a statutory rules prescribed a particular mode of selection, it has to be given strict adherence to accordingly. In case of no procedure is prescribed by the rules and there is no other impediment in law, the competent authority, while laying down the norms for selection, may prescribe for the test and further specify the minimum benchmark for the written test as well as for vivaos.
But everything should be done before
Yes.
selection process
Here,
begins.
nothing has been changed. the merit list remains the same. Person who has secured the marks has remained the same. And here there is no interview. Only on the basis of the marks secured, the selection list is prepared.
But all this has been occasioned because of these two circulars.
Yes,
We agree that.
yes.
But for these circulars, it would not have happened.
My lord, I was prevented. My lord, I in the sense, my lord, a candidate from Hyderabad, Karnataka were prevented because they have shown the option of being considered, my lord, in the Hyderabad, Karnataka region, a reserved quota under 371J.
At what stage these circulars are issued?
My lord, after the examination, this 1/2/2003, my lord, is issued, my lord, when the objection was raised with regard to disqualifying them from consideration of their merit in the selection process.
When select list was provisionally published,
My lord,
dated,
ಇದರಲ್ಲೇ ಇದೆ. In this application, my lords will find.
just give the skeletal detail.
Yes,
When the applications were called, 3 dates, when the applications were called, when they wrote the examination, when they were called for interview, when the provisional list is. These 4.
may I request your lordship kindly see, my lord, list of dates, my lord, at page 5.
Page 5.
Page 4 and 5, my lord. The second date, your lordship will. (30/9/2021), my lord.
The recruitment process began with
Yes.
calling of applications.
Yes.
That notification is dated
30/9/2021, my lord.
written examinations
On between 12 March 2022 to 16/3/2022. Your lordship will get at page 5, my lord.
interview,
Interview illa.
ಇಲ್ಲ,
No interview.
no interview.
Yes.
Then provision,
After this 16/3, my lord,
huh,
the notification dated 15/6 comes. That is the first change made.
provisional select list ಯಾವಾಗ ಅದು publish ಆಗಿದೆ?
On 31/2023.
30 January
ಹೌದು. 30
1.
January 23.
So the first circular is issued after this.
No, before that.
No,
Because that last paragraph in 15(1) was not withdrawn.
that was retained as it is.
That was retained. For the existing recruitment, this 1/2/2023 will not apply. 15(3) dalli ಬರೀತಾರೆ. Your lordship may recall, my lord, kindly see the notification, my lord. ಇದೇ book ಅಲ್ಲೇ ಇದೆ ಬೇಕಾದ್ರೆ annexure A. Page 71. Page 76, my lord.
How? 15/6/22.
ಹೌದು.
Its last paragraph says what?
Existing recruitment ಬರಲ್ಲ ಇದು ಅಂತ ಹೇಳ್ತಾರೆ.
So not applicable at all.
Not applicable at all.
Therefore, they
This
could not
last
have
paragraph-
grieved against this at all.
Yes.
All right. The then 1/2/2023.
Next page.
That is there. Then that will boils down to that one only.
Yes. The last paragraph saying it is applicable to future existing recruitment ಗೆ ಇಲ್ಲ ಅಂದಿದ್ದನ್ನ paragraph ತೆಗೆದುಬಿಡ್ತಾರೆ. Therefore, the gist of 15.4, except last paragraph, will come into operation. Page 24. ಅದರಲ್ಲಿ next last line. Page 79 ನಲ್ಲಿ.
ವಿವಿಧ
ಅಲ್ಲ,
ದಿನಾಂಕ 15/6.
ಸುತ್ತೋಲೆ ಕೊನೆಯ ಖಂಡಿಕೆಯನ್ನು ಮಾತ್ರ ಹಿಂಪಡೆಯಲಾಗಿದ್ದು
ಇನ್ನುಳಿದ ಎಲ್ಲ ಅಂಶಗಳು ಯಥಾವತ್ತವಾಗಿ ಇರುತ್ತೆ.
Yes.
ಕೊನೆಯದೇನಿದೆ?
ಕೊನೆಯದು ಅದೇ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್.
So that makes the circular with retrospective effect.
ಅನ್ಬೋದು.
Effect ಹಂಗಾಗ್ಬೋದು.
Yes.
That will not make, that per se will not make it invalid ಅಂತ ನಿಮ್ contention.
ಹೌದು. Because it has not changed the rules of the game.
Rules
Qualification has not changed.
rules
Criteria has not changed.
effect is changed ಅಂತನ. The substratum is retained as it is,
Yes.
but effect is changed.
Yes.
That is
Instead-
not a
instead-
change of rule of
How?
game ಅಂತ ನಿಮ್
Instead of saying this 15/6/2022 is applicable, it was not made applicable when the selection list was drawn. Even though 15/6 was, well, your lordship will kindly see the dates.
15/6/22.
It was there, but it was not made applicable to the existing recruitment. How?
And by what, 2/23?
After the,
It is made applicable by deleting that last paragraph.
Yes.
That does not amount to changing the game, rules of the game ಅಂತ ನಿಮ್ contention.
Because qualification remains the same, merit remains the same. No
Process
question
is-
of interview. By this process, a person who was made not to compete in the residuary cadre is made to compete. That change is in conformity with Article 14 and 16. Now kindly see, my lord, this judgment, my lord, last second paragraph. Conclusion, second paragraph.
Page.
Page 43, my lords. Last three lines, my lord, in para 2. Even if such change is permissible under the exact rules or advertisement, the change would have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitrariness.
No, this change they are speaking of, the change before the game began. Even for that, this should be the requirement.
How?
They do not say the change which is brought about when the process was halfway through. That change they are not speaking of at all.
Yes.
They are saying, even if you bring the change before the game began, that change has to be consistent with Article 14 and should meet the test against non-arbitrariness. So it appears things will boil down to what is meant by changing the rules of game ಅನ್ನೋದಕ್ಕೆ ಹೋಗಿ ನಿಂತ್ಕೊಂಡ್ಬಿಡ್ತದೆ.
ಹೌದು. ಅದಕ್ಕೆ ಮಂಜುಶ್ರೀ ಕೇಸಲ್ಲಿ ಹೇಳ್ತಾರಲ್ಲ, ಕ್ವಾಲಿಫಿಕೇಶನ್ ಚೇಂಜ್ ಆಗಬಾರ್ದು, ಎಲಿಜಿಬಿಲಿಟಿ ಚೇಂಜ್ ಆಗಬಾರ್ದು.
You mean to say that something which was in the control of the candidate, which you could have improved, had that rule been notified earlier.
ಇಲ್ಲ ಅದು ಆಗಲ್ಲ. ಅವ್ರು ಹೇಳೋದೇನು ಎಲ್ಲದನ್ನು ಆಸ್ ಇಟ್ ಇಸ್ ಇಟ್ಕೊಂಡಿವಿ ನಾವು.
My lords have given the new dimension. If it was within his control, if the candidates had within his control,
Then
he would have
only
improved. He should not be put to disadvantage. He has nothing in his hand. There is no question of depriving the eligibility or a criteria. He has already appeared for the examination. He has scored some marks. According to his marks, he will be eligible for the post that his merit requires. Because somebody is losing, I am getting, is not a gaining the qualification. Somebody is made to lose, and he wants to take the benefit of loss caused to somebody. That giving an option was not voluntary, my lord. It was a compulsion on a candidate. Otherwise, my application will not be accepted. Either you say yes or no. If you say yes, this is the consequence. If you say no, this is the consequence.
You had no option at all.
I had no option at all. And it was not permissible to apply for both the case and try my luck in both the recruitments.
They're not permissible.
It was not permissible. Examination is one. Securing the marks is by one standard.
ಅದ್ಯಾವುದು ಅಲ್ಟರ್ ಆಗಿಲ್ಲ.
You know.
And no right flows, no concrete right flows from the provisional list, even otherwise.
Yes, but there are judgments, but even if your name is there in the select, I will not trouble you. Even if the name is there in the select list also, it does not confer any right to approach the court challenging the non-issuing of appointment order.
ಒಂದು ಸ್ವಲ್ಪ ಟ್ವೀಕ್ ಆಗಿದೆ ಲಾಸ್ಟ್ ವೀಕ್ ಆ ಪ್ರಿನ್ಸಿಪಲ್ ಲಿಟಲ್ ಟ್ವೀಕಿಂಗ್ ಆಗಿದೆ. ಲೇಟೆಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಲಾಸ್ಟ್ ವೀಕ್ ಇಟ್ ಕೇಮ್. ಐ ಥಿಂಕ್ ಇಟ್ ಕೇಮ್ ಆನ್ Tuesday. This week Tuesday perhaps. Little, but still basic remains as it is. Only they say for no reason you cannot remove a person. You can't say that will not give you appointment. That you have to give reason why you want to. According to you, this will be the reason anta nim contention.
Person with less merit is been displaced.
ಹಂಗಾಗಿ ಅದು ಗ್ರೀವೆನ್ಸ್ ಅನ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
There cannot be compulsion on an employer to take a person who is less meritorious.
I mean, whether one is more meritorious, less meritorious, ಆ ಯಾರ್ಡ್ ಸ್ಟಿಕ್ ಅನ್ನು ಅಲ್ಟರ್ ಮಾಡಿಲ್ಲ ನಾವು.
No.
ನಿಮ್ ಕಂಟೆಂಟ್.
No. Coming to the question of retrospective and all that, my lord. Your lordship will kindly see, my lord, section 6 of the General Clauses Act. If the intention is otherwise, there is no question of either saying that a right conferred or a right taken away or something is lost will not be benefited, and you should read the rule as if it was there when the selection or whatever is done. If the intention is made clear in this 1/2/2023 notification that a person who is more meritorious, a person who is from Hyderabad, Karnataka area is also entitled for selection, this non-residuary is a open quota where every person is eligible to contest or eligible to participate. The intention of the government is to see that everybody is eligible for competing in the residuary cadre. The question of saying it is not retrospective or prospective, my lord, will not arise. Is one submission. The other argument is retroactive. If a right has been conferred, my lord, in accordance with law constitutionally upon a person, if you give a retrospective effect of it, my lord, is denied of his right, then, my lord, the courts have held the right which has been conferred legally on a person cannot be taken away. This person who is or retrospective ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಅದಕ್ಕೆ.
Retrospectivity can operate even
Repeat.
outside 6 also.
Yes.
6 is confined to statutes and the rules promulgated under the statutes.
My lord, they want to say, my lord, it is retrospective. It's
In
only for
6
that reason, my lord. The question of retrospectivity will not arise in this case. Now, the other question, my lord, with regard to roster point.
Yes.
Separate roster point, my lord, have been fixed both for local cadre and the residuary cadre. The lordships have seen, my lord, those rules made. It takes care of, my lord, the state list, seniority list, and also, my lord, the list of local cadre.
Rule 13.
Yes.
ಅದ್ಯಾವುದು alter ಆಗಿಲ್ಲ.
ಅದು ಏನಾಗಲ್ಲ.
Understood.
My lord, in the case of selection by the UPSC, they may choose some cadre, my lord, a different state. There, my lord, the select list of, my lord, the merit list is maintained. Similarly, my lord, they may maintain, my lord, the state seniority list 1 according to your merit and local cadre, my lord, according to his merit, my lord, of selection. Ultimately, the marks determine, my lord, marks and the roster point determine, my lord, the seniority of a person. That cannot be a ground, my lord, to say that the process of selection is ultra vires. When everything is done, my lord, in accordance with the merit secured by a candidate in a written examination, which is not tilted or altered, my lord, by way of, sometimes it happens, my lord, in the interview, some marks are given more.
Whole selection process as such is kept intact.
Intact. And it is only written examination. Whatever the marks secured, my lord, will determine the merit of a person.
ಹಂಗಾಗಿ legal injuryನೇ ಇಲ್ಲ ಅಂತ
No.
ನೀವು ಹೇಳೋದು. ಇದು ಚಾಲೆಂಜ್ ಮಾಡ್ಲಿಕ್ಕೆ ಲೋಕಸ್ ಇಲ್ಲ.
No right, my lord, will be available to a person to challenge. I must be selected as I was in this provisional select list. Ignore the merit of a candidate who has displaced me.
So according to you, merit is the mantra.
How? That has not changed.
That remains intact and with that premises only everybody has written the examination.
Yes.
To that voice is given by these circulars.
Yes.
Nothing beyond that.
Nothing beyond that. It has only altered the sequence of making a selection. First, you make the residuary cadre and thereafter go to the local cadre, which is a reserved category. The basic principle of merit, reserved and unreserved category is make a selection for the unreserved category and thereafter go to the reserved category.
ಇಲ್ಲ ಅನ್ರಿಸರ್ವ್ ಕ್ಯಾಟಗರಿಯಲ್ಲಿ ಅವ್ರು ಬಂದ್ಬಿಟ್ಟಿದ್ದ ಅಂತಂದ್ರೆ ಅಲ್ಲಿ ತನಕ ಹೋಗೋ ಪ್ರಶ್ನೆನೇ ಬರಲ್ಲ.
ಬರದೇ ಇಲ್ಲ.
Yes.
Lord, there are 2-3 other judgments, my lord. Karnesh Kumar anta ondide.
Saying
Ultimately, my lord, change in the rules of the game ಬಗ್ಗೆ. The Admur judgment is once, my lord, there is a constitution bench judgment, my lord. The
Best
other
things may not.
yes. Consistently, my lord, it is been held, my lord, and upheld by the Supreme Court in the recent judgment also. Merit should not change, qualification should not change in the middle of the selection process. Even cutoff marks for the interview. Sometimes, my lord, only 50% merited candidate will be allowed to appear for the interview. There are so many process of selection. Lord.
Yes.
They call 1:5.
Yes.
Lord, Karneshwarana judgment alle, para 32 in my lords may kindly know. Two, three, my lord. The respondents have also placed reliance on the decision of the court in the case of K. Manjushri. They place reliance on Manjushri.
However, in our considered view, the facts of decision are quite different from present case. Yes.
My lords may kindly mark this, my lord. Rule cannot be brought in, disqualifying him to participate in the selection process.
Correct.
His case was also considered because he did not have the merit, my lord, he was not considered. It is not that his case was not considered at all. Then, my lords are aware of it, my lord. Mischief Hayden's case, my lord. I've just enclosed it, my lord. Paragraph. Raipur Development Authority. Well, British Airways. Lord, at page 235. I'll just read, my lord. Your lordships are familiar with that doctrine.
Raipur was by Justice Krishna here.
British Airways, 1 minute.
No, British Airways is different.
Either 2020.
Anyway, we have Supreme Court accepted head-on's case
Yes.
long ago.
Yes. Idu mark madidda.
Mischief rule.
Yes. Para 8, my lord, at page 240, my lords. British Airways. While interpreting a statute, the court should try to sustain its validity and give such meaning to the provision which advances the object sought to be achieved by the enactment. The court cannot approach the enactment with a view to pick holes and search for the defect of drafting which makes its workable impossible. It is a cardinal principle of construction of a statute that the effort should be made to construe the different provisions so that each provision will have its play. And event of any conflict, a harmonious construction is to that effect should be given in all provisions, and any provision, if so as it makes it workable. A particular provision cannot be picked up and interpreted to defeat the another provision made in that behalf under the statute. It is the duty of the court to make such construction of a statute which shall surpass the mischief and advance the remedy. While interpreting a statute, the courts are required to keep in mind the consequences which are likely to go from the intended interpretation. At page 240, my lord.
It is.
Another Raipur Development Authority, the next judgment. At page 252, my lord. Paragraph 60.
Interpretation which subserves the legislative intent should be preferred.
Yes.
Mischief rule, head-on.
Yes. Whenever there are two possible interpretation, the one which subserves the intent of legislature to be accepted. Not the same principle, my lord, even in Raipur Development Authority case also. My contention with regard to governor's power and, my lord, the interplay of 13 and the Hyderabad Development Board is only to demonstrate, my lord, the governor has taken all care and he has put the mechanism in place, and there is no prejudice caused to any person, my lord, except, my lord, making a proper procedure for the recruitment, direct recruitment and promotion in the matter relating to the vacancies or post in the Hyderabad, Karnataka region.
Who is the author of these circulars?
Author of the circular, your lordship will kindly see, is the governor.
It's the government.
Yes, not the governor. I'm sorry, my lord. Page 15, your
Right, so in the name of and order of the governor, etc. That's one thing. Every government order will be expressed that way only. But who is the author of the governor? This question we had put to the learned AAG to ascertain from the file and come back. What's your answer?
page 22, ಸರ್ಕಾರದ ಅಧೀನ ಕಾರ್ಯದರ್ಶಿ ಸಿಬ್ಬಂದಿ ಮತ್ತು ಆಡಳಿತ ಸುಧಾರಣೆ ಇಲಾಖೆ. DPR.
It is the state government.
It's the government
It is the government.
as distinguished from governor.
Please.
ಸರ್ಕಾರ ಅಧೀನ ಕಾರ್ಯದರ್ಶಿ ಸಿಬ್ಬಂದಿ ಮತ್ತು ಆಡಳಿತ ಸುಧಾರಣಾ ಇಲಾಖೆ ಸೇವಾ ನಿಗಮ 1.
And I will address the source of power, my lords, in my arguments also, because the allocation of business rules have been amended, and my lords, DPR governor has amended the allocation of business rules have been amended, and DPR has been given the specific subject notes for the in respect of 371J. So, my lords, my argument would be that under the constitutional scheme, it is either the governor will act on the aid and advice, or he acts in his discretion. The provision, the way it is worded, my lords, here the way it is worked out, my lords, is on the aid and advice. So, my lords, though in part 6, it is not about the executive power, it is about the states generally. And I will, my lords, demonstrate that. I will be able to convince my lords. Lords, we have secured the original file also relating to 371J, when the 2013 order when it was issued, and also relating to the circulars. I have the files.
In KAT, you had not appeared.
In one of the matter, my lord,
You had appeared.
Lord, in 2 occasions, my lord, I appeared, my lord, in the KAD. One, my lord, the judgment rendered by their lordship Justice Pakta Vasula. Even before, my lord, the recruitment process. And it has been held, my lord, by the KAT, that, my lord, if any person, my lord, is deprived of participating, my lord, in the residuary cadre, it will be violative of Article 15 and 16. That was holding the field. When that was the, my lord, the law of the as on that day, my lord, again, the
Tribunal
same
could
mistake.
not have.
Same mistake. On the last occasion, my lord, I have placed on record the order of the tribunal. The same mistake. And the order of the tribunal, my lord, has been upheld by the division bench, my lord, where Justice Joshi was. Yes.
With my brother and.
Yes.
Wrong.
The same mistake they commit. Restrict, my lord, the participation of HKE.
Yes.
My lords will have to see, my lord, whether it falls within the ambit of 371J. If it is outside
overall,
3,
if it fits into,
yes,
regardless of arguable infirmities, we should not much bother about that.
Yes.
Is your, because
yes,
whether it predominantly it gives effect to the intent of 371J order or not.
yes. And whether there can be an embargo upon the candidates of HKE from participating in the residuary
General
cadre.
residuary.
My lord, this will be the sum and substance of, my lord, the contention.
All.
The government could not have, my lord, created an embargo upon these candidates just because they have a quota. This non-residuary, my lord, is an unreserved quota. It's not a quota at all where everybody can participate, my lord, in this process. Ultimately, it will be boiled down to that. And whether it amounts to change the rules of the game once it is commenced. Merit is not affected at all. That's all, my lord.
Thank you so much.
Yes.
Yes.
That's there is insofar as, my lords, the constitution of the
Can you little upset your structure of argument?
please, my lords,
Learned senior advocate says,
please.
part
6.
6 is alien to 371 jurisprudence. 371 is a jurisprudence now, because not only J, 371 A, B, C, D, E, F, G, H, I, J.
Please.
Perhaps thereafter also one more come up. So it is developed as a separate jurisprudence only. Keep this also in your view. Please start.
Lords, I'll just put out, my lords, I know, my lords, I can just, my lords, summarize my submissions so that I'll elaborate on it later on. Lords, I'll just, because we are short of time, because if I start the flow, I'll just put it. Lords, insofar as, I'm just summarizing, my lords, what actually I wanted to say. Lords, under the constitutional scheme, in the way, my lords, the governor functions, either the governor functions with the aid and advice of the Council of Ministers or in his discretion. These are the only two options that are
No
available.
hybrid thing at all.
There is no hybrid thing at all. That is what, my lords, Nabia Ram's judgment says, and I will cite that, which Lakshman sir has cited already. I will rely on certain paragraphs. In fact, that was a case, my lords, where with regard to session, my lords, certain directions were issued by the governor, which without the aid and advice of the Council of Cabinet, Council of Ministers, my lords, Supreme Court said that set aside, my lords, that directions with regard to the legislative functioning is concerned. Now, my lords, insofar as part 6 talks about the states, it is not about the executive power. Executive power is only one of the articles, my lords, that is provided for. And, my lords, part 6 also contains governor, Council of Ministers, the government, etc.
Executive power is not of the governor at all.
No, my lords.
Executive power is of the state
Please, my lords,
or the center.
Here we are not on executive power. I am just saying, lords, the way I'll just put it out that from the file, I've seen the file. A cabinet subcommittee, my lords, after 371J, my lords, the presidential order was issued. The cabinet, my lords, formed a cabinet subcommittee for the purpose, my lords, of working out the provisions of 371J. And, my lords, the cabinet subcommittee, my lords, recommended how it has to be worked out. And, my lords, literally the draft, everything has been approved by the cabinet subcommittee. Then the cabinet approves it. Then it has been sent to the governor. The governor has given his approval. And that is the order, my lords, that my lords have seen. 2013 order. This is how it is actually in the file. 2013 governor's order
is made by the government of the day.
No, my lords, it is made by the governor.
Made by the governor.
Made by the governor.
In his capacity, in aid and advice, athwa.
There I will come. My lords, there are only two concepts. Either it is under aid and advice or it is in discretion. Even if you take it as aid and advice, there is aid and advice on the file. If you take it as discretion, he chose to take the aid and advice, and therefore that is also covered, is my respectful submission. Now, if we are going to use
governor should act on the aid and advice of the government of the day is one principle.
Please, my lords.
That does not prohibit governor from taking the aid and advice is another principle.
Please, my lords.
Either way it is sustainable.
Either way it is sustainable. I'm not, it is the governor's order. It is certainly the governor's order. The fact that, my lords, when governor takes the aid and advice, my lords, it is treated
that
as
does
a
not render it invalid.
That does not render it invalid, because the concepts are only two, twin concepts: aid and advice, discretion. Discretional, when even it is in discretion,
he may take the aid.
He may take the aid and advice. That is my respect.
Like Abdul Kalam Sahab calling P.P. Rao, Sorabji, then taking a decision whether to call particular head person who headed the political party for forming the government.
Please.
That way.
Please. Now, my lords, that is the first limb of the argument. The second limb of the argument, my lords, if you see the 2000, thereafter, my lords, in 2013, when the governor's order was issued, the source of power, my lords, is in terms of, my lords, a clause in the 2014 amendment. A clause has been inserted, my lords, clause 19, in the 2013 order by virtue of the 2014 amendment, which is a source of power empowering the government, my lords, to issue these circulars. That is the second argument, my lords, with regard to the source of power. Third, my lords, limb of the argument is that under, my lords, under the constitutional scheme, the governor, my lords, frames the allocation of business rules and the transaction of business rules for the efficient functioning of the government. Allocation of business rules, my lords, was amended, my lords, to provide for 371J, my lords, to a particular department. And in respect of each of the departments, my lords, there is a separate entry that has been made. That is also, my lords, that rule is made by the governor.
That is made by the government.
That is made by the governor. That's not made by the state government. Because it is under the constitution, the governor makes it.
Allocation of business rules.
Allocation of business rules.
Yeah,
So,
rule 235, ಯಾವ್ದು? Which is that?
my lords, allocation of, I'll just,
Article level.
article.
Allocation of business rules ಮಾಡುವಾಗ governor does it on the advice of the government ಅಲ್ವಾ?
My lords, but the rule is made by the governor.
No, in his individual discretion.
My lords, it would be on the aid and advice.
That's what.
That's all. Please, my lords. No, but still, my lords, what I'm saying is it could be, but at the end of the day, my lords, the governor has, my lords, insofar as the rule making power is concerned, there are two things, my lords. One, the 2014 empowering the state government to issue such circulars, and now it is issued by the DPR. That is the Department of Personal and Administrative Reforms. Under the allocation of business rules, my lords, made by the governor, maybe it could be with the aid and advice, but that power has been conferred, my lords, on that particular department. I'll be able to demonstrate that. This is the, insofar as the constitutional aspect is concerned. Insofar as, my lords, the eligibility thing is concerned, my lords, the way the cadres have been constituted is slight. I'll just clarify, my lords, exactly how it was constituted. My lords, insofar as the Hyderabad Karnataka region was concerned, now the 8 districts, we have the 75%, 80% and 85% for different cadres. That is one cadre. That is the Hyderabad Karnataka cadre and the residual parent cadre in that local region. Apart from that, in the remaining areas, there is no concept of 8%. The 8% is only at the state level institutions. Like, for example, at the state level offices, that is only at the state level offices. And, my lords, the concept of cadre basically means is that it is a separate unit for the purpose, my lords, of service jurisprudence. It is a separate unit. I will take, my lords, to the definition of cadre in various judgments. Now, my lords, what happens is we are doing a common recruitment. It is the Hyderabad Karnataka cadre and the residual parent cadre post. Even let us assume, my lords, there was different cadres. Like, for example, a FDA cadre and a stenographer cadre in different departments. Common recruitment, my lords, is not barred anyway. And a common eligibility criteria, a common selection process is not barred anywhere. So what we are doing is a common selection process. At the end of the day, my lords, in the full bench decision, my lords, in Ved Prakash case, Supreme Court has said that the change of the rules has to be cannot be in terms of you cannot change the eligibility criteria. That is the word actually used. I will read other paragraphs, my lords. Eligibility criteria vishayadalli another change of the. Then with regard to procedure, my lords, courts have said after that stage is over, you cannot change the procedure. Two things, my lords. One is regarding eligibility criteria. Eligibility criteria gets fixed at the time of advertisement. That you cannot change. Second thing is, suppose interview, there was a cutoff marks fixed. After the interview is over, you fix the cutoff mark. That was, my lords, a case in Manjushri. After that stage is over, you cannot change it. You can change it subject to requirements that you meet 14, 16 requirements and it is notified. That is what it says. So this is the other limb of the argument, lords. And there are multiple cases. What has been argued by sir is with regard to assistant professor recruitment. Then, my lords, the other people have argued with regard to school education. Totally, my lords have 5 different recruitments before, my lords. Different dates operate in respect of different cases. I will place all that on record, my lords.
But to all of them, these 2 circulars would apply.
Timeline apply. Timeline applies, my lords. In fact, my lords, I will point out in the different. In fact, in Justice Sanjay Gowda's judgment, he has called out. He has in fact summarized at different points in time, my lords, what was the policy. In the first 2015, we said that you do a common recruitment. Then we did separate recruitment. Then it came back to common recruitment. Then finally, when it was a common recruitment, how merit list has to be done was the only thing. Now, ultimately, my lords, my argument will be what change was made about in the 2023 circular was only change in how you get selected. That is the chances of selection, which is not a rule of the game, is my respected submission. I'll elaborate on all these things.
Thank you. Very illuminating argument.
Pleasure.
In fact, after sir's argument, our work burden is
very illuminating argument.
please.
ಎಲ್ಲಿ ಥ್ರೋಟ್ ಎಲ್ಲಿ ಕೇಳ್ಕಾರ ಒಂದು ಸ್ವಲ್ಪ ಬೇಸರ ಬರಲಿಲ್ಲ.
Let's for the continuation.
ರಿಸರ್ವ್ ಡೆಲಿಟ್ ಮಾಡಿದ್ದೇವೆ ನಾವು ಇನ್ನೊಂದು Very. Which date will be convenient to you to come?
No, any day I'm here only.
Oh, that may not be true. 22nd, I may not.
We may get 2 days, my lord, on 21 and 22. 22, my lord, is working day, I'm told.
22 is working day.
Yes.
But I have some other. It's not 21. We'll not fix the date now.
Please.
We'll have some
Yes.
discussion with
As
Honorable
your lord.
Chief Justice and come back. Then we
As your
can
lord.
decide.
after 22nd, also next Saturday working day.
29.
29 is,
29th working day. ಇಲ್ಲ sir, ಇಲ್ಲ.
unless you make it working day. We all judges come to your house only. Anyway, we'll have and then we'll intimate.
Please,
Yes,
please.
that,
Let's interim orders to extend.
interim order to continue.
Lord,
Thank you, sir.
can I renew my request, my lord? Permit us to appear for,
This ತೊಗೊಳೋದೇ.
Another house.
Huh?
only for counseling, my lord.
ಏನು ಕೌನ್ಸಿಲಿಂಗ್ ಅದೇನು ಕೌನ್ಸಿಲಿಂಗ್ ಅಷ್ಟೇ ಹೋಗ್ತೀವಿ ಅಂತಾರ ಅವರು. ಅಲ್ಲ, ಹೌ ಯು ವಿಲ್ ಬಿ ಅಗ್ರೀವ್ಡ್. ನೀವು ಅಪೋಸ್ ಅಂದ್ರೆ ಹಂಗಲ್ಲ, ಏನು ವೈ ಯು ವಿಲ್ ಬಿ ಅಗ್ರೀವ್ಡ್ ಬೈ ದಟ್ ಟರ್ಮ್. ಹಿ ಸೇಸ್ ಕೌನ್ಸಿಲಿಂಗ್ ಆಗಲಿ ಅಲ್ಟಿಮೇಟ್ಲಿ ಸಬ್ಜೆಕ್ಟ್ ಟು ರಿಸಲ್ಟ್ ಆಫ್
Now,
ಪಿಟಿಷನ್ಸ್ ಅಂತ ಅವ್ರು ಹೇಳೋದು. ಅದರಿಂದ ಯಾರು ಏನ್ ಕಳ್ಕೊಳ್ಳೋದಿಲ್ಲ ಅಂತ. ಹಾ.
Let's do, insofar as counseling, my lords,
in all matters, my lord, there is.
we can hold a,
Except few matters, my lord, there is no only this matter, my lord, we do not have the interim order. In all other cases, my lord, there is an interim order, my lord. Though there is, my lord, a stay of the selection, but they are permitted to, my lord, appear for,
lords.
except
not like-
this case, my lord,
My
where
lord,
I am
what had
appearing.
happened is, KIT, my lords, in the two petitions pertaining to assistant professors and school GPST teachers, my lords, KIT, my lords, has squashed the final select list and asked us to.
Hey, your client is behind you. Ask him to go back. Go back. Your lawyers are here.
Lords, the KCT has squashed the select list and my lords asked us to redo the select list. So in that, there is a conditional interim order that you can, the final select list can be operated except insofar as the post, my lords, from which the early, where the petitioners were displaced. So therefore, my lords, we gave appointment orders to all the other persons. Now the certain posts have been kept vacant from which the petitioners were displaced. We can do the counseling. My lords can say appointment orders can be issued, they can do counseling, but let them not join anta. In case that can.
Appointment ಅಲ್ಲ, counseling ಮಾತ್ರ.
ಅಲ್ಲ,
ಯಾವ
counseling with,
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಇಶ್ಯೂ
ಅಲ್ಲ, without appointment order, counseling is for posting.
ಮಾಡೋದಿದ್ರೆ post appointment order ಆಗುತ್ತೆ ಅದು.
ಹೌದು,
Post
counseling.
appointment counseling.
Appointment order, you hold an appointment order for the purpose of posting, you hold a counseling. So, ಈಗ counseling ಮಾಡಿ on paper ಅಲ್ಲಿ ನಾನು, if I keep it also, my lords, but in the other cases, there is also, my lords, in the other cases where.
ಇಲ್ಲ, appointment ಆದ್ಮೇಲೆ counseling is for posting purpose.
ಹೌದು.
It is for posting purpose.
My lord, at the last, my lord, if I am allowed to participate, my lord, in counseling, I will get, my lord, the leftover posts, which will prejudicially affect me. Even though I have a merit, my lord, I will be counseled, my lord, at an end where, my lord, I will have to go to some village or some other place where, my lord, it will prejudicially affect my right.
No, no, we will address that also when we pass the final law.
Appointment itself. is
ಅದೇ
a
ಇದೆ
dilemma.
challenge.
And now you are saying that.
No, we were-
ಎಲ್ಲರಿಗೂ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ನಾವು ಉಳಿದಿರೋದು ಬೇರೆ ಒಂದು 10-12 ಜನ ಅಷ್ಟೇ.
Let's appointment order ಕೊಟ್ಟು counseling ಮಾಡಿದ್ರೆ we have no objection. And that can be subject, because in the other cases what has happened is the tribunal has allowed the petitions. Here it has dismissed the petitions. In the other petitions where tribunal has allowed, my lords have granted as a blank interim order without any conditional. So in that everybody has been appointed. It is only for these 2 recruitments. So my lords have 4 recruitments where in respect of 2 recruitments, since it's a stay of the tribunal's order asking us to redo the list, everybody has been given appointment orders subject to. But in respect of other things, only where the petitioners have been displaced. So we can actually appoint them. And
No.
Please.
Already we have taken a stand now.
Great.
ಇಷ್ಟು ಮಾಡಿದ್ರು 65 ನೋಡ್ರೆ